Ladies and gentlemen, thank you for coming to the conference. And now we will proceed to the conference, so please take your seat. Once again, now we'll proceed to the conference, so please have the seat. Thank you. Good morning, ladies and gentlemen. Welcome to the 9th International Conference on the Law of the Sea. My name is Kim Ki-hyun, and I'm honored to serve as the host of this esteemed gathering. It is truly a great pleasure to be here with you today. On behalf of the organizers, I extend my sincere gratitude to all of the distinguished panelists and participants for gracing us with your presence at this conference. Today's conference will be facilitated both online and offline, as will be live streamed on YouTube. Before we invite our esteemed guests here up on the stage, we would like to inform you about the translation service available today. Please use the receivers on your table. Channel 1 is English, channel 2 for Korean. And without further ado, let us start the conference under the title, 30 Years of UNCLOS, Then, Now, and the Future. Now, to begin this conference, I am honored to introduce Her Excellency Kang In-sun, Vice Minister of Foreign Affairs of the Republic of Korea, to deliver welcoming remarks. Ladies and gentlemen, please welcome Her Excellency.
His Excellency Thomas Haida, President of the International Tribunal for the Law of the Sea, Professor Kim Min-seo, President of the Korean Society of International Law, distinguished members of the Tribunal, Excellencies, distinguished guests, ladies and gentlemen, it is a great pleasure to welcome you all to the 9th International Conference on the Law of the Sea. We are pleased to host this significant event in collaboration with the International Tribunal for the Law of the Sea and the Korean Society of the International Law. This conference has been an influential forum where experts from home and abroad, including the members of the Tribunal, exchange ideas and insights on the most pressing issues of the law of the sea, promoting a shared understanding of the new developments in the field. This year marks the 30th anniversary of the entry into force of the United Nations Convention on the Law of the Sea. The theme of the conference, which reflects on the past, present, and future of the UNCLOS, seems timely and relevant. As a constitution of the ocean, the Convention has laid the legal foundations for maintaining peace and stability in the ocean. In our discussions today, I hope we can focus on how UNCLOS can continue to serve as a living instrument, enabling the international community to effectively respond to the new emerging challenges. This convention, as stated in its preamble, seeks to establish a legal order which will promote the peaceful use of the seas and oceans, the equitable and efficient utilization of their resources, and protection and preservation of marine environment. The convention set up UNCLOS as one of the most important pillars reinforcing the rule of law framework in the ocean. It also created International Seabed Authority and the Commission on the Limits of the Continental Shelf, for the effective implementation of the relevant rules on the common heritage of mankind. It is widely recognized that UNCLOS has contributed to peace and security, cooperation, and friendly relations among nations in conformity with the purposes and principles of the UN. In this sense, UNCLOS is regarded as possibly the most significant legal instrument of this century. What distinguishes the Convention from other international agreements is its comprehensive scope and universal acceptance. UNCLOS covers a broad spectrum of issues concerning the legal regime of maritime spaces and is widely regarded as reflecting customary international law even by states that are not parties to it. Today, the Convention faces urgent and serious global challenges, along which climate change and marine biodiversity are the most striking. The international community's approach to these complex challenges within the framework of UNCLOS highlights its resilience and enduring relevance. In May 2024, UNCLOS issued its advisory opinion on climate change. This was a landmark ruling in the history of international judicial bodies. While climate change is not directly mentioned in UNCLOS, the Tribunal has affirmed that UNCLOS remains relevant to this new global challenge facing humanity. Notably, this advisory opinion clarifies that greenhouse gas emissions are encompassed in the definition of pollution of the marine environment under Article 1, Paragraph 4 of the Convention. An unprecedented number of states, parties, international organizations, and other stakeholders actively participated in the written and oral proceedings for this advisory opinion. Korea also presented both written and oral statements to engage in this critical discussion on the application of Convention to climate change. Indeed, our government is fully committed to achieving the global goal of carbon neutrality through close cooperation with the international community. As we stressed at the World Leaders Climate Action Summit last week in Baku, the Republic of Korea will continue to support developing countries in our collective response to the climate crisis. Another major issue in the law of the sea is the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. The new BBNJ agreement is the first global multilateral treaty to protect the environment and marine biodiversity in the high seas, covering nearly 2/3 of the ocean's surface. It was the result of extensive negotiations, cooperation, and coordination among the participating nations. Korea signed the agreement in October 2023 as the 83rd state and is currently undergoing domestic procedures for ratification. We anticipate that this agreement will serve as a renewed safeguard for marine biodiversity in the high seas in the coming years. Distinguished guests, as President Yoon Suk-yeol pointed out during his state visit to Singapore last month, tension and conflicts predominantly arise from the maritime domain in the Indo-Pacific region. Indeed, it is the case in many parts of the world. This makes UNCLOS all the more important as a mechanism for conflict management and prevention, supporting the rules-based international order. As one of the greatest beneficiaries of this order, Korea will continue to work with our partners to strengthen the UNCLOS regime and its adaptability to the changing environment in this global multifaceted crisis. We also wish to continue our engagement with UNCLOS to raise awareness of the importance of the law of the sea and to promote knowledge and capacity building on UNCLOS through annual workshops for legal advisors in Hamburg. Distinguished guests, I am certain that insightful presentation and dynamic discussions during this year's conference will further enhance our common understanding on critical issues for the future of the law of the sea. Thank you for your attention.
Thank you very much, Vice Minister, for your enlightening remarks. Thank you. Next, President Kim Min-seo, the President of the Korean Society of International Law, will present opening remarks. Please join me in welcoming President Kim to this stage with a big round of applause.
Your Excellencies, distinguished colleagues and guests, I'm honored to welcome you to the 9th International Conference on the Law of the Sea, organized by the Ministry of Foreign Affairs of the Republic of Korea, the International Tribunal for the Law of the Sea, and the Korean Society of International Law. This year marks the 30th anniversary of the United Nations Convention on the Law of the Sea. After 10 years of negotiations, the convention was adopted in 1982 and came into force in 1994 after being ratified by the 60th country in 1993. We now look back on 30 years since its entry into force. The signing of this convention in 1982 was an important moment in history, following the League of Nations and 3 major international conferences organized by the United Nations. It is meaningful to reflect on its history this year, as the convention has played a key role in shaping the law of the sea over the last 3 decades. At this conference, we will focus on important topics such as territorial seas, exclusive economic zones, continental shelves, marine environmental protection, and dispute resolution under the convention. We will not cover the deep seabed in detail today, as it is better suited for discussion at another time. This conference offers a valuable opportunity to exchange experiences and knowledge from the past 30 years, with presentations and discussions led by leading experts in these areas. The law of the sea is not only a critical part of international law, but it also offers clear examples of how international law works in practice. For instance, the relationship between treaties and customary international law can be seen in the North Sea continental shelf case. When the convention defined the rights of archipelagic states, we finally could be able to predict with certainty which countries would be affected. Unlike municipal law, which applied to large populations, international law deals with a small number of states, around 200 countries. This makes it easier to predict how the laws will work. The small number of countries also makes it harder to separate the process of creating laws from enforcement. Part 11 of the convention, which deals with the deep seabed, was a major reason why many developed countries hesitated to ratify the convention. However, after the 1994 implementation agreement, which made significant changes to Part 11, most of these countries become parties to the Convention. If there had been a separate system for non-member states in the deep seabed area, it could have conflicted with the broader goals of the Convention. It seems that reconciling these two systems helped lead to the 1994 agreement. Finally, speaking of the deep seabed, Article 136 of the Convention stipulates that the deep seabed and its resources are the common heritage of mankind. With over 160 countries now part of the Convention, and after 30 years of implementation, can we now say that the legal status of the deep seabed has become part of customary international law? What about those countries that have consistently opposed Part 11? Are they persistent objectors? Does the persistent objection of certain states prevent it from meeting criteria for a peremptory norm of general international law? Or has it become a peremptory norm of general international law despite opposition from certain states? Thank you for your attention.
Thank you, President Kim, for your meaningful remarks. Now, I'd like to invite His Excellency Thomas Haidar, the President of the International Tribunal for the Law of the Sea, to the stage. He's here with us today to deliver a keynote speech. So, ladies and gentlemen, please join me in welcoming His Excellency Thomas Haidar.
Vice Minister of Foreign Affairs, In-sun Kang, President of the Korean Society of International Law, Min-seo Kim, Director General Jun-sik Hwang, Excellencies, distinguished colleagues, and guests. It is an honor for me to welcome you all to the 9th International Conference on the Law of the Sea, co-organized by the Ministry of Foreign Affairs of the Republic of Korea, the Korean Society of International Law, and the International Tribunal for the Law of the Sea. On a personal note, it is a distinct pleasure to join you for the second time in my capacity as President of the Tribunal. At the outset, I would like to express my gratitude to the Ministry of Foreign Affairs and the Korean Society of International Law for their initiative in organizing this event and congratulate them on bringing together such a distinguished and diverse group of experts to celebrate the 30th anniversary of the entry into force of the United Nations Convention on the Law of the Sea. The adoption of the Convention in 1982 is one of the greatest achievements in multilateral treaty making in the history of the United Nations, and up until the present day has contributed significantly in international peace and security. As the first and only comprehensive treaty on the law of the sea, the Convention combines both zonal and functional approaches, providing a jurisdictional regime prescribing the rights and obligations of states across different maritime zones and enshrining a substantive legal framework for all uses of the oceans. Crucially, the Convention also establishes a compulsory mechanism for the settlement of disputes. As you may gather from the conference program, the organizers have been successful in selecting panels that cover all the core features of the Convention that I have just highlighted. At the different commemorations of anniversaries of the Convention, such as ours today, it is repeatedly recognized that this instrument was negotiated with foresight and has withstood the test of time. However, it was emphasized already at the third United Nations Conference on the Law of the Sea, which was convened to negotiate and adopt the Convention, that scientific and technological advances and changes could occur and new economic, political, juridical, and environmental developments might take place, all of which could affect the subject matter of the parts of the Convention. Accordingly, the Convention, like any other living instrument, must adapt to changing circumstances. There are a number of ways in which such adaptation may occur, including the possibility of formal amendment, the adoption of so-called implementing agreements, the incorporation of external rules via rules of reference, and the jurisprudence of international courts and tribunals. I have decided to focus my remarks on the latter category and establish a connection with the discussions that will ensue over the course of the next 2 days. To be more precise, I will endeavor to demonstrate how the case law of the Tribunal has made noteworthy contributions to every panel theme of the present conference. Following the chronological order of the conference proceedings, I will start with the first panel, which centers on the territorial sea. As stipulated in Article 2, Paragraph 1 of the Convention, the sovereignty of a coastal state extends beyond its land territory and internal waters, and in the case of an archipelagic state, its archipelagic waters, to an adjacent belt of sea described as the territorial sea. Its breadth may not exceed 12 nautical miles, measured from baselines determined in accordance with the Convention. Where the territorial sea of two neighboring states with opposite or adjacent coasts overlap, a delimitation line will need to be drawn. In this regard, Article 15 of the Convention provides that neither of the two states is entitled, failing agreement between them to the contrary, to extend its territorial sea beyond the median line. It is therefore important to ascertain the existence and nature of such an agreement. In 2012, the Tribunal delivered its groundbreaking judgment in the dispute concerning delimitation of the maritime boundary between Bangladesh and Myanmar in the Bay of Bengal, which concerned inter alia the delimitation of the territorial sea. In its judgment, the Tribunal clarified several key aspects with regard to what kind of instrument might constitute an agreement within the meaning of Article 15 of the Convention. The Tribunal found that the term agreement refers to a legally binding agreement, and what is important is not the form or designation of an instrument, but its legal nature and content. After careful examination of the terms of agreed minutes of a meeting held between the parties' representatives, the Tribunal held that the latter document did not constitute an agreement in the sense of Article 15 of the Convention. In the very same case, the Tribunal also had the opportunity to address the issue of the overlap between the territorial sea on the one side and exclusive economic zone and continental shelf on the other. This occurred in relation to an insular feature belonging to Bangladesh, namely St. Martin's Island. The Tribunal pointed out that Bangladesh has the right to a 12 nautical mile territorial sea around St. Martin's Island in the area where such territorial sea no longer overlaps with Myanmar's territorial sea. It was further explained that a conclusion to the contrary would result in giving more weight to the sovereign rights and jurisdiction of Myanmar in its exclusive economic zone and continental shelf than to the sovereignty of Bangladesh over its territorial sea. Looking beyond the territorial sea, the Tribunal has dealt with various cases concerning the interpretation and application of the legal regime of the Exclusive Economic Zone, or the EEZ, which forms the focus of the second conference panel. The decisions rendered by the Tribunal have provided noteworthy clarifications on a range of matters, including the regulation of foreign-flagged vessels engaged in fishing and fishing-related activities in the EEZ. For instance, in 2014, the Tribunal delivered its judgment in the MV Virginia G case, the facts of which concerned bunkering in support of foreign flagged vessels fishing in the EEZ of a coastal state. The tribunal found that the use of the terms conserving and managing in Article 56 of the Convention indicates that the rights of coastal states in its EEZ go beyond conservation in its strict sense, and the regulation by a coastal state of bunkering of foreign vessels fishing in its EEZ is among those measures which the coastal state may take in its EEZ to conserve and manage its living resources under Article 56 of the Convention, read together with Article 62, Paragraph 4. It added that this view was also confirmed by state practice which had developed after the adoption of the Convention. While concluding that the bunkering of foreign vessels engaged in fishing in its EEZ is an activity which may be regulated by the coastal state concerned, the tribunal clarified that the coastal state does not have such competence with regard to other bunkering activities, unless otherwise determined in accordance with the Convention. Through its judgment, the tribunal removed some uncertainty that had beset the questions of bunkering, thus offering legal certainty to states parties and other interested actors. Apart from classical contentious cases on the merits, the tribunal also helps uphold the balance of rights and obligations laid out in the EEZ regime through its jurisprudence concerning prompt release of vessels and their crews. When a coastal state has taken enforcement measures, including arrest, in order to ensure compliance with the laws and regulations in the EEZ that it has adopted in conformity with the Convention, it is required to promptly release arrested vessels and their crews upon the posting of a reasonable bond or other security. Under Article 292 of the Convention, where the flag state of a vessel alleges that the coastal state has not complied with its prompt release obligation, the question of release may be submitted to the tribunal under the conditions specified in that provision. If the tribunal finds that the detaining state was bound to comply with its prompt release obligation, it will determine whether the bond fixed by the detaining state was reasonable. If no bond has been fixed, the tribunal will proceed to determine a reasonable bond. In its first decade of judicial activity, UNCLOS heard 9 applications for prompt release, including its very first case, the MV Saiga. However, interestingly, since 2007, only one such application has been brought to the tribunal. This may be explained by the fact that the tribunal has developed a comprehensive jurisprudence on various issues that may arise under Article 292 of the Convention. In particular, in the Kamioku case, the tribunal listed some of the factors it considers when assessing the reasonableness of a bond. It has been argued by some that the case law of the tribunal has served to prevent the occurrence of disputes in this field. I now wish to turn to the legal regime of the continental shelf, on which we will hear more from the speakers of the third conference panel. In this regard, the tribunal has made crucial contributions in the 3 maritime delimitation cases it has adjudicated: Bangladesh, Myanmar, Ghana, Cote d'Ivoire, and Mauritius, Maldives. The tribunal clarified in particular questions concerning jurisdiction to delimit the continental shelf beyond 200 nautical miles and the legal status of the so-called gray area. I will illustrate the relevant legal findings with reference to the Bangladesh, Myanmar, and Mauritius, Maldives cases. The 2012 judgment in the Bangladesh-Myanmar case, which I referred to earlier, constituted the first ever instance in which an international court delimited the maritime boundary between the parties' respective continental shelves beyond 200 nautical miles. On this occasion, the tribunal set out in detail the relationship between delimitation and delineation of the continental shelf beyond 200 nautical miles. As the tribunal pointed out, these are distinct processes: delimitation governed by Article 83 and delineation by Article 76 of the Convention. What they have in common, however, is the requirement of entitlement to a continental shelf beyond 200 nautical miles. Without demonstrating such entitlement, there cannot be any delimitation or delineation of an outer continental shelf. There are various circumstances in disputes regarding the delimitation of the outer continental shelf. In some cases, recommendations from the Commission on the Limits of the Continental Shelf, or the CLCS, may be available, and even final and binding outer limits established by the relevant coastal states on the basis of such recommendations from the CLCS. In other cases, where recommendations are not available, the relevant coastal states may be able to demonstrate entitlement to the outer continental shelf with different means, for example, through submissions made to the CLCS. In the Bangladesh-Myanmar case, both parties had made submissions to the CLCS, but the Commission had not been in a position to consider the submissions due to a lack of consent by the two states. Referring to the concept of a single continental shelf, the Tribunal clarified that it had jurisdiction to delimit the continental shelf in its entirety, both within and beyond 200 nautical miles. It also found that it was appropriate to exercise the jurisdiction in this case. Importantly, the Tribunal stated that it would have been hesitant to proceed with the delimitation of the area beyond 200 nautical miles had it concluded that there was significant uncertainty as to the existence of a continental margin in the area in question. However, it noted the unique situation of the Bay of Bengal as acknowledged in the course of the negotiations of the Third Law of the Sea Conference, and took note of uncontested scientific evidence that there is a continuous and substantial layer of sedimentary rocks extending beyond 200 nautical miles. On 28 April last year, an UNCLOS special chamber rendered a judgment in the Mauritius-Maldives case. This was the first case regarding delimitation between two archipelagic states, one located in Africa, the other in Asia. The case concerned the delimitation of the EEZ and the continental shelf within 200 nautical miles and of the continental shelf beyond 200 miles between the Chagos archipelago and the Maldives. As far as the delimitation of the outer continental shelf is concerned, both parties had filed submissions with the CLCS, but no recommendations had been made by the Commission. The special chamber stated that, to this extent, the situation was similar to that in Bangladesh-Myanmar case. Accordingly, it decided to apply the standard of significant uncertainty when assessing the existence of a continental margin beyond 200 miles. The Chamber further explained the rationale for applying this standard. It serves to minimize the risk that the CLCS might later take a different position regarding entitlements in its recommendations from that taken by a court or tribunal in a judgment, and affords protection to the interests of the international community in the area and the common heritage principle. What is different in the Mauritius-Maldives case is that while the entitlement of the Maldives to the continental shelf beyond 200 miles was uncontested between the parties, they disagreed as to Mauritius' entitlement to the outer continental shelf. Mauritius set out 3 different routes for natural prolongation to a foot of slope point, which it had identified as the basis of its claim. As the first route presented by Mauritius passed within the uncontested continental shelf of the Maldives within 200 miles, the Chamber considered that it was impermissible on legal grounds under Article 76 of the Convention. The Chamber then found that there was significant uncertainty as to whether the second and third routes could form a basis for Mauritius' natural prolongation. Therefore, the Special Chamber concluded that given the significant uncertainty, it was not in a position to determine the entitlement of Mauritius to the outer continental shelf and consequently did not proceed with the delimitation of the continental shelf beyond 200 miles. Through its meticulous and well-reasoned application of the significant uncertainty standard, the Tribunal has not only made significant contributions towards the understanding of the outer continental shelf, but also strengthened the status of the Convention as a living instrument by offering a solution to the potential impasse in the implementation of the Convention. The second important issue concerning the outer continental shelf that the Tribunal has clarified in its jurisprudence is the legal status of the so-called grey area. In the Bangladesh-Myanmar case, the Tribunal stated that the delimitation of the continental shelf beyond 200 miles, in this case, gives rise to an area of limited size located beyond 200 miles from the coast of Bangladesh, but within 200 miles from the coast of Myanmar, yet on the Bangladesh side of the delimitation line. A grey area arises in the delimitation of the continental shelf beyond 2 nautical miles between states with adjacent coasts whenever a delimitation line deviates from an equidistance line. In the Bangladesh-Myanmar case, a relatively small grey area was the consequence of the adjustment of the provisional equidistance line in favor of Bangladesh, which was required to achieve an equitable solution. The Tribunal explained that in the grey area in question, Bangladesh has continental shelf rights with respect to the seabed and subsoil, and Myanmar has EEZ rights with respect to the subadjacent waters. Thus, there is an overlay of Bangladesh's continental shelf rights and Myanmar's EEZ rights in the grey area. The Tribunal pointed out that there are many ways in which the parties may ensure the discharge of their obligations in this respect, including the conclusion of specific agreements or the establishment of appropriate cooperative arrangements. It is for the parties to determine the measures that they consider appropriate for this purpose. At present, allow me to shift from the zonal approach to the functional approach and take up the topic of marine environmental protection, which will be addressed during the 4th conference panel. The Tribunal has dealt with a number of cases in which it was called upon to closely examine the rules of the Convention that deal with the protection and preservation of the marine environment, as found primarily in its Part 12. Different types of proceedings have been a source of relevant jurisprudence, including orders prescribing provisional measures, such as the Southern Bluefin tuna cases, and advisory opinions, namely the 2011 Area Advisory Opinion of the Seabed Disputes Chamber, the 2015 SRFC Advisory Opinion, and the 2024 Climate Change Advisory Opinion, both of which were handed down by the plenary tribunal. The Tribunal has interpreted and applied many of the obligations stemming from Part 12 of the Convention, including the general duty to protect and preserve the marine environment, the duty to cooperate, the duty to apply the precautionary approach, and the duty to conduct environmental impact assessments, and has opined on the nature of different types of obligations, including due diligence. In its jurisprudence, the Tribunal has given authoritative interpretations of what is meant by the term marine environment under the Convention. Although Part 12 of the Convention focuses on marine pollution, it is clear from its Section 1 that it was never intended to be limited to pollution, and that it also encompasses protection of ecosystems and conservation of depleted and endangered fauna and flora. Reference may be made to the Southern Bluefin tuna cases, which related to a fisheries dispute, and provisions of the Convention concerning fishing. Nonetheless, the Tribunal expressly stated in its order that the conservation of the living resources of the sea is an element in the protection and preservation of the marine environment. This finding was later confirmed in the SRFC Advisory Opinion and in the Climate Change Advisory Opinion. This brings me to the latter advisory proceedings, which I will now explore in greater detail. In what has been referred to as a landmark ruling, the Tribunal concluded in the Climate Change Advisory Opinion of 21st May last that anthropogenic GHG emissions into the atmosphere constitute pollution of the marine environment within the meaning of Article 114 of the Convention. I'm sure that we will hear more on this historic case during the fourth conference panel, which will also consider the nexus between the law of the sea and climate change. It bears reiterating that on 26 August 2022, the Commission of Small Island States on Climate Change and International Law, which I will refer to as COSIS, decided to request an advisory opinion from the Tribunal on two questions. The first question, which is centered on pollution of the marine environment, was formulated as follows. What are the specific obligations of states parties to the Convention, including under Part 12, to prevent, reduce, and control pollution of the marine environment in relation to the deleterious effects that result or are likely to result from climate change, including through ocean warming and sea level rise, and ocean acidification, which are caused by the anthropogenic greenhouse gas emissions into the atmosphere. As you may well know, terms such as climate change, greenhouse gas emissions, and ocean acidification do not appear in the text of the Convention, since they were not necessarily in the minds of its drafters back in the 1970s and early 80s. Nevertheless, the advisory opinion makes clear that the absence of such terminology does not place these phenomena beyond the scope of the Convention. The Tribunal observed that the first question submitted by COSIS concerns the specific obligations of states parties to the Convention to prevent, reduce, and control marine pollution in relation to the deleterious effects that result or are likely to result from climate change and ocean acidification, which are caused by anthropogenic GHG emissions into the atmosphere. Noting that this question is formulated on the premise that these obligations necessarily apply to climate change and ocean acidification, the Tribunal stated that the validity of this premise could not be presumed and therefore needed to be examined. The Tribunal therefore considered whether anthropogenic GHG emissions meet the criteria of the definition of pollution of the marine environment in Article 1, Paragraph 1, Subparagraph 4 of the Convention. I will read out the latter provision. For the purposes of this Convention, pollution of the marine environment means the introduction by man, directly or indirectly, of substances or energy into the marine environment, including estuaries, which results or is likely to result in such deleterious effects as harm to living resources and marine life, hazards to human health, hindrance to marine activities, including fishing and other legitimate uses of the sea, impairment of quality for use of seawater, and reduction of amenities. Following thorough examination, the Tribunal found that anthropogenic GHGs are substances, that their emissions are produced by man, and that by introducing carbon dioxide and heat, which is energy, into the marine environment, they cause climate change and ocean acidification, resulting in deleterious effects. On this basis, having determined that all three criteria of the definition were satisfied, the Tribunal concluded that anthropogenic GHG emissions into the atmosphere constitute pollution of the marine environment within the meaning of Article 114 of the Convention. Accordingly, the advisory opinion has brought climate change into the realm of the Convention and confirmed the applicability of pollution-related provisions in the Convention with regard to GHG emissions. The advisory opinion also shows how external rules, including those addressing climate change and environmental issues, interact with the Convention and enable the latter to remain up to date. As highlighted by the Tribunal, coordination and harmonization between the Convention and external rules are important to clarify and to inform the meaning of the provisions of the Convention and to ensure that the Convention serves as a living instrument. At this juncture, I wish to turn my focus to the topic of our last panel, dispute settlement under the Convention, and share some thoughts on the jurisdiction of the Tribunal. As one of the means for the settlement of disputes under Article 287 of the Convention, the Tribunal shares the compulsory jurisdiction to deal with disputes concerning the interpretation and application of the Convention with the International Court of Justice and arbitral tribunals constituted under Annex 7 and Annex 8 to the Convention. In addition to this, the Tribunal also enjoys exclusive compulsory jurisdiction in relation to 3 categories of contentious proceedings: disputes concerning activities in the area with respect to the seabed dispute chamber, the prescription of provisional measures pending the constitution of an arbitral tribunal, and applications for prompt release of vessels and crews. Moreover, both the seabed dispute chamber and the full tribunal enjoy advisory jurisdiction. Having received 33 cases, of which 2 are currently on the docket, the Tribunal has consistently and conscientiously fulfilled its mandate, and in so doing has strengthened the dispute settlement mechanism under the Convention. It is noteworthy that the Tribunal has received the largest volume of cases submitted pursuant to Part 15, Section 2 of the Convention. This exceeds the number of Annex 7 arbitral tribunals that have been constituted, which serve as the default forum under Article 287 of the Convention. It may also be observed that parties have opted to transfer their disputes from Annex 7 arbitration to the Tribunal in an increasing number of instances, including all 3 maritime delimitation cases that have come before the Tribunal or a special chamber, as well as the ongoing MT Heroic Eden case, number 2 case. This trend signals the trust that states parties to the Convention place in the Tribunal. A further sign of this confidence in the Tribunal can be found in the newly adopted agreement under the UN Convention on the Law of the Sea on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, or BBNJ agreement. Pursuant to Article 47, Paragraph 7 of the agreement, the Conference of the Parties may decide to request the Tribunal to give an advisory opinion on a legal question on the conformity with the agreement of a proposal before the Conference of the Parties on any matter within its competence. Thus, the Tribunal may be called upon to assist the parties to the BBNJ agreement with its effective implementation through the issuance of advisory opinions. In my view, this development also shows states' recognition of the significance of advisory opinion in tackling contemporary challenges, as demonstrated by the climate change advisory opinion. In light of the experience of that opinion, I believe that the Tribunal has shown that it plays a crucial role in ensuring that the Convention remains relevant as a living instrument and will continue to do so in the foreseeable future. Excellencies, distinguished guests, I have now come to the end of my keynote address. On behalf of the Tribunal, I wish to reiterate our appreciation to the Ministry of Foreign Affairs and the Korean Society of International Law for coordinating this most promising conference and also for their hospitality. I look forward to the interesting discussions ahead, and thank you for your kind attention.
Thank you, President, for your insightful keynote address. Thank you once again. Now, before we proceed to the main session, we'll have a 20-minute coffee break, so please enjoy your time, and we will resume at 10:40 a.m. Korea Standard Time. Thank you. Ladies and gentlemen, once again, may I have your attention, please? We'll resume the conference shortly at 10:40 a.m., so please enter the hall and take your seat. Thank you. Once again, ladies and gentlemen, we'll resume the conference at 10:40 a.m., so please enter the hall and take your seat. Thank you. Ladies and gentlemen, we'll soon resume our conference. That is session number 1, so please come inside the hall and take your seat. Ladies and gentlemen, once again, we'll resume the session, and please come inside the hall and take your seat. Thank you. Ladies and gentlemen, welcome back to the 9th International Conference on the Law of the Sea. Now we'd like to commence the first session of our conference under the topic of coastal state jurisdiction in the territorial sea. And for this, Her Excellency Maria Teresa Infante Coffey, Judge of the International Tribunal for the Law of the Sea, will moderate this session. Judge Infante Coffey, now the floor is yours.
Thank you very much. Good morning, Excellencies, professors, distinguished participants. It is a real honor to moderate this panel, which is devoted to the coastal state jurisdiction in the territorial sea. As the title suggests, the focus is on jurisdiction and its connections with sovereignty and its limits. There are strong underpinnings in international law of this subject. Questions relating to people on board foreign flagged vessels from the perspective of their protection will also be analyzed in the panel. The powers of coastal states is among the most traditional chapters of the law of the sea, and this panel will certainly provide a better view of the current situation and will anticipate features of future developments in a highly dynamic area. Among the aspects to consider in these scenarios, there are trends to include the perspective of people at sea, from the balance of interest and rights between coastal states and foreign vessels, to the question of jurisdiction to adopt measures in certain situations, what raises, among other issues, the nature and scope of the innocent passage issue. Articles 17 to 20 of UNCLOS could be read as established law. They reflect the current framework of the territorial sea regime. The question for the panel is whether there are new insights to illuminate their purposes and object. The panel is integrated by the following speakers and discussants: Professor Tara Davenport from the National University of Singapore, where she's an assistant professor at the Faculty of Law. She's also co-head of the Oceans Law and Policy team at the Center for International Law at the University of Singapore, National University of Singapore, Deputy Director of the Asia Pacific Center for Environmental Law, and member of the Executive Council of the Asian Society of International Law, a member of the editorial board of the Asian Journal of International Law and Ocean Development and International Law Journal. She studied at the London School of Economics, the National University of Singapore, and Yale Law School. Her research interests are in the law of the sea, including maritime security, submarine cables, deep seabed mining, interactions between climate change and law of the sea and the marine environment. Then Professor Anna Petri, who holds the chair of international law and public law at the University of Basel in Switzerland. She was previously professor at the University of Zurich. She studied at the University of Basel and in Harvard Law School, and is a member of the bar of the Canton of Bern and of the New York State Bar. Her legal experience includes work in private practice, the courts, and the legal division of the International Committee of the Red Cross. She has contributed with many textbooks on the law of the sea, international public law, and criminal law. She has provided expert advice, oral evidence, and legal counsel on maritime-related matters to the government of Switzerland, to NGOs, to the United Kingdom House of Lords, and international organizations. She was also a member of the Swiss delegation to the International Maritime, has been a member of the Swiss delegation to the International Maritime Organization. And what is very important, she was sitting as a dog judge in the International Tribunal for the Law of the Sea in cases 27 and 29. And she's currently a board member of the Swiss Maritime Law Association and the Swiss Society of International Law, and co-rapporteur of the Committee on Protection of People at Sea of the International Law Association. Mr. Carl Reich, from the Ministry of Foreign Affairs and Trade of New Zealand, is currently Chief International Legal Advisor in the New Zealand Ministry of Foreign Affairs and Trade, and responsible for general international law, trade law, sanctions issues, and environmental law. He has been ambassador to the European Union and NATO, and has had postings in The Hague and Geneva. Before joining the Ministry of Foreign Affairs and Trade, Mr. Reich worked for the New Zealand Attorney General's Department and was a state prosecutor. His studies have been followed at the University of Canterbury and the Victoria University of Wellington in his home country, New Zealand. And Dr. Kim Won-hee, from the Korea Institute of Ocean Science and Technology. He's director of the Ocean Law Research Department at the Korea Institute of Ocean Science and Technology. Before joining the institute, he was a senior researcher at the Korea Maritime Institute and the secretary-in-chief of the Korea Society of International Law. He was also a lecturer at Konkuk University, a women's university, and Korea National Open University. Dr. Kim participated as a legal advisor to the Korean delegations in the 5th session of Intergovernmental Conference on the BBNJ Agreement and the meeting of state parties to UNCLOS. He has recently published studies such as reconceptualization of the critical date in territorial disputes in the light of the law of evidence before the international courts and tribunals, United Nations ocean governance and recent practice of the Republic of Korea on the law of the sea, as well as the import of hybrid activities in the South China Sea. With these presentations, now I open the panel. Panelists will have 30 minutes each, and they will have discussions of 15 minutes each. And then we will leave 10 minutes for general questions and comments. So with this, Tara, the time is yours. Thank you.
Good morning, distinguished guests. Excuse me. I am truly honored to be here today in such a distinguished panel and such a distinguished conference, and would like to express my heartfelt thanks to the Ministry of Foreign Affairs, the Korean Society of International Law, and the International Tribunal for the Law of the Sea for the invitation and wonderful arrangements. Today, I'm talking about reconceptualizing coastal state sovereignty in the territorial sea through the lens of transit submarine cables. Two disclaimers before I begin my presentation. Firstly, my ideas on this are very tentative, very preliminary, still evolving. And secondly, I'm here in my personal capacity, and in no way does this represent the views of Singapore or the Center of International Law or the National University of Singapore. Right, so I'm going to go straight to the problem. There are generally two types of submarine cables: submarine fiber optic cables, which traverse the ocean floor, connecting continents and countries, and which facilitate the transmission of data, providing internet-related services that we take for granted every day, and more importantly, that contribute significantly to the economic development of states. The second type of submarine cable are submarine power cables, which facilitate the transmission of electricity. While not as extensive as submarine fiber optic cables, you can see from this chart that their use has been steadily increasing, especially as the world turns to renewable energy in the quest to get to net zero emissions. The legal regime governing submarine cables, of course, is set out in the 1982 UN Convention on the Law of the Sea, which purported to establish a legal order for the oceans which will facilitate international communications, which I've highlighted there in the preamble. Excuse me. The provisions in UNCLOS on submarine cables are based on older treaties, such as the 1884 Convention on the Protection of Submarine Telegraph Cables and the 1958 Geneva Conventions on the continental shelf and on the high seas. When UNCLOS was concluded in 1982, submarine cables were not extensively relied upon. You can see in 1982, there were 6 submarine fiber optic cables, 17 submarine power cables. This year, there are 559 submarine fiber optic cables and approximately 450 submarine power cables. These submarine fiber optic cables provide 99% of global telecommunications, and of course, power cables are providing an increasing proportion of our energy needs, especially as we turn to renewable energy. While UNCLOS affirmed that all states had the freedom to lay and repair cables in the exclusive economic zone and the continental shelf, high seas, and deep seabed, of course, subject to the various obligations and rights in those zones, in areas subject to sovereignty, such as the territorial sea, the straits used for international navigation, and archipelagic waters, the right to lay and repair submarine cables was deemed to be subject to coastal state or archipelagic sovereignty. This leads us to the subject of this presentation, finally, namely submarine cables that transit areas under sovereignty without making landfall, which I will describe as transit submarine cables. I've put here some examples on the basis, on the perspective of Singapore, which is a global hub for submarine fiber optic cables, but being a geographically disadvantaged state, several of these cables have to pass through the territorial seas of Malaysia and archipelagic waters of Indonesia. In the second image, you will see the proposed Sun cable, which intends to import low-carbon electricity from Australia to Singapore. But it is subject, of course, to the regulatory approval of Indonesian authorities as the cable passes through their waters. Singapore is one such example, but there are other examples of transit submarine cables passing through the territorial sea of coastal states without making landfall, particularly given the extensive use and reliance on submarine cables. So I guess the problem that I've been contemplating, or the issue that I've been contemplating, is, of course, the assumption is that such transit submarine cables are subject to coastal state sovereignty under UNCLOS. Pursuant to such sovereignty, it is generally accepted that coastal states can refuse consent for deployment of such cables, or refuse consent for the repair of existing cables, or can impose permitting requirements or cabotage requirements. Coastal states have a significant degree of leverage over the deployment and repair of such cables, and there is an assumption that there is a little recourse to challenge such regulations. The question, which is really a hypothetical scenario, which I want to explore, is do coastal states have obligations to states that are connected to submarine cables that transit the coastal state's territorial sea? This is, again, as I said, a very much hypothetical question, but I thought it would be a useful lens through which to interrogate a broader question of the limits of coastal state sovereignty in the territorial sea. Transit submarine cables pose a unique challenge in that they do not directly benefit the coastal state, but their neighboring states. But they also raise similar concerns that coastal states would have in their territorial sea in relation to their security and environmental concerns of activities in their territorial sea. I intend to develop my argument by talking about the historical development of coastal state sovereignty, the conception of coastal state sovereignty under the Law of the Sea Convention, the limits that have been developed by UNCLOS courts and tribunals, and then going back to the question and seeing how these arguments can apply to my initial question: do coastal states have obligations to states that are connected to submarine cables that transit the coastal state's territorial sea? Do not be alarmed. I do not intend to start at the 12th century for the development of coastal state sovereignty, but only to start with a general proposition that state sovereignty over territory has evolved over historical and political contexts and has also been heavily contested. There has always been this tension between, I guess I would say, absolutist conceptions of sovereignty, as articulated by Jean Bodin, as this idea of sovereignty is absolute, perpetual, and undivided, to a gradual limitation on sovereignty, which I would say reflects modern conceptions of state sovereignty in the 20th and 21st century. The development of coastal state sovereignty over the territorial sea has a long and complex history, which is closely linked to the development of the nation state. So, of course, the seeds for coastal state sovereignty over the territorial sea can be traced back to the 17th century debates between Grotius and his contemporaries in response to the explosion of colonial, maritime, and trading ambitions of European states. As I'm sure the audience here knows well, Grotius used domestic conceptions of property based on Roman law to argue that the seas were res communis, common property, because it could not be occupied due to its non-rivalrous nature and its susceptibility to universal use. Grotius was using, of course, these arguments to support freedom of navigation and ultimately freedom of trade. But he also acknowledged later on that some parts of the sea near the coast could be occupied and subject to private property, with the caveat that such occupation should not hinder common uses, such as navigation, which really did not deprive coastal states of the use or enjoyment of that area. So there were various different theoretical justifications for coastal state rights in the territorial sea between the 17th and 20th century. In the 17th and 18th century, the idea that such waters were the property, were owned by the coastal state was prominent. The basis of such ownership would be, for example, again, based on this idea of occupation and control, such as through the 3 nautical mile cannon shot rule, exclusive fishing rights. However, property theories were not able to reconcile ownership with the recognition of the growing rights or the important rights of ships to navigate unimpeded, which became particularly important in the 19th century with the growth in trade, developments in technology, with the steamship, and so forth. Therefore, other theories, such as the jurisdictional theories, which essentially argued that coastal states had certain rights of jurisdiction over the sea, but without owning it, and therefore innocent passage was permitted. But there were also weaknesses with the jurisdictional theories, because it could not account as to why coastal states have exclusive rights to maritime resources or marine resources in the territorial sea. This led to sovereignty theories. Right, sovereignty theories became entrenched, and I put here a quote from Richard Barnes in his book Property and Natural Resources, where property-based claims merge with the exercise of governmental authority. D.P. O'Connell would more acerbically observe that the predatory instincts of states could only be satisfied in the concept of sovereignty, for where sovereignty was lacking, there was doubt about the state's authority to appropriate to itself the riches of the coastal sea and to legislate effectively for foreign ships. So this idea of sovereignty not only entailed jurisdiction, both prescriptive and enforcement, but also this idea of exclusive rights to the resources. In the 20th century, debates about the juridical nature of the territorial sea died down, and very few authors disagreed with the notion that the coastal state had sovereignty, and this was bolstered by developments in state practice. In the Grisbadana case of 1909, the Permanent Court of Arbitration found that that maritime territory constituted an inseparable appurtenance of the land territory, which automatically forms part of ceded territory, presaging the arguments we would see in the continental shelf cases, this idea that it is your sovereignty over your territory that gives you sovereignty over the waters and the continental shelf eventually. The prevailing theory at that time was that the territorial sea depended not on the coastal state's property rights, but that of sovereignty over land territory. In the 1930 Hague Conference, which was the first attempt to codify the law of the sea, the Property Commission noted, it would seem possible to take as a point of departure the proposition that the state possesses sovereignty over a belt of sea around its coasts. This involves possession by the state in the belt of the totality of those rights which constitute sovereignty, so that it is not necessary to specify, for example, that it has legislative authority over all persons, power to make and apply regulations, judicial authority, power to grant concessions, and so forth. Again, in the 1956 ILC draft articles, this conception of coastal state sovereignty didn't really change much. Article 1 of the ILC draft articles said the sovereignty of a state extends to a belt of sea adjacent to its coasts, described as the territorial sea. It went on to say that the Article 1.2, the sovereignty is exercised subject to the conditions prescribed in these articles and by other rules of international law. The commentary noted that paragraph 1 brings out the fact that the rights of the coastal state over the territorial sea does not differ in nature from the rights of sovereignty which the state exercises over other parts of its territory. Again, it also noted this idea that this reference to other rules of international law was because it could not exhaustively state what the limitations to coastal state sovereignty would be. So again, the nature of coastal state sovereignty in the territorial sea was not subject to much discussions during the negotiations of UNCLOS in the third conference on the UN Law of the Sea. Although there was an attempt by Ecuador to provide a detailed list of activities that was to be regulated by the coastal state, including natural resources, energy generation, marine pollution, marine scientific research, artificial islands, and so forth. The primary limitation on coastal state sovereignty in UNCLOS is this obligation not to hamper innocent passage of foreign vessels. Beyond innocent passage, oh, thank you very much. You can tell my voice is going. Excuse me. My apologies for that. Beyond innocent passage, there is uncertainty on coastal state authority to control activities in the territorial sea. A state that wishes to claim otherwise has the burden of proving that other rules of international law restrict the residual authority of a coastal state to regulate a particular activity. Again, this idea, the conception of sovereignty in UNCLOS, right, in comparison to the exclusive economic zone and continental shelf, which is very much seen as zones of shared obligations, shared rights, shared responsibilities, through the mechanisms of due regard, for example, as well as its obligation not to cause unjustifiable interference with the rights and freedoms of other states. This was not present in Part 2 of the Law of the Sea Convention. Again, I come back to one of my favorite jurists, D.P. O'Connell, right, who I think provides a very good conception, or I guess articulation of the conception of sovereignty that underpinned coastal state sovereignty in the Law of the Sea Convention at the time it was negotiated. A state is sovereign over something which it can impose its power over the thing, and the territorial sea is something over which a state can exercise its dominion by force of arms. International law in its present form admits that the territorial sea, without being susceptible of property in the private law sense of the term, is so in the international sense of sovereignty. The result is that the coastal state is sovereign in the coastal seas as it is on dry land, and its sovereignty is a prolongation of its territorial sovereignty. The territorial sea is part of its domain and not simply a part of the vast ocean envisaged in its majestic unity. So this idea, again, that the oceans has always been this space of shared rights and obligations and responsibilities, but this was not so in at least the conception of sovereignty that underpinned the Law of the Sea Convention. But of course, UNCLOS courts and tribunals have tried to, or have attempted to articulate some limits to coastal state sovereignty. In the Chagos Marine Protected Area Arbitration in 2015, it noted that Article 2.3 places an obligation on coastal states to exercise their sovereignty subject to the general rules of international law, as opposed to bilateral undertakings. It noted that the ILC considered reference to other rules of international law necessary, as there were certain general rules of international law which were applicable in the matter, as indeed to other topics of international law, such as the principle prohibiting the abuse of rights and generally the law of state responsibility. Article 2.3 requires the United Kingdom to exercise good faith with respect to Mauritius' rights in the territorial sea. Article 56.2 requires the United Kingdom to have due regard for Mauritius' rights in the exclusive economic zone. The tribunal considers these requirements to be, for all intents and purposes, equivalent. And again, I think it's useful to elaborate on this idea of due regard, which the arbitral tribunal articulated, right? They said that it's not a universal, the due regard obligation does not prescribe a universal rule of conduct. The extent of the regard required by the convention will depend upon the nature of the rights held by Mauritius, their importance, the extent of the anticipated impairment, the nature and importance of the activities contemplated by the United Kingdom, and the availability of alternative approaches. In the majority of cases, this assessment will necessarily involve at least some consultation with the rights-holding state. To me, this is alluding to this idea of proportionality, that your rules and regulations have to be proportional. In the South China Sea arbitration, the arbitral tribunal recognized that traditional fishing rights constituted a vested right, and the tribunal considers the rules of international law on the treatment of vested rights of foreign nationals to fall squarely within the other rules of international law applicable in the territorial sea. The tribunal noted, however, that traditional fishing rights are not absolute or impervious to regulation. Customary international law in this respect does not restrict the coastal state from reasonable regulation. Again, this is sort of a recognition that the territorial sea is also this area of shared rights and obligations in which balancing of interests between states is necessary. In the Dusgit integrity arbitration in 2016, which I think is also very interesting, this concerned the exercise of enforcement jurisdiction by Sao Tome, I'm pronouncing it wrongly, over a vessel that is suspected was committing ship-to-ship transfer in its archipelagic waters. The arbitral tribunal found that in the tribunal's view, when considered together with the prolonged detention of the master and the vessel, the monetary sanctions, and the confiscation of the entire cargo, this cannot be regarded as proportional to the original offense or the interest of ensuring respect for Sao Tome's sovereignty, including Sao Tome's interest in demonstrating that such conduct will not be tolerated in future cases. Excuse me, I'm going to take a drink of water. The disproportionality is such that it renders the cumulative effect of these sanctions incompatible with the responsibilities of a state exercising sovereignty on the basis of Article 49 of the Convention. This, of course, refers to sovereignty in archipelagic waters. The tribunal went on to find that Article 300 of the Convention, which sets out a good faith and abuse of rights obligations, which I'll come to later, it noted that the tribunal is not aware of any prior instance in which another tribunal or court has found a breach of Article 300 of the Convention. There is therefore little guidance as to the legal test that needs to be satisfied. In the present case, the tribunal sees no need to determine a violation of Article 300, given that it has already determined that Article 49.3 has been violated. Again, this alludes to this idea that sovereignty comes with certain responsibilities. A last slide on potential other limits to coastal state sovereignty. Other rules of international law which have not been explicitly dealt with by UNCLOS courts and tribunal. This idea of no harm. A state's sovereign right to use its territory is circumscribed by an obligation not to cause injury to or within another state's territory. This was, of course, recognized in the Islands of Palmer's arbitration. Territorial sovereignty has a corollary, a duty, the obligation to protect within the territory the rights of other states, in particular their right to integrity and inviolability. In the Corfu Channel case, every state's obligation not to allow knowingly its territory to be used for acts contrary to the rights of other states. So, of course, this is manifested most concretely in the obligation not to cause a transboundary environmental harm. And again, this, cases such as the land reclamation case, the South China Sea arbitration, right, the idea of the duty to cooperate puts a restraint on the complete discretion that coastal states have within its territorial sea. There is restraint in what it can do within its territorial sea. It cannot cause harm to other states. Article 300 of the Law of the Sea Convention, state parties shall in good faith assume the obligations under this convention and shall exercise the rights, jurisdiction, and freedoms recognized in the convention in a manner which would not constitute an abuse of rights. So, testing the limits, I see I have 6 minutes, I'm making good time. Back to the question, do coastal states have obligations to states that are connected to submarine cables that transit their coastal state's territorial sea? I would like to tentatively and preliminarily argue that the cases that I've discussed so far demonstrates there are limits to sovereignty, underpinned by this conception that even in areas subject to sovereignty, it is still necessary to balance rights and obligations of other states. And this is done through various mechanisms, be it good faith, be it through the idea of proportionality. However, both the Chagos Marine Protected Area arbitration as well as the South China Sea arbitration was based on this idea of other states had vested rights. There are no such vested rights for states that are connected to transit submarine cables, right? The right to lay and repair a submarine cable in the territorial sea is not recognized in the Law of the Sea Convention. There's a more promising argument that can be made in the Dusgit integrity arbitration, right? This idea that the enforcement actions taken by Sao Tome were not proportional to the interest of ensuring respect for Sao Tome's sovereignty under Article 49 of UNCLOS. Could it be argued, for example, that particularly for coastal state regulations for the repair of transit submarine cables, it's very important to do it in a very expeditious manner, that regulations which are excessive do not meet this requirement of proportionality? Is there a general requirement that coastal state sovereignty or coastal state jurisdiction has to be exercised in a proportionate manner that really aims to protect the sovereignty of the coastal state? What about the obligation to ensure that any regulations relating to transit submarine cables do not cause harm to the states connected to the transit submarine cable? Right, this idea that if you don't, in particular, allow repairs or even deployment, you are in some way harming the interests of connected states to the transit submarine cable. The possibility of using Article 300 of UNCLOS, this idea of good faith and abuse of right, is probably not going to be very successful. Courts and tribunals have found that this is not a standalone right and has to be accompanied with breaches of other obligations in the Law of the Sea Convention. So, in conclusion, I would say that while there has been a shift towards viewing the territorial sea and other areas under sovereignty as not the absolute domain of the coastal state and an area of shared rights and responsibilities in which some form of balancing of interests must take place, either through this idea of good faith or proportionality, there is still uncertainty on the limits of coastal state sovereignty, and in turn, the limits of coastal state jurisdiction in relation to activities that do not fall within the innocent passage paradigm. As a matter of lex lata, it is not possible to state with certainty whether coastal states have obligations to states that are connected to submarine cables, although plausible arguments can be made, particularly in relation to proportionality and good faith. UNCLOS was adopted at a time when submarine cables were not in extensive use as they are now, and the question remained as a matter of lex ferenda, and of course there are many ways in which, there's still the hurdle of how this is going to be done, whether the interests of all states in communications and energy supply necessitates a rethinking of the laying and repair of transit submarine cables in areas under sovereignty. Perhaps it is time to think about coastal states, of course, being able to regulate the activity, as they do with innocent passage, but in a way that is specifically circumscribed. Again, we go back to this idea that Grotius articulated, this idea of common use, and that even in areas in which there is sovereignty, right, this does not mean that the common use of the oceans can be prohibited. And I will end with that, with exactly 1 minute and 54 seconds. Thank you very much.
Thank you very much, Professor Davenport. And now I invite Professor Anna Petty to take the floor. Thank you.
Dear Excellencies, judges, ladies and gentlemen, it's really a great pleasure and an equally great honor to speak at this very prestigious conference, generally hosted by the Korean Ministry of Foreign Affairs, the UNCLOS, and the Korean Society of International Law. Thank you very much for the invitation and for your overwhelming hospitality. This conference marks the 30th anniversary of the entry into force of UNCLOS. This is indeed an appropriate moment to reflect on how the interpretation of the rules of UNCLOS have been shaped by developments within and outside the law of the sea over the past 3 decades, and where the journey might lead us in the future, or to use the words of the conference title, to reflect on the then, now, and the future of UNCLOS. When choosing a topic for this conference, it was natural to ask where there have been noticeable differences between the then and now, and that could influence the interpretation of the rules on coastal state jurisdiction, and where there seems to exist some momentum for the law of the sea to move in new directions in the future. One of the areas where the law, and arguably even more so its interpretation, has undergone significant changes between the entry into force of the UNCLOS and today is the protection of people at sea. For the longest of the time, people at sea remained rather invisible. This is also reflected in the text of the UNCLOS, which has, to quote Sir Malcolm Evans, more to say about protecting fish than about protecting people. Yet, over the past 15 years, a series of crises, the security crisis with piracy, the migration crisis, the health crisis with the pandemic, made people at sea somewhat more visible, including the risk of violations of their most basic rights. The ensuing doctrinal and policy debates have largely dismantled the ideas that the oceans are an exceptional space where human rights would not apply. During the very same period, transnational crime at sea has risen to the top of the list of security threats, underscoring the relevance of transnational criminal law for the maritime domain. A body of law that was bolstered by the entry into force of new treaties after the turn of the millennium. Think of the UN Convention Against Transnational Organized Crimes or the Trafficking in Persons Protocol. Finally, in the past decade, there has been a growing recognition of the link between transnational crime and violations of rights of people on board ships. For example, instances of IUU fishing, trafficking of people, forced labor, and inhuman treatment not rarely occur in combination. In light of these developments, this presentation aims to shed light on the possible interaction between the innocent passage regime of the UNCLOS and human rights at sea and transnational criminal law at sea. The innocent passage regime, a cornerstone of international law of the sea, is shaped by the interest of the coastal state and in asserting jurisdiction over the waters of their coast, and the interest of flag states in unimpeded navigation therein. The UNCLOS codifies and thus stabilizes this delicate balance struck between these competing interests. However, the relevant provisions allow for a degree of flexibility in considering changes in the legal order and shifting priorities in ocean governance, thus enabling the Convention to remain in tune with the times. Against this background, I would like to offer reflections on two key questions. First, it will be asked whether UNCLOS authorizes the coastal state in certain situations to take action against a foreign flagged ship in its territorial sea on the grounds that the violation of the rights of persons on board would render the passage non-innocent. In other words, is it conceivable that violations of the rights of people on board render the passage non-innocent? Second, and assuming for the sake of the argument that the UNCLOS does confer jurisdiction on the coastal state because the ship's passage is non-innocent, it will be explored whether international human rights law and/or transnational criminal law might even oblige the coastal state to exercise its jurisdiction. That is, whether the coastal state may, by virtue of external rules, be obliged to subject the ship to its laws and procedure, even if under the law of the sea considered in isolation, the coastal state is only authorized but not obliged to do so. Before starting the analysis, a caveat is in order. This presentation will ask more questions than it answers. To provide firm answers is impossible at this stage for at least three reasons. First, the provisions of the UNCLOS on the innocent passage regime carry a high number of ambiguities and are controversially discussed. Second, while the concept of human rights at sea has gained in acceptance in recent years, it is far from being fully established. Third, there is very little doctrine and even less state practice on the interaction between coastal state jurisdiction in the territorial sea, international human rights law, and transnational criminal law. In light of this, please consider this presentation as an invitation to join me in an exploration and to navigate together through uncharted waters. Let me begin with the question of whether the UNCLOS authorizes the coastal state to take actions on the grounds that a violation of rights renders the passage of the ship non-innocent. We will thus explore whether violations of rights of people on board a foreign-flagged vessel in the territorial sea of a third state could render the passage of that ship non-innocent. In that case, the coastal state would have full prescriptive and enforcement jurisdiction over the ship in question and would therefore be entitled to take action. In other words, the foreign-flagged ship would lose its shield protecting it from the coastal state jurisdiction. The meaning of innocent passage is defined in Article 19. The provision appears to offer 3 possible avenues for taking into account violations of rights of people on board. The first possible avenue offers Article 19.2L, which provides that passage is non-innocent if the vessel engages in, I quote, any activity not having a direct bearing on passage. This is the last item on a list of 12 activities that render passage non-innocent, a list that was intended to remove some of the subjectivity in the assessment of non-innocence. While some describe it as a catch-all provision, compromising the very idea of removing the subjectivity in the assessment, I think it's still very challenging and far from obvious to argue that violations of rights of people are covered by this item. Let me give 3 reasons why this is the case. First, the violation of rights might be excluded from this clause because it has been argued, in contexts other than this one, that the wording of Article 92L refers to the conduct of the ship rather than the conduct of persons, and violations of rights are carried out by persons. This argument can probably be refuted by pointing out that various provisions of the UNCLOS refer to ships when they actually mean the persons on board. This is true even of provisions relating to offenses which are per se committed by human beings. Secondly, it is held that the clause "any activity not having a direct bearing on passage" only covers conduct that manifests itself externally, which is generally not the case for violations of rights of people on board. Yet it seems rather artificial to distinguish external from internal conduct, since the conduct of the ship is inextricably linked to the conduct of persons on board. For example, a ship engaged in legal or illegal fishing can only do so because there are fishers on board who may be subjected to forced labor, for instance. Third, and this has to be taken very seriously in order not to go against the grain of the innocent passage regime, the listed activities have to reach a certain level of gravity. This not only follows from the very idea of balancing flag and coastal state rights, but also from the chapeau of Article 19.2 UNCLOS, which states that the listed activities are deemed to be prejudicial to the peace, good order, and security of the coastal state. When Natalie Klein recently wrote, and I quote, that committing human rights violations would not typically constitute actions that are directly connected to passage, end of quote, this is true, but a contextual reading of the clause suggests that only violations of rights reaching a certain threshold render passage non-innocent. Let me explore this threshold question in the context of the second possible avenue to integrate rights considerations into the meaning of innocent passage, which is the first sentence of Article 19.1. The first sentence of Article 91 UNCLOS stipulates, I quote, "Passage is innocent so long as it is not prejudicial to the peace, good order, or security of the coastal state." Several aspects of these provisions are controversially discussed. Among these is the question of whether the coastal state has a residual authority to determine that a ship is non-innocent on the basis of this sentence alone, without the ship engaging in any of the listed activities in Article 19.2. For the purposes of this presentation, it is assumed that Article 91 UNCLOS have a self-standing meaning. It is therefore necessary in a next step to determine what the terms peace, good order, and security cover. As these terms are very broad, it's easier to define them negatively, to state what they do not cover, rather than defining them positively. In this way, it has been argued in doctrine that so-called passive factors do not amount to acts prejudicial to peace, good order, and security. So what about violations of rights by omission? Can they never qualify as activities rendering passage non-innocent? Considering the passive factors usually mentioned, such as the cargo on board or the state of the ship, it seems that they all refer to conditions and circumstances that do not amount to conduct. In light of this, it seems that violations of rights by omission are not passive factors, since omissions are next to actions a form of conduct. It has further been held that the coastal state can only invoke the protection of its own interest in the context of innocent passage, but not those of other states or of the international community. This argument can arguably be discarded if the obligation violated amounts to an erga omnes obligation. In the Barcelona Traction case, the International Court of Justice held that some obligations of international law arise, I quote, towards the international community as a whole, that by their very nature are the concerns of all states, and, quote, in view of the importance of the rights involved, all states can be held to have a legal interest in their protection, their obligation erga omnes. Interesting for present purposes is that the ICJ considered, quote, the principles and rules concerning the basic rights of human persons, including protection from slavery, as erga omnes obligations, with the consequence that the protection of coastal state interest and interest of the international community merge. The erga omnes nature of an obligation may help us discarding the argument that protection of community interests should not be taken into account when assessing whether passage is non-innocent. But we still need to positively define the threshold of a rights violation that is prejudicial to the peace or good order of the coastal state. Indeed, the spectrum of violations of rights is immense in terms of gravity and seriousness. Compare the situation of a seafarer who is denied medical treatment for a flu with the situation where a miner is lured on board a fishing vessel, forced to work, drugged to keep performing despite sleep and food deprivation. What kind of violation of rights is such as to consider the passage of a ship non-innocent? Arguably, the jus cogens nature of the obligation could provide for a benchmark. The circle of peremptory norms is not clearly delineated, but the International Law Commission in its draft conclusions of 2022 provides a non-exhaustive list of norms having jus cogens status. Among them are the prohibitions of slavery and torture. I guess all of us have heard of slavery-like conditions on board certain ships. However, it has yet to be determined what slavery means in the contemporary context and whether the reference situations amount to slavery in the technical sense of the term. For torture, it would have to be determined what the positive obligations of states are in this respect and whether they are part of the jus cogens core of the right. But should really the type of right violated be decisive, or should rather count how serious, protracted, and/or systematic a violation is? Does it matter if the violation of the right of a person amounts to a serious crime, because this may have security implications and not only pertain to the good order of the coastal state? Without digging any deeper here, allow me to discuss the third avenue which may allow to consider violations of rights in the assessment of whether passage is non-innocent, which is the second sentence of Article 19.1. This provision states that such passage shall be in accordance with the provisions of this convention and other rules of international law. The meaning of the reference to other rules of international law is controversially discussed. Some argue that this merely requires that other rules of international law, in our case international human rights law, be taken into account in the interpretation of the concept of non-innocence. Such systemic integration creates some space for taking into account norms protecting people at sea when striking the fine balance between coastal and flag state interests. It is essentially what my analysis has done so far. Others have a much more liberal interpretation of the second sentence. According to them, innocence is defined in UNCLOS. As defined in UNCLOS is not the only criterion to consider whether passage is non-innocent, but that other rules of international law may also control the right of passage. They point to the wording of the provision, which state that passage shall be in accordance with this convention and other rules of international law. This creates for much more room to bring international law protecting people at sea into play when assessing innocence, rather than only interpreting innocence in light of international human rights law. Innocence would be measured against the standards of this external body of law. In sum, Article 19 UNCLOS offers at least 3 hooks where considerations relating to the protection of persons on board foreign flagged vessels could potentially come in. However, whether we accept that the protection of people at sea is a factor to be considered in the assessment of innocence very much depends on how we generally read Article 19, which we have seen is read in very different ways. Even if we agree in principle that considerations relating to the protection of people at sea should come to bear, the unsolved question is which violations render passage non-innocent, a decision that we should not be taken too lightly in light of the delicate balance to be maintained between coastal and flag state interests. For the sake of argument, let us assume for the second part of this presentation that exceptionally grave violations of rights of people on board a foreign flagged ship render its passage non-innocent. In such a case, the coastal state regains full prescriptive and enforcement jurisdiction over that ship. Well, jurisdiction under the law of the sea is permissive, it's not prescriptive. This means that the coastal state is authorized to exercise it, but not obliged to do so. In other words, a coastal state may exercise its jurisdiction over a ship engaged in non-innocent passage. However, it may also choose to merely expel the ship from its territorial waters or even to tolerate the non-innocent passage. Indeed, Article 25 UNCLOS states, and I quote, "The coastal state may take the necessary steps in its territorial sea to prevent passage which is not innocent." The word may indicates that it may choose not to take any action at all. If it decides to take action, the somewhat ambiguous words "prevent passage" in Article 25 are read by the majority of commentators as giving the coastal state 2 options: to exercise jurisdiction over the ship, meaning to subject the ship to its laws and procedure, or to simply expel the ship from its territorial waters. Concerns have been expressed that if the coastal state decides not to take any action at all or simply expels the ship, that the violation of the rights of people on board and the related crimes will become someone else's problem or potentially no one's problem at all. In other words, that an impunity gap may be created. In light of this, commentators have recently put the argument forward that other rules of international law may, in certain situations, oblige the coastal state to exercise its jurisdiction over the non-innocent ship. I will therefore explore in a next step whether international human rights law and or transnational criminal law have the potential to transform the authorization to exercise jurisdiction under the law of the sea into an obligation to exercise jurisdiction. I start with international human rights law, and let me be very clear, international human rights law does not affect the allocation of jurisdiction at sea. The allocation of jurisdiction is a matter for the law of the sea. However, where a state actually has jurisdiction under the law of the sea, international human rights law may oblige the coastal state to exercise it. This has to do with the obligatory nature of human rights, which imposes duties upon states requiring specific conduct in specific situations. As Irini Papanikolapoulou has put it, and I quote, "In several cases, duties under human rights law actually oblige states to engage in activities that otherwise would be only discretionary, according to the law of the sea provision." And she goes on to state, whenever a state has the right to exercise a power under the law of the sea provision, and that power is instrumental to the protection of the rights of a person, then that state is under an obligation to take such action. This would follow from a joint reading of the law of the sea and human rights law. This raises the question of whether, under international human rights law, the coastal state has a duty to act when a violation of rights occurs on board a foreign-flagged vessel in its territorial waters that renders the passage non-innocent. This requires a two-step analysis. The first step is to determine whether international human rights is applicable at all to the situation at hand. A state does not owe human rights obligation to all persons, but only to those with whom it entertains a relation of duty. This accrues from Article 1, European Convention of Human Rights, or Article 2.1, ICCPR. Such a relation of duty exists in particular if a state has de jure jurisdiction over a person, for example, by virtue of the law of the sea. Since a coastal state has full de jure jurisdiction over a ship engaged in non-innocent passage, the applicability of its human rights obligation are triggered. However, it is not sufficient that human rights are applicable to the situation at hand. Rather, a substantive obligation of the coastal state to act in a particular case, a duty to act, must be identified. This is not readily apparent in our case, as the violation of rights on board is committed by private actors on board a private ship. Let us therefore take a step back and consider different roles a state has in protecting people. First, the coastal state may be the direct source of a human rights violation when it takes action at sea using its state vessels. Law enforcement is a classic situation where a coastal state may be the violator of human rights, for example, through the use of excessive force. These negative obligations have received increasing attention in recent years, but are not relevant in present case. Second, and this is a less explored role, states are also guarantors of rights of people at sea. The positive obligations under human rights law require the coastal state to take measures to protect people to whom it owes human rights obligations, including from harm caused by private actors such as masters, ship owners, or ship operators. The Committee on Economic, Social and Cultural Rights stated that the duty to protect requires states to take various types of measures to ensure that private business actors do not cause violations of economic, social and cultural rights, and the Human Rights Committee held the same for civil and political rights. The Committee Against Torture wrote in its General Comment number 2 that states engage their human rights responsibility if they, I quote, know or have reasonable grounds to believe that acts of torture or ill treatment are being committed by non-state actors or private actors, and they fail to exercise due diligence to prevent, investigate, prosecute and punish such non-state officials or private actors. From this quote, it becomes evident that the duty to protect, which is part of most substantive human rights obligations, is a due diligence obligation and thus an obligation of conduct and not result. Coastal states are thus not under an obligation to achieve a certain result, but are legally obliged to employ adequate means to exercise possible efforts. There is also no predefined list of measures that a state must take to fulfill its due diligence obligations. Nevertheless, judicial and quasi-judicial bodies have identified a number of measures that are relevant in assessing compliance. Key for present context are the obligations to enact and actually enforce domestic legislation, particularly criminal law that prevents private actors from engaging in conduct that violates the rights and values protected by human rights law. In sum, under international human rights law, the coastal state owes obligation to people on board a non-innocent ship because the ship falls under its de jure jurisdiction. Under the positive obligation of various human rights, such as the right to life or the prohibition of torture, the coastal state has a duty to protect these people from harm caused by private actors. This due diligence obligation requires the taking of appropriate or adequate measures, which generally include the enactment and enforcement of laws preventing the harm in question. Let me return to Article 25 UNCLOS. We have seen that this provision authorizes the coastal state to exercise its jurisdiction, that is, to subject the non-innocent ship to its laws and procedures. But it does not oblige the coastal state to do so. The coastal state may also do nothing or merely expel the ship. By contrast, international human rights law obliges the coastal state to exercise its prescriptive and enforcement jurisdiction. In light of this, some commentators argue that the international human rights law transforms the right to act granted by the law of the sea into a duty to act, implying in our case that the coastal state must be subject the non-innocent ship to its laws and procedures. The same argument has recently been made by Antonios Tsanakopoulos in relation to transnational criminal law. Transnational criminal law is key for the protection of people at sea, since violations of rights on board ships often result from or are closely linked to the commission of transnational crimes. The main legal instruments to prevent and repress transnational crimes are suppression conventions, such as the UN Convention Against Transnational Organized Crime, or the Trafficking in Persons Protocol. Typically, suppression conventions require state parties to criminalize the offenses defined in the treaty under their domestic law, that is, to exercise their prescriptive jurisdiction. In addition, they generally contain an obligation to either extradite or prosecute suspects found on the territory of the state party, and thus exercising its enforcement jurisdiction. In addition, some of these treaties oblige state parties to respect and protect persons who are victims of these offenses, such as victims of trafficking in persons. The argument is then very similar to that made in the context of international human rights law. Transnational criminal law treaties do not confer a coastal state with jurisdiction over foreign flagged ships. However, if the law of the sea allocates jurisdiction to the coastal state, they come to bear, since they oblige the coastal state to exercise its prescriptive jurisdiction by criminalizing certain conduct, and to exercise its enforcement jurisdiction by either prosecuting or extraditing the suspect. The coastal state is thus obliged to subject the non-innocent ship to its law and proceedings. Let me conclude. The theme of this conference is 30 years of UNCLOS, then, now, and the future. Since the entry into force of UNCLOS 3 decades ago, international law has evolved. New treaties have been adopted, and existing law, which has traditionally been considered from a land perspective, started being perceived in a maritime context. This is true of international human rights law, but also of transnational criminal law. Not only has the law evolved, but so has our interpretation of it, with the legalization and judicialization of world politics after the end of the Cold War, reflected in the adoption of new multilateral treaties and the creation of various international courts and tribunals. There has been a growing awareness of a certain risk of fragmentation of international law. Systemic integration was identified as one of the main strategies for achieving a degree of harmony between different legal regimes. Most recently, in its advisory opinion on climate change, the UNCLOS stressed that systemic integration is a tool to avoid fragmentation. It held the tribunal is of the view that subject to Article 293 of the Convention, the provisions of the Convention and external rules should, as far as possible, be interpreted in a consistent manner. A combined reading of the innocent passage regime of UNCLOS with the coastal state's obligation under international human rights law and transnational criminal law, the relevance of which for the maritime context is today much higher than in '94, not only prevents fragmentation and conflict, but also contributes potentially to strengthening the protection of people at sea. But there is still a long way to go. Writing this paper felt like building a house of cards. None of the elements are stable. The innocent passage regime is fraught with interpretative challenges. Human rights at sea is still a concept in the process of consolidation, and transnational criminal law has rarely been considered in its interaction with the law of the sea and transnational and the protection of people at sea. But even a house of cards, if built with the necessary caution, care and time, could ultimately stand. Thank you very much for your attention.
Thank you very much, Professor Petty. Many thoughts, yes, to encourage the discussion. And now we have the pleasure to introduce Mr. Calbrecht, who will be the first discussant of this panel. The time is yours.
Kia ora koutou e ngā rangatira. Good morning, distinguished guests. Firstly, let me start by thanking our gracious hosts for organising this conference. I must especially thank my friends and colleagues in the International Legal Affairs Bureau of the Ministry of Foreign Affairs for their leadership both in organising this conference but also on law of the sea issues generally, so thank you for hosting us. Please allow me also to thank and acknowledge our extraordinary panel today, particularly our esteemed moderator, Judge Infante Caffey, our two extraordinary speakers and my fellow discussant. I'm humbled to be part of such an august panel. So, at the outset, it might be useful for me to talk a little about New Zealand's approach to the UN Convention on the Law of the Sea. The starting point for all of us, I'm sure, is that the Convention is and has been for more than 40 years a mainstay of international law. As Vice Minister Kang indicated this morning, the Convention is perhaps the most important multilateral treaty we've seen over the last century, with the exception of the Charter itself. New Zealand remains deeply committed to upholding the Convention's position as the definitive legal framework from which all activities in the oceans and seas must be carried out. And like many other states, we regard the Convention as being the constitution for the oceans. And so as we commemorate the 30th anniversary of the entry into force of the Convention, we see its negotiation as a historic achievement and a shining light for multilateralism. And I'd like to respectfully endorse your comments, Judge Haidar, earlier this morning about the status of the Convention. While the Convention is still young in relative terms, it is difficult to imagine now a world without it. It protects and empowers us. It preserves a balance of rights and responsibilities, about which more in a moment, and it provides the legal framework under which all activities in the ocean and on the seas must be carried out. And so that is also why this conference is so important. It allows us to reinforce our collective understanding of the universal and unified nature of the Convention. And in that way, the conference contributes to the strengthening of international law. I'll conclude by noting I've put my favourite map on the slide there. There are so many maps, including, unfortunately, Professor Davenport, one of yours this morning, that omits New Zealand. So I like to choose one that really only has New Zealand on it and the blue Pacific continent. So the question of sovereignty or jurisdiction in maritime zones is an important and topical one. Perhaps the foundational question is, where do those zones begin? How might those zones change in the future? For New Zealand's part, we're committed to ensuring the preservation of maritime zones in the face of climate change-related sea level rise. Our view, and it's not ours alone, is that states can maintain their maritime zones as notified under the Convention to the Secretary-General, and the rights and entitlements attached to those zones, notwithstanding any physical changes connected to climate change-related sea level rise. This is an important issue for many states, including many Pacific Island countries. The picture on the slide indicates or gives you an idea of the issue. It is a view of one of the atolls of Tokelau, which is a non-self-governing territory of New Zealand in the Pacific. And you can see for the New Zealand citizens living on those atolls, along with many thousands of other Pacific Island citizens, that the question of sea level rise is indeed an existential one, not merely a legal one. So therefore, New Zealand was pleased to play a part, along with the leaders of many other Pacific Island countries, back in 2021, when Pacific Island Forum leaders made a declaration on preserving maritime zones in the face of climate change-related sea level rise. We also very warmly welcomed the meeting on this issue at the General Assembly back in September, and we're pleased that the international community has founded this program of work on an ongoing basis. And of course, we were pleased to participate with so many other countries in the advisory opinion in UNCLOS. So I turn now to the topic of this session, jurisdiction in the territorial sea. Perhaps the obvious point for me to make is that the relative importance of the territorial sea and other maritime boundaries depends on your geography. And you can see from the slide that New Zealand has very few issues arising from our territorial sea. Our neighbours are a long way away, and they're friendly, if you include Antarctica as being friendly, but let's say for the sake of argument that it is. So our focus is primarily on our exclusive economic zone and the extended continental shelf. And of course, we're strong supporters of the Agreement on Biodiversity Beyond National Jurisdiction, and we look forward to it entering into force as soon as practicable. And you can see from this slide the importance of maritime zones and boundaries to Pacific Island countries. So maritime boundaries, the rights and responsibilities of maritime zones are extremely relevant and extremely important to the Pacific region. So let me turn to the excellent presentations that we've had this morning, and I'm grateful to our two illustrious speakers and Madam Moderator for their insightful remarks. I approach my remarks from the perspective of someone in the South Pacific and from the perspective of a Foreign Ministry legal advisor. Professor Davenport's presentation brilliantly conceptualises notions of coastal state sovereignty over the territorial sea. The presentation contemplates a reconceptualisation of the territorial sea as a space of shared rights and responsibilities. Perhaps how one approaches that notion of reconceptualisation, again, depends on one's geography and on one's role. Whether one supports the idea of shared rights and responsibilities depends perhaps on what one has to gain or lose from them. I would say, as a Foreign Ministry legal advisor, in a Pacific country that does not have near neighbours, I personally am very much on the despotic and absolutist end of that spectrum. We view the territorial sea as being under our sovereignty, subject only to specific limitations agreed to in international law. There are, of course, competing interests in the territorial sea, including freedom of navigation, and Professor Davenport helpfully set out the important jurisprudence of UNCLOS courts and tribunals on possible limits of coastal state sovereignty. Professor Petrick's outstanding presentation raises important issues about coastal state jurisdiction in the territorial sea, international human rights law, and the application of transnational criminal law. The focus on these issues and how they relate to innocent passage is very welcome. I would add, in the case of both of the examples that we heard about, including submarine cables and the application of international human rights law to vessels, foreign flagged vessels in the territorial sea, as being relevant and topical issues. I would add, though, that as a Foreign Ministry legal advisor, the legal position is only one of the considerations, of course, that a government would be looking at very closely when determining what to do. And we've seen from headlines this morning in respect of the Baltic Sea how timely and important these issues can be. Professor Petrick notes that there is still uncertainty about a number of these issues, and there's a need for further work and study. We also note the very important work that is being undertaken on some of these issues by the International Maritime Organisation. Like very many other countries, New Zealand has enacted legislation to set out clearly what maritime powers our agencies may exercise in the territorial sea. Our Maritime Powers Law, enacted in 2022, was designed to expressly comply with our international law obligations while at the same time securing our maritime environment against threats such as drug trafficking, wildlife trafficking, and human trafficking. More broadly, and again, just to repeat the record, as a government legal advisor, I would be very cautious about developments outside multilateral processes or outside the processes of international courts and tribunals. The reason, obviously perhaps, for that caution is to avoid in any way diminishing the coherence, status, and primacy of the Convention. So if you'll allow me, I'll conclude where I started by saying that the UN Convention on the Law of the Sea reflects a carefully negotiated balance of rights and obligations that serves all of our interests. New Zealand will continue to promote and defend the status of the Convention as the primary international treaty governing ocean activities. So please allow me to conclude by again thanking our gracious hosts and my esteemed fellow panelists. Thank you very much.
Thank you very much, Ambassador Rich. And now I invite Dr. Kim to conclude with the discussion of this panel.
Thank you, Madam Chair. I'd like to express my sincere gratitude to the organizers, Ministry of Foreign Affairs, International Tribunal for the Law of the Sea, and Korean Society of International Law. It is such an honor and great pleasure for me to be part of this very meaningful gathering for commemorating the 30th anniversary of the entry into force of the United Nations Convention on the Law of the Sea. I'm also really enjoying and learned a lot from two speakers. They spoke about the coastal state jurisdiction of the territorial sea, but one speaker, Tara, mentioned that the development of the convention, the UNCLOS, can restrict the coastal state jurisdiction of the territorial sea. On the other hand, Professor Anna Petrick, argued that the coastal state jurisdiction and coastal states' power to regulate activities in the territorial sea could be transformed into the obligation to protect of the human rights in the territorial sea. So I found it very interesting to presentation. So I'd like to ask some question and give some comments. And just for your information, I don't want to be a bad guy to destroy your house of cards, but I will be very faithful to my role as a discussant. Before beginning my discussion, I'd like to quote my favorite writer, Philip C. Jessop. he wrote a book about the law of territorial waters and maritime jurisdiction. It was published in 1927. So I quote, "If sovereignty is an absolute thing, any restriction upon it is its own negation. But such a concept is not in accord with the facts of present international life. International law itself is a restriction upon and a denial of absolute sovereignty. Most treaties, though freely entered into by an exercise of sovereign will, thereafter constitute a limitation upon sovereignty." End of quote. So even in 1927, it's only the Pilistich Jessup mentioned that some possible limitation of the coastal state sovereignty of the power in the territorial sea. And our discussion today, I think that our discussion in this session is focusing on the interpretation of Article 2, Paragraph 3 of the Convention. That means the sovereignty of the territorial sea of the coastal state is exercised subject to their sovereignty, subject to the Convention and other rules of international law. So both speakers mentioned that what is the other rules of international law. So in my opinion, I think that we should be some cautious to identify which will be the other rules of international law. So my first question goes to Tara. So Tara explained and so gave us some examples of the three cases, the Chagos MPA arbitration and South China Sea arbitration and Dujit integrity arbitration. But it seems to me that the three cases are very fact-intensive cases, and they have very unique factual backgrounds. So, for example, Chagos MPA of arbitration, the legal basis of the tribunal to recognize the limitation of the exercise of territorial, the UK's power over the territorial sea was the UK's commitment to return the Chagos Archipelago arising out of the Lancaster House undertakings. So the basic legal ground for the tribunal to render to limit the exercise of the power of the coastal state was not the other rules of international law, but from the UK's commitment. So the South China Sea applies the same. The traditional fishing activities done by the Filipino and Chinese fishermen was the legal ground for the tribunal to render the limitation of the exercise of territorial sea. So my question is whether it is appropriate to draw some limitation. Is it appropriate to draw some generalization to limit the sovereignty over the territorial sea from those cases? Is my first question. And second question to Tara is that is there any existence? Is there any existence of general rules regulating the laying and repairing marine cables in the territorial sea? So there have been developed the 1884 Convention on the International Marine Cables. So there are separate legal regime regulating the submarine cables. So if we argue that the sovereignty over the territorial sea could be limited in the territorial sea, then we should look for any evidence that there exists a general rules of international law to limit the sovereignty over the territorial sea. So the next question goes to the Professor Anna Patrick. So I really appreciate your meticulous analysis on the relevant rules and external rules relating to protection of the human rights. And I got some impression that there have been many scholars, especially Irini, pointed out that most lacking regulation under the convention was the protection of person at sea. So it's still, I'm sorry that even we are commemorating the 30 years of the entry into force of the convention, we are still suffering the same problems. So I really appreciate Professor Anna Patrick's attempt to theorize to oblige the coastal state to exercise jurisdiction of the territorial sea to protect the human rights. However, there are some suspicion and there are some doubts over your argumentation. So my first question is about the general rules of treaty interpretation. So you try to interpret Article 25 of the Convention that there exist other rules of international law may control the right of passage. But when we recall the general rules of interpretation of the treaties under the Vienna Convention on the Law of the Treaties, Article 31 and 32, do you think is it consistent with the general rules of treaty interpretation under the Article 31 and 32? Because it seems to me that the only ordinary meaning has no relevance to the protection of the human rights in the convention, and also context and object and purpose of the convention was not envisaged for protection of the person at sea in the territorial sea. So in this case also there are some separate legal regime developed to protect the person at sea, like a Convention on Maritime Labors and other relevant IMO's conventions. So my question is that whether your interpretation of Article 25 is consistent with the general rules of treaty interpretation. My second question is about the terminology of the jurisdiction used in the Convention on the Law of the Sea and used in the international human rights treaties. For example, the Article 1 of the European Convention on the Human Rights, I quote, "The high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in Section 1 of this convention." So the same, almost similar provision was provided in Article 2 of the International Covenant on the Civil and Political Rights. So I quote, "Each state party to the present covenant undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction." So it seems to me that the international human rights law imposed the obligation of the state party to protect the human rights of the everyone within their jurisdiction. So that means that article is relevant for the scope of application. It is not relating to the exercise of the coastal state jurisdiction over territorial sea. So whether, I have some question whether there is any confusion of using the terminology of the jurisdiction of the coastal state over territorial sea and the protection of the people within their jurisdiction under the human rights treaties. And my last question is about the external rules. You mentioned that the UNCLOS advisory opinion on climate change and international law, it is quite a historical judgment, historical advisory opinion to clarify the meaning of the marine pollution relating to the emission of the CO2 and relating to climate change. But the UNCLOS has clearly declared that the convention and external rules should be interpreted consistently, and also the external rule should clarify the meaning of the convention. It's not the incorporating the external rules into the convention system, because the UN Convention on the Law of the Sea has adopted a compulsory mechanism of the dispute settlement. So I think that is the most important part of the convention, and many contribution of the peaceful settlement of the maritime dispute. But if we are extending to incorporating external rules like the human rights treaty obligation into the Convention on the Law of the Sea, so is there any possibility to expand, too much expand the scope of the convention. So I totally agree with that. The convention is a living instrument, and openness and generally accepted international rule and regulation could be referred. But we should be careful about that the external rules should have to clarify the meaning of the convention, not to expand the legal obligation under the convention. I have 2 minutes more, but yeah, that's my question. Thank you very much. Thank you.
Thank you very much, Dr. Kim. I think our speakers have had enough questions to answer. And unless you would like to raise another point, I will invite you to address these questions.
Thank you very much for the very useful comments. Just to emphasize one more time, it was a thought experiment, and I guess this analogy of a house of cards fits very well. And it's interesting to see that Tara's presentation and my presentation went in opposite directions. You taking something away from the coastal state, where I rather made an argument on how to expand coastal state jurisdiction. But still, I guess we agreed on several points, such as there is much uncertainty about the extension of jurisdictions of the coastal states. Also, this idea that it's an area of shared rights and obligations, the constant need of balancing, plus what you said, sovereignty comes with responsibility. I guess prima facie we do not quite align, but if we look a little closer, I guess our claim is very different. Then I very much agree that with what Mr. Reich said, that the position may very much depend on or how you look at things, about your geography and other interests, and there is a political dimension. What I did was a very sterile exercise, a purely legal exercise to test the limits. Of course, then you have to hold that against the background of politics and other interests. And I very much agree that we need a cautious approach, that developments should take place in a multilateral setting. Courts and tribunals should develop the law in this respect, and there are now several interesting developments going on in the area of the protection of people at sea, which could maybe ultimately lead also to a multilateral process. Then I'm very grateful for all the questions posed by Kim. So the general rules of treaty interpretation, I guess we have to distinguish Article 19 from Article 25, because Article 19 has an explicit reference to other rules of international law. So at least some see this as the possibility to really integrate other rules of international law into the innocent passage regime. I do not necessarily agree with this very liberal interpretation. I have mentioned there are 2 readings of what this means, whether it's just this reference to other rules of international law are just an invitation to consider the rules of the UNCLOS in light of external law, or whether external rules really control the passage regime. And so in Article 19, since there is this explicit reference to other rules of international law, this could go beyond systemic integration. But I guess a more narrow reading prevails if I look at the literature, and there it would just be systemic integration, meaning you consider the rules in light of external law. And then, of course, there is the wording, but the wording is not very helpful. What does good order means, or any activity not bearing on passage? So. But I have also emphasized the context. It's clear that a certain threshold of gravity must be there in order not to disturb the overall balance between coastal state rights and flag state rights. So I very much favor an interpretation which takes into account all types of interpretation rules, but I guess systemic integration is a method of interpretation which is increasingly important. Then yes, the terminology on jurisdiction, that's a very vexing thing that both in human rights law, in the scope of application provisions, jurisdiction is used, but jurisdiction is also used in general international law and law of the sea, and they do not mean the same. I tried to avoid the notion of jurisdiction in my talk. I referred to relation of duty, and actually jurisdiction in the human rights clauses mean to whom do you owe an obligation, and you owe to them, to all persons under your jurisdiction, which can mean under your de jure jurisdiction, under international law, or de jure jurisdiction under the law of the sea, or even de facto jurisdiction if you have no entitlement to act, but for instance you arrest someone at sea. So jurisdiction in the sense of human rights clauses can mean jurisdiction de jure and jurisdiction de facto, and so you have three terms which sound similar but which are very different. And my argument is not that human rights jurisdiction should control the jurisdiction at sea, but if you have jurisdiction under the law of the sea, that may determine to whom you owe the human rights obligations, because the scope of application provisions of human rights treaties refer to de jure jurisdiction. So it's linked but different, and it's a very complex problem, and there is an ILA committee which has been recently established which will study just this notion of jurisdiction for the next 4 years, which testifies to the complexity of these notions. Then again, external rules, whether they should just be taken into account or whether they could also expand the obligations under the law of the sea, that again very much depends on how you read this clause, and it could mean just systemic integration or it could mean more. If you look at all the case law, it's very contradictory, but it seems that recently there is a trend towards a more restrictive understanding that it's just systemic integration. But even then you have somehow to take into account human rights law, and the nature of human rights law and transnational criminal law is very different. It has this obligatory character, so how do you deal with this in a law of the sea regime which is more permissive? And I guess this balance has to be struck in the future, and as mentioned, we are at the very beginning of this development, and my presentation was not at all a Lex Lata presentation, but really like a thought experiment and an invitation to reflect upon these complex interactions. Thank you very much.
Yes, Professor Davenport, would you like to?
I do apologize as well for losing my voice in the middle of my presentation. I'm sure it did not sound very pleasant. Again, I'm losing my voice. Thank you very much for the very thoughtful comments by Mr. Reach and Dr. Kim. I think I will again borrow from Anna to say that it was a thought experiment, really trying to interrogate the nature of coastal state sovereignty and the limits to it, which I think in the Law of the Sea Convention, with the exception of the innocent passage rules, there's still considerable uncertainty. And I think also in relation to this idea of competing conceptions of sovereignty, sort of as a normative basis for understanding the limits to coastal state sovereignty. I think I was very interested in this idea of, which is why I emphasize this, the property theories that actually gave rise or, developed into sovereignty theories. So this idea that we have, Blackstone, I teach land law in Singapore, so everything is infused with some sort of property. But this idea that our conception of property is sort of sole and despotic dominion, this idea of complete control, the right to do what we want, in this case within the territorial sea. And I was interested in, I guess, alternative conceptions of sovereignty and this idea that, which I think the case law has slowly or alluded to without maybe explicitly doing, that there are limits to coastal state sovereignty. I think I completely agree that it really depends. I think most coastal states would very much take the position that the territorial sea is part of their territory. It is their sole and despotic dominion. And I think that's it is a very realist and natural position that coastal states will take. Coming back to what Dr. Kim said, and I think I did not, and his questions actually made me think about what I did not say, which is that there are both substantive restraints on coastal state sovereignty. For example, through I would say the obligation not to harm. You can't use the territorial sea in a way that will harm other states. But I think what both the Chagos Marine Protected Area Arbitration and the Dusgit arbitration was alluding to was this idea that, well, I don't like to call it procedural obligations, but the way that coastal states exercise their jurisdiction are subject to certain restraints, whether it be good faith, whether it be proportionality, right? That it has to be something that is exercised in a proportional manner that, protects your interests in sovereignty, but does not excessively impact other states' rights. So I think these are and he's absolutely right to say that you can't draw sort of, general conclusions because they are very fact intensive. But I think what these arbitral cases, I guess, are building towards is that there are limits on coastal state sovereignty, at least the way that they exercise their jurisdiction. There are no existing rules under rules of international law in relation to submarine cables and pipelines. But I think what I was very interested in is this idea that in the EEZ and in the high seas, freedom of navigation has been recognized, freedom to lay submarine cables and pipelines. Both of these are sort of part of the general idea of freedom of transit, freedom of communications. Navigational rights were protected in the territorial sea, but there was no equivalent protection given to the right to lay submarine cables, even though they're also essential to this idea, a general idea of freedom of communications, and so forth. So I think that was something I was very interested to explore further. Again, it was a thought experiment. I think it would be very hard to argue or to challenge this idea that the coastal state can do what it likes within its territorial sea and can regulate. But I think it is an interesting way to sort of interrogate the nature of coastal state sovereignty, and maybe we also need to reconceptualize it as I had said earlier, this idea of shared rights and responsibilities.
Thank you very much. I would like to conclude this. We're going to conclude this panel with a very thoughtful, yes, and heartfelt thank you to all of you. You have provided insights in order to counter these uncertainties. I think there are more certainties than uncertainties in what you said, and thank you very much for your presentations and discussions.
Thank you. Once again, please. Thank you very much, Judge Infante Kafi, and also my gratitude to all of our panelists for the discussion. So please, once again, applaud for our moderator and our panelists, please. Ladies and gentlemen, thank you for your active participation. This concludes session number 1, and we will have a lunch break before the next session begins. Please enjoy your lunch, and we'll resume at 2 p.m. Korea time. Thank you. Ladies and gentlemen, welcome back. I hope you enjoyed the meal. Now we'll commence our second session titled The Legal Regime of the EEZ under UNCLOS. Before we invite our panelists here up on the stage, we'd like to inform you about the translation service available today. Please use our receivers on your tables and select channel 1 for English, channel 2 for Korean. And now it is time to welcome our panelists for session number 2. This session will be moderated by His Excellency Osman K. Kamara, Judge of the International Tribunal for the Law of the Sea. Judge Kamara, the floor is yours.
Thank you, program host, for the kind words about me. Allow me to express my gratitude to the Ministry of Foreign Affairs of the Republic of Korea and the Secretariat of the ICLS for the excellent hospitality they've accorded to all participants. Distinguished experts, esteemed participants, ladies and gentlemen, I welcome you to this significant discussion on the exclusive executive zone under the United Nations Convention on the Law of the Sea. I'm privileged to moderate this session, a session designed to explore the complexities and emerging issues surrounding the EEZ, a crucial aspect of maritime law. Briefly, the EEZ is a maritime zone where coastal states have sovereign rights over the exploration and use of marine resources, including fishing, energy production, and transportation. As we delve into this topic, let us consider the multifaceted nature of the EEZ, encompassing resource management, environmental protection, and international cooperation. Our esteemed panelists will share insights on the legal regime governing the EEZ, shedding light on its applications and challenges. Throughout this session, I encourage active participation, thought-provoking questions, and insightful discussions. Let us strive to enhance our understanding of the EEZ and its implications for global maritime governance. 4 distinguished experts will lead the discussion, 2 speakers and 2 discussants. Thereafter, I'll open the floor for questions, because we experienced that during the first panel, we didn't engage our participants. This time around, we intend to give them at least 25 minutes each, so that we'll encourage our participants to also participate. So now, let me start with the speakers now. Our first speaker is Professor Geraldine Girardot of the University of Paris-Saclay. Geraldine Girardot is a full professor of public international law of the University of Paris-Saclay. She holds a PhD from 2 universities, Paris and Panthéon-Sorbonne and Carlos III University of Madrid. Her research has been mainly focusing on territorial seas, law of the sea, international migration, and international relations. She is currently conducting research on different legal questions specific to the Asian-Pacific region, including impact of climate change on maritime zones and governance of the deep sea. She also served as an assessor judge appointed by the UN High Commission to the National Court of Asylum from 2012 to 2016. She is currently Joint Director for Studies of the French branch of the International Law Association, co-director of the Asian Pacific section for the Annuaire Français de la Relation Internationale, and member of the International Law Association Research Group on Cables and Pipelines. Let me do it this way. I will now give the floor to Professor Geraldine to make her presentation. Thereafter, I'll read the bios of others, and then they also make their presentation accordingly. You have the floor now.
Distinguished guests, 안녕하세요. I would like to warmly thank the organizers for this beautiful event and this honorific invitation. I'm really delighted to be here. I've been asked to provide a general presentation on EEZ legal regime, and I have to say that talking about past, present, and future of the EEZ is quite of a program. So I will try today to draw a general panorama and to pinpoint some aspects that hopefully will be the object of further discussions and questions. I'll start with a teasing. EEZ legal regime is not perfect. But is there any legal regime which is so? It's a unique and ambitious normative framework with some limits, which withstood quite fairly the test of time, which is now confronted to important challenges which can be overcome both by political will and evolution, thanks to the flexibility of law, and thanks also to the very important task of the international judges. Let's start with some general considerations. Along with the international seabed area and the common heritage of mankind, the EEZ is indeed the major innovation of the third conference of the law of the sea. As a maritime zone extended up to 200 nautical miles offshore from the baselines, where a state retains exclusive rights to the exploration and exploitation of natural resources, it is an emblematic symbol of states' growing control on oceans, designed to balance the freedoms of the high seas with the economic interests of the coastal states. It owes much of its origin to the energetic efforts of developing states. Emerging from nothing, the EEZ was adopted within the space of a few years by the vast majority of states. In 1996, 2 years after the entry into force of UNCLOS, 90 states had already created an exclusive economic zone. The EEZ has since become a key institution of the law of the sea. And while UNCLOS was, and the EEZ was a major innovation in the form of a compromise that made it possible to reconcile contradictory issues and claims, the questions now arises as to whether its legal regime is sufficient to grasp all the current prospects for the development of the law of the sea. And to try to assess this question, I'll first remind how the EEZ became an essential institution of the law of the sea. I'll underline some specificities of its legal regime, and I'll then focus on some current and maybe future challenges. Since the aftermath of the Second World War, the law of the sea had been fraught with uncertainty. The absence of a legal regime for fishing, apart from traditional one of freedom of fishing on the high seas, gave rise to a variety of practices, including the practice of an extended territorial sea up to 200 nautical miles by certain states from South America. These concerns focused on the exploitation of biological resources, were closely combined with those relating to development to give rise to the concept of a zone for economic purposes under the control of the coastal states, which would avoid at the same time the general extension of territorial seas up to 200 miles. And even before the start of the third conference, plans for the creation of a zone to serve economic development were drawn up into different geographical areas, specifically into the Caribbean Sea, and also at the same time, Kenya proposed the creation of an EEZ, a project that was then transmitted and taken through the Organization of African Unity and transmitted to the Seabed Committee. So the second project, as you know, prevailed, and it was debated and commented during the third conference. It was indeed it arised indeed, sorry, I went a little bit too far, vigorous opposition, especially from the traditional maritime powers. But the determination shown by coastal states and developing states in defense of this notion made it impossible to envisage the project being abandoned. So while continuing to debate certain aspects, the third conference quickly reached a consensus on admitting the institution. And thus, in just a few years, the new EEZ was accepted. The 200 nautical mile zone, which a few years earlier under the heading of an extended territorial sea had seemed exorbitant and unacceptable, was now generally recognized in the form of the EEZ. Over the course of the 1970s, many countries incorporated the institution into their national legislation. Nowadays, as we can obviously observe on a map, waters of the EEZ represent a substantial part of the oceans. Most coastal states, especially former colonial empires, have shown an obvious effort to maximize the effects of UNCLOS, including by creating EEZ around territorial formations whose compatibility with the UNCLOS Article 121 criteria of what an island is appears sometimes unclear. Furthermore, the growing assertion of state rights over the EEZ has contributed in substantially modifying geopolitical relations in recent decades, due to the vastness of the maritime areas now under state jurisdiction. This is particularly true for islands, especially for the Pacific island states. We find in this region the vast majority of the biggest EEZ in the world. The 360 degrees projection of islands and archipelagos on the sea implies an exceptional ratio between land area and EEZ, converting small pieces of land into huge maritime nations. The EEZ also easily found its place in the differentiated compartmentalization of zones established by UNCLOS. In general, its relationship with the other zones is one of simplicity, but of course the relationship with the continental shelf is much more difficult, the very existence of the second one having been threatened by the creation, by the project of creating a unique zone. So although the distinction between the two zones has prevailed, it is not without ambiguous implications, particularly in the establishment of state obligation in environmental matters and in maritime delimitation disputes. I won't be too long on the specificities of the legal regime. It's very specific because it is nor the one of the territorial sea, nor the one of high seas, and tries to reach a delicate balance between coastal states' interests and other states' interests. So regarding first the sovereign rights and jurisdiction of the coastal states, the EEZ is a functional zone in which the coastal state only has powers of attribution which are limited in scope and mainly, but not exclusively, economic in character. Article 56 of the Convention, which sets out the general definition, distinguishes between the exercise of sovereign rights and the exercise of jurisdiction in a number of areas. The coastal state has sovereign rights for the purpose of exploring and exploiting, conserving and managing the natural resources, whether living or non-living, of the waters superjacent to the seabed, as well as with respect to other activities tending to the exploration and exploitation of the area for economic purposes, such as the production of energy from water, currents, and winds. Biological resources were a central concern at the third conference on the law of the sea. They represented the essential and immediate interest of developing countries who wanted to avoid overexploitation of stocks in areas close to their coasts. Even today, The economic aspects are indeed fundamental, since 90% of the fish market comes from EEZ. And despite ever increasing international regulations, fish stocks continue to decline. The consistency of the coastal states' sovereign rights over the living resources of the EEZ is fundamentally based on the right to determine, on one hand, its capacity to exploit the living resources in accordance with Article 62.2 of the Convention, and on the other hand, the admissible volume of catches in accordance with Article 61.1. The terms of Article 62 indicate that the coastal state is bound by the obligation to admit other states to the catch of what remains when it does not itself have the capacity to reach the allowable catch volume. However, the unilateralism implied by the Convention in the management by the coastal states of catches in its EEZ can be counterbalanced by the presence of regional fisheries management organization. Article 56 of the Convention, which sets out the sovereign rights of the coastal states in its EEZ, goes on to set out the areas in which it exercises jurisdiction. This concerns the establishment and use of artificial islands, installations and structures, marine scientific research, and protection and preservation of the marine environment. Very important challenges for this legal regime nowadays. In recent years, the massive construction of artificial islands off the coasts of certain states has raised important questions about the legal status of these installations and their uses, and obviously the protection and preservation of the marine environment, as set out in Article 56, is the third most important area in which coastal states can exercise jurisdiction, and it is currently maybe one of the more striking challenges. The rights and freedoms enjoyed by third states are the freedoms of navigation and overflight, and the freedom to lay submarine pipelines. And on these 3 points, therefore, the legal regime of the EEZ borrows from that of the high seas. The Convention is elliptical on the obligations of other states in the EEZ. Article 58 quite logically obliges third states to respect the laws and regulations adopted in conformity with the provisions of the Convention, and insofar as they are not incompatible with with the part mentioned with other rules of international law. So while the Convention does not provide a lot of clarification on the scope of this obligation, the case law developed until now is very enlightening to that regard. So Article 56 could give the impression of an harmonious balance and equitable sharing by obliging the coastal states and third states to take due account of each other's rights and obligations. But we all know in this room that it's been much more challenging than this. And again, that the role of the international judge is absolutely crucial in that matter. At the time of assessing the current and huge challenges of the EEZ legal regime, two at least approaches could be retained. So I was mentioning here what we could call the normative approach. It means focusing on limits and absence of certain norms, or the material approach, mentioning some of the events, factors, external evolution, which explain the current challenges. So concerning the normative approach, and I'm here quoting Robert Beckman and Tara Davenport, who's here in the room, who identify different types of normative challenges: regulation of express EEZ freedoms in contravention of UNCLOS, deliberate or constructive ambiguity or lack of definitions of key terms, lack of detailed regulations on certain obligations, and development not foreseen by UNCLOS. If we mention the challenges by themselves, not only on the legal regime, but also on the existence of the institution itself and on the implementation of the regime. We can mention climate change, dispute security issues, and so on. I'll say a few words about them. I won't be exhaustive. I don't pretend to be so, but I will just pinpoint some of these current issues. I'll start by delimitation, which is probably not the most important challenge nowadays, but it is a remaining issue, still raising some concerns in some parts of the world. Quite numerous bilateral delimitations have still to be delimited, often because of competing claims. Interstate disputes concerning these delimitations that have not found a diplomatic solution are fueling substantial arbitral and judicial litigation, including recent ones. It is not impossible that new disputes emerge from the competing claims of using the same energy in the EEZ. Challenge of sea level rise and permanence of the EEZ itself. Because sea level rise and its consequences are absent from the convention, a quite recent but absolutely crucial question is around permanence of EEZ and its limits, despite recession of baselines or recession of low watermarks. It is such a crucial issue for small island states. The question also exists around what would become of the EEZ in case of the worst scenario of when a territory would disappear or become uninhabitable. And we have to mention here that those small island states pushed for legal evolutions to the recognition of such permanence. An example is given by the Pacific Island Forum Declaration on Preserving Maritime Zones in the Face of Climate Change-related State Level Rise of August 2021. And more generally speaking, I would like here to underline the very important role of small island states in shaping the future of the law of the sea. Climate change, more generally speaking, is obviously a very striking challenge and threats on environment. We could mention at least two types of threats. A substantive threat to the sea's biological resources, which is overexploitation. Many fish stocks are in dangerous decline, despite an ever-growing body of law aimed at preventing resource depletion. Article 61.2 essentially states that it is the responsibility of the coastal state, taking into account the best scientific evidence available, to take appropriate conservation and management measures to ensure that the maintenance of the living resources in its EEZ is not jeopardized by overexploitation, and to grasp the content of the coastal state's obligations with regard to the conservation, preservation of biological resources. It is therefore necessary to move beyond the general framework of UNCLOS and to take into account numerous other sources of law. Also, the Convention has very important limits, indeed, regarding protection of environment, and that gives rise to fundamental questions for the future. The recent UNCLOS opinion on climate change is of crucial importance to understand states' obligation in this matter, and more generally reminds the fundamental task of the international judge, including through advisory opinions, to allow the EEZ regime to overcome the challenge of time. Today, the protection of the marine environment also raises complex legal issues in the EEZ. It reflects the tension between the coastal states. The first major legal question is the extent to which the general obligation laid down by the Convention and the relevant provision of international and regional legal instruments can impede that freedoms and rights of exploitation recognized to states over these waters. The question of how to reconcile obligations to protect the marine environment in the EEZ with the rights of states, it's likely to become even more sensitive, and we can already observe this in the regulation of marine protected areas. In the same vein, the tightening by certain coastal states of their regulations on maritime traffic in order to avoid pollution, accidents by ships could hinder freedom of navigation in the EEZ. Also, very briefly, we can mention all the current questions around potential exploration and exploitation of seabed before 200 miles and the consequences it could have on the water column. In the context of the energy transition, which is essential to maintaining a stable and viable global climate, the exploitation of renewable marine energies is of obvious interest, as it would make it possible to cover a large proportion of the planet's energy needs, but raises very important issues regarding competing use or hypotheses where the coastal state may also authorize other states to have access to these sources. This hypothesis highlights one of the likely difficulties of exploiting marine energies in EEZ, competing sovereign rights to exploit the same energy source, such as the marine current, could arise between several adjacent or opposing coastal states. I'll also mention security. Security is a very wide challenge regarding the implementation of the regime and the regime itself. It is linked to the huge technical tools required to be able to ensure the implementation of the regime, for example, to fight against illegal fishing. We can also mention the specific case of cables. We know that the international network of submarine cables, and we talked about it this morning, is the object of a legal regime too elliptical that needs to evolve. There's a lot of stake here considering the world's increasing reliance on submarine cables for communications, the complexity of having very different actors implied, and the fact that a lot of states have adopted laws and regulation in relation to submarine cables which cannot be considered reasonable measures for the exploration and exploitation of resources. A lot of committees are thinking about this currently, including into the International Law Association. Finally, I would not like to conclude on a too dramatic note, but the challenge around EEZ legal regime has also to be replaced in the larger context of the growing tensions around oceans and the fact that the whole law of the sea, not to say in some aspects the whole international law, appears to be challenged. Thank you. Gamza Hamida.
Thank you, Professor Geraldine Giraldo. Thank you for that presentation. Our next speaker is Dr. Camille Goodman. Dr. Goodman joined the Australian National Centre for Ocean Resources and Security at the University of Wollongong in March 2001. She is also a visiting fellow at the Australian National University College of Law, where she completed her PhD in January 2019. From 2005 to 2020, Dr. Camille Goodman worked in the Office of the International Law at the Commonwealth Attorney General's Department. From 2010 to 2012, she was seconded to the International Fisheries team at the Department of Agriculture. In these roles, Dr. Camille Goodman served as the Australian government legal advisor at the international meetings, advised on the implementation of international law, and managed litigations before international courts and tribunals. Dr. Goodman is the deputy editor of Ocean Development and International Law, an active member of Australian and New Zealand Society of International Law. Dr. Camille is an author. Her first book, titled Coastal State Jurisdiction Over Living Resources in the Exclusive Economic Zone, was published by Oxford University Press in November 2021. Without much ado, Dr. Camille Goodman, you have the floor.
I'd like to start by offering my sincere gratitude for the extremely warm and generous hospitality of our hosts and the very thoughtful arrangements that they've made for this wonderful event. It's a great honour to have the opportunity to participate in this conference, exchange ideas with the preeminent experts in our field, and to spend time considering the important theme of this conference, 30 years of UNCLOS, then, now, and the future. So thank you for the invitation, and I hope that I can contribute in a small way to this extremely timely discussion. Then, now, and in the future, the beating heart of the 1982 United Nations Convention on the Law of the Sea is its role in balancing the interests of all states. Nowhere is this more true or more important than in the regime for the EEZ. The balance of interests features prominently in almost every discussion about the EEZ. It lies at the heart of the compromise described in Part 5 of the Convention. It's invoked in literature and jurisprudence to characterise and define the legal regime that applies in an area covering 1/3 of the world's oceans. And it's relied on by states to underpin arguments in support of both the attribution and the limitation of jurisdiction in the EEZ. And yet the Convention itself makes no specific reference to the concept of a balance of interests in the EEZ, let alone the process for achieving that balance. Given the critical role of the balance of interests in achieving and maintaining the grand bargain embodied in the EEZ regime, then, now, and in the future, my presentation today will focus on understanding this ubiquitous but elusive concept. In essence, what I'm asking is, what is the balance of interests in the EEZ, and how do we find it? In this respect, I'm taking some inspiration from my favourite Australian film, The Castle. This is a comedy that centres around a stereotypical hard-working Aussie family who are fighting to keep their modest home next to Melbourne Airport from being acquired by the government for airport expansion. They are represented by a well-meaning but incompetent lawyer called Dennis Denuto, who is completely out of his depth. In one of the movie's most famous scenes, Dennis is attempting to argue against the compulsory acquisition of the family's home. But he doesn't have any real knowledge of the relevant law. And when the judge asks him what his argument is, he resorts to saying, it's the law, it's justice, it's the vibe. This has become an iconic phrase in Australian culture because it highlights the idea of legal arguments being based on a feeling or a sense of what is right, rather than on solid legal grounds, and perhaps because it pokes fun at lawyers. But it's also a useful way to underline the relevance of my question about the balance of interests. We all know what the balance of interests is. We probably have a feeling about what is right or just, but could we explain it in legal terms? So, what is the balance of interests in the EEZ? At face value, this is a simple question. The legal regime for the EEZ is achieved through a balance between the exclusive interests of coastal states, reflected in their sovereign rights and associated jurisdiction, pursuant to Article 56, and the inclusive interests of other states, reflected in freedoms of navigation, overflight, laying of cables and pipelines, and other internationally lawful uses of the sea under Article 58. But the simplicity of this framework belies some complexities. Which interests are relevant to this balance? By what process are they to be balanced? And what might it look like in practice? Is the balance fixed or does it change over time? Let's take these questions one at a time, considering then, now, and the future. The first question, which interests are to be balanced in the EEZ? We've had a lot of quotes from favourite authors today. I'm fond of a much quoted statement from the first president of UNCLOS 3, that dispute settlement procedures will be the pivot upon which the delicate equilibrium of the compromise must be balanced. Otherwise, the compromise will disintegrate rapidly and permanently. So I thought the best place to find the answer to this question would be in the jurisprudence of international courts and tribunals, appointed under Part 15 to carry out this pivotal role. I want to highlight 4 waypoints in the jurisprudence that I think help to show how our collective approach to this question has evolved from then to now. The first waypoint reflects one of the earliest themes in the jurisprudence of ITLOS described by Judge Haidar this morning: procedures for the prompt release of fishing vessels and their crews. Over the course of its first decade, from Saiga No. 1 in 1997 to Tomimaru in 2007, the question of how the balance of interests in the EEZ should be applied in the context of prompt release procedures was a recurring theme in the work of the tribunal. While the balance of interests required by Article 73, together with Article 292, is mentioned in some fashion in each of the prompt release cases considered by ITLOS, the formulation presented in the Monteconferco case in 2000 became the general point of reference on the balance of interest in subsequent cases. As formulated in Monteconferco, Article 73 identifies 2 interests: the interest of the coastal state to take appropriate measures as may be necessary to ensure compliance with the laws and regulations adopted by it, on the one hand, and the interest of the flag state in securing prompt release of its vessels and their crews from detention, on the other. It strikes a fair balance between the 2 interests. This formulation is noticeably binary and specific. There are 2 relevant interests to be balanced in the context of prompt release, and they are both in the nature of rights: rights to ensure compliance with laws and regulations, and rights to secure the release of vessels and crews. This approach to the balancing of coastal and flag state interests under Article 73 has been subject to some criticism as inappropriately favouring flag states and as failing to consider the proper context of the EEZ regime. In particular, the fact that both coastal and flag states have duties as well as rights, which are relevant to the way in which this balance should be struck. Apologies. The tribunal was specifically invited to consider some of these broader contextual issues in the 2004 Volga case, in which Australia, as the respondent, argued that the imposition of non-financial conditions as part of a bond was necessary in order to effectively combat IUU fishing in the Southern Ocean. While the tribunal acknowledged the need to have regard to all the circumstances of the case and took note of the significant international concerns about IUU fishing, it nonetheless adhered to the balance of interests as formulated in Monteconferco. As an Australian, I must note that a dissenting opinion was issued by Judge Ad Hoc Shearer, with whom Judge Anderson agreed, which called into question the idea that the balance to be achieved in the EEZ should be preserved exactly as it was conceived at the time of UNCLOS 3, and suggested that in the context of fishing, and in the light of the challenges presented by unscrupulous operators and ineffective flag state control, changing circumstances required a new balance to be struck between vessel owners, operators and fishing companies on the one hand and coastal states on the other. While I'm not sure that owners and operators should necessarily be part of this balance, I think Judge Shearer was right in trying to provide a broader formulation of the interests that require consideration, and perhaps he was just 10 years ahead of his time. Let's stay with ITLOS and with fishing, but jump forward 10 years to the 2014 decision in the Virginia G case, also mentioned by Judge Haidar this morning, and the 2015 request for an advisory opinion submitted by the Sub-Regional Fisheries Commission. These cases dealt with different legal questions, which raised the balance of interests in different ways, but both of them opened the door to considering not only rights, but duties as part of the balance of interests. As Judge Haidar reminded us this morning, in Virginia G, the tribunal was required to balance the coastal state's exclusive sovereign rights over living resources with the freedom of navigation of all states in order to decide whether fishing-related activities, such as bunkering, fall within the jurisdiction of the coastal state or the freedom of flag states. The tribunal did not spell out its balancing process in detail, and it focused primarily on determining the extent of coastal state rights, rather than the balance to be achieved between coastal and flag states. But importantly, it touched on the idea that the coastal states' interests include not only the rights in Article 56, but the related conservation and management provisions in Article 61 of the Convention, which are essentially duties. A more detailed balancing process was also described in a separate opinion of Judge Peck, as he considered whether or not the confiscation of Virginia G was necessary in the sense of Article 73(1). Judge Peck noted specifically that the elaborate balance between the rights and the obligations of the coastal state and those of other states is at the core of the legal regime of the EEZ. He gave serious weight to the challenges experienced by the coastal state in enforcing its fisheries legislation effectively, and he also acknowledged the potential for various coastal state enforcement actions to burden the freedom of navigation for flag states in a way that would upset the balance of interests. These ideas are also reflected, in a different way, in the SRFC advisory opinion. Once again, the decision does not specifically refer to the balance of interests or describe a process of balancing, but it does specifically recognise both the rights and the obligations of coastal and flag states. In particular, it recognises that the Convention approaches the issue of conservation and management of living resources from the perspective of obligations of the coastal state, and that these obligations entail corresponding rights. This decision recalls the responsibility of coastal states to ensure the conservation and management of living resources in the EEZ, and it confirms that in light of the special rights and responsibilities assigned to the coastal state in the EEZ, it has the primary responsibility for taking measures to address IUU fishing. It also recognises the general and specific obligations of flag states in this regard, spelt out by reference to the duty of flag state responsibility in Articles 92 and 94. So these cases move beyond the binary and rights-focused approach of the prompt release cases, and they endorse the balancing of a fuller range of interests, not just rights or entitlements, but obligations or responsibilities or duties. This may seem obvious, particularly given the rule of reciprocal due regard in Article 56 and 58. But in the absence of an explicit process for balancing interests in the EEZ, recognition that both rights and duties are relevant to establishing the balance is critical, including to ensure that the ceiling placed on the state's rights is interpreted in a way that keeps it above the floor of states' duties, to steal from Alex Mills. In other words, to ensure that the rights of the coastal or flag state are not interpreted so restrictively as to impede the fulfilment of its obligations, and vice versa. I think this is an important distinction between the rights-focused approach taken in the early cases and the more comprehensive approach of these later fisheries cases. But the balance of interests in the EEZ is not limited to fisheries. Another significant contribution was made by the Annex 7 Tribunal in the 2014 Arctic Sunrise arbitration. In this case, the Tribunal was effectively asked to consider the balance between coastal state sovereign rights over non-living resources and the freedom of foreign nationals and foreign vessels to conduct protest actions at sea. In this respect, the Tribunal found that the coastal state's sovereign rights legitimately extend to taking measures of protection or prevention, provided that those measures do not infringe or unjustifiably interfere with the navigation and other rights and freedoms of flag states. As in other cases, the decision does not explicitly refer to the balance of interests, but the Tribunal specifically and usefully provided that it would be reasonable for a coastal state to act to prevent violations of its laws adopted in conformity with the Convention, dangerous situations that can result in injuries and damage, negative environmental consequences, and delay or interruption in essential operations. The Tribunal described all of these things as legitimate interests of coastal states, but also provided some outer limits by specifically noting that coastal states should tolerate some level of nuisance so long as it does not amount to an interference with the exercise of sovereign rights. So this case goes another step further than the rights and duties framing and demonstrates there's this broader category of legitimate interests derived from the rights and duties of coastal and flag states. What is this interest? How do we define it? Perhaps one way to think about it is that if rights are things we may do and duties are things we must do or we must not do, perhaps interests are the things that affect our rights and duties. Do they affect what we may do or what we must or must not do? The final case I want to touch on is the 2015 Chagos arbitration, which was also raised by Professor Davenport in the previous session. In contrast to previous cases, This decision did refer specifically to the balance of interests, but with a focus not on fisheries or oil and gas, but on the declaration of a marine protected area, and not on the extent of coastal state sovereign rights, but on the requirements of coastal state duties, specifically the duty of due regard under Article 56(2). In this context, while declining to find any universal rule of conduct, the Tribunal set out a clear process for determining the extent of the regard required by the Convention. Pursuant to this process, the extent of the regard required will depend on the nature and importance of the rights held by the flag state, the nature and importance of the activities contemplated by the coastal state, the extent of the anticipated impairment to the flag state's rights, and the availability of alternative approaches. The Tribunal also noted that in the majority of cases, assessing the outcome of this process will necessarily involve at least some consultation with the rights-holding state. So this is effectively a balancing process, and it can apply to coastal and flag states pretty much interchangeably given the reciprocal nature of due regard. So from this approach, I take inspiration for a general process which involves assessing and weighing the nature, importance and impairment that any particular action will have on the rights and the duties and the legitimate interests of all relevant states, and considering whether there are any available alternatives. Having started with then and reviewed the jurisprudence to determine which interests are to be balanced in the EEZ, we find ourselves now facing the challenge of enunciating a consistent or at least reasonably coherent process that can be followed for actually balancing those interests. To do this, I'm going to combine the various elements established from the jurisprudence and propose a three-step framework that states or tribunals or commentators could use to assess where the balance of interests might lie in relation to different issues in the EEZ. And in the tradition of speakers from the previous panel, you might like to think of this as a thought experiment. The first step is to consider what effect any given jurisdictional assertion, a measure or action, might have in the context of the relationship between the coastal state's own rights and duties. So this is a binary, but not in the sense of the prompt release cases. The purpose of this binary is to assess the nature and importance of the coastal state's rights, things that the coastal state may do, including any legitimate interests that might affect the exercise of those rights, and equally, the nature and importance of its duties, things that it must do or must not do, as well as any potential impairments to those rights and those duties. The reason for starting with this balance is to ensure that the coastal state's rights are not interpreted so restrictively as to prevent it from fulfilling its obligations, or indeed that its duties are not interpreted so onerously as to prevent the enjoyment of its rights. For example, noting the statement in the SRFC advisory opinion that the coastal state has the primary responsibility to prevent, deter and eliminate IUU fishing in the EEZ, it would arguably be relevant to make sure that its rights are interpreted sufficiently broadly to allow it to take relevant measures in relation to IUU vessels. The second step is to undertake a similar exercise with respect to the rights and duties of other states. And here I would say most importantly that means any relevant flag states, or one if there's one particular flag state, but also any other states, given that the measure or action may affect multiple states, or even potentially all states in terms of its precedential effect. So in this case, we consider the nature and importance of the rights of other states, the things they may do and their legitimate interests, and equally the nature and importance of their duties, the things they are obliged to do or refrain from doing. And we need to consider any potential impairments to those rights or duties that might result from the proposed action. Finally, the outcome of these two considerations needs to be balanced against each other in the way suggested in the Chagos arbitration. At this point, some other X factors may also come into play, depending on the particular type of balancing exercise and the jurisdictional assertion in question. In some situations, this will involve the consideration of alternative options to see if there's something else which has less impact on the interests of other states. And in some situations, it will, as the Chagos Tribunal identified, require consultation. In other situations, it might be relevant to consider the broader context, including the circumstances and manner in which the action or measure is proposed or was taken, as suggested by Judge Peck in Virginia G, or even the interests of the international community as a whole. Now, at this point, it's important to note that, as in the Chagos arbitration, this is not intended as a universal rule of conduct. And in the application of this test, and in the weighing of the balance, reasonable minds may differ. There's no completely objective way to ascertain which right or duty is more important, or to predict exactly how they may be affected. But that's why we have courts and tribunals. And this might at least provide a consistent and reasonably predictable process for states in making such decisions, and a way to ensure that all relevant rights and interests are taken into account. So finally, let's look to the future and consider what the implementation of this framework might look like in practice. I want to use an example which was actually raised by Professor Giraudot, but has not so far been the focus of much discussion and is about to become highly relevant: the regulation of navigation in and around offshore wind farms. So why is this relevant? In 2013, there was just 7 gigawatts of installed offshore wind in the world. In 3 years, this had doubled to 14 gigawatts, and in another 3, it had doubled again to 28. By the end of 2022, 63 gigawatts of offshore wind had been installed worldwide, and this trend is set to continue. In order to achieve net zero emissions by 2050, we need to install 2,000 gigawatts of offshore wind. This will require a further 32 times the amount of generation capacity currently installed, 3,200%. To fulfil this, we will need approximately 200,000 wind turbines, which will require approximately 500,000 square kilometres of ocean. So we're talking about some very large areas. This is going to require us to think about how we balance the interests of coastal states and other states, and of individual vessels, and of the international community as a whole, in areas where offshore wind turbines and navigation intersect. Obviously, there are an almost infinite number of specific jurisdictional assertions that we could weigh up here, but for simplicity, I want to think generally about what's involved in balancing the interests of coastal and other states in respect of offshore wind farms and navigation, using the framework just developed. Start with the coastal states' interests. The coastal states' rights are sovereign and exclusive in nature. They include the rights to exploit offshore wind resources, to regulate offshore structures and establish safety zones, and to prevent pollution. And they extend to interests in preventing interference with those rights. These rights are important because they relate to critical maritime infrastructure, which will be key to the coastal state's energy and economic security, and thus its national security, and to the renewable energy transition. They're also important to protecting the marine environment, which is a matter of both intrinsic and economic importance. On the other side of the ledger, the coastal state has a combination of general duties, like the duty of due regard and marine environmental protection, and more specific duties, like the requirement to give due notice of structures and safety zones, prevent, reduce and control pollution, and tolerate some level of nuisance in relation to its protected rights. These are important duties. They're central to preserving the protected rights of other states and underpin the fundamental freedoms of communication, as well as the safety of life and property, and once again, the protection of the marine environment. It's a bit difficult to predict the extent of the likely impairment to these rights, or to the coastal state's ability to fulfil these duties without actually considering the nature of the specific action or measure proposed or challenged. For example, the consideration would be different if the coastal state were proposing to prohibit all navigation through a 700 square kilometre wind farm, the size of Australia's largest offshore wind farms under our legislation, than if it is proposing to limit transit to certain vessels under specific conditions. But in general, the likely impairments are remarkably similar, whether they are considered by reference to rights or duties. Essentially, restrictions on the coastal state's discretion are likely to make it harder to locate, establish and operate wind farms, and regulate navigation in and around them in the most effective, efficient and environmentally responsible way, which will lead to higher energy costs and potentially economic and environmental damage. A similar exercise can be conducted with respect to other states. This most obviously involves other states in their role as flag states, whether because they have a direct interest in vessels sailing in that area or because of concern about the precedent this might set for other areas. But other states also have other roles, including as consumers of energy produced and exported by the coastal state through cables, and as members of the international community with concerns about the marine environment, the energy transition, or even the costs of shipping. At a basic level, the protected rights of other states in this situation include freedom of navigation and related freedoms in Article 58, including the right to protest identified in Arctic Sunrise. The freedom from interference with use of sea lanes essential to international navigation in Article 60, and the exclusive right to exercise jurisdiction over vessels. Some of these rights are closely related to the coastal states' duties, and they're important for the same reasons. They underpin fundamental freedoms of communication and safety of life and property. But there's an added issue for other states that relates to the efficiency of navigation in terms of time, economic cost, and even environmental cost in terms of emissions. Of course, the duties of other states are established a little bit differently to those of coastal states. They share the reciprocal duty of due regard and the duty to prevent pollution, but they must also comply with coastal state laws and respect safety zones and navigation rules established by the coastal state, and they have to exercise their flag state responsibilities effectively. Again, the potential impairment to the interests of other states is difficult to assess without a specific regulation in mind, but in general, they're likely to include increased costs, decreased profits, and higher emissions as a result of navigation being routed around wind farms, or potentially danger to life and property and increased insurance costs if navigation is exposed to more risk within wind farms. Either way, it could be more expensive. So what does it look like to balance these interests against each other in the third stage of the process? I was a bit surprised in summarising these rights and duties to find that coastal and other states had more common or overlapping interests than I expected. In particular, the inevitable balance between sovereign rights and flag state freedoms, which arise as rights and duties on both sides, the protection of the marine environment, and the safety of life and property. This also reveals some outlying interests which are important to take into account. In the case of coastal states, interests associated with protecting critical infrastructure and the production of renewable energy, and in the case of other states, the efficiency of navigation and the potential for higher shipping costs. And there are also a range of X factors which could be considered as part of the process, depending on the action or measure in question and who is doing the balancing. So to return to my question, what is the balance of interests in the EZ? I think it is law and justice and the vibe, but I think it can also be considered in a more systematic way. It's important to acknowledge that this approach might not be appropriate in all situations, and it's not intended as a universal rule or a universal ruler of conduct, but as a flexible framework to ensure that all relevant perspectives can be considered. It can be applied in a differentiated way, depending on the subject matter and the nature of the measure, action, or assertion in relation to which balancing is needed. Importantly, the balance of interest is not binary, but three-dimensional. It includes rights and duties and legitimate interests of coastal states, flag states, and other states. And it's comprehensive. It requires consideration of the nature and importance of those rights, duties, and interests, as well as potential impairments to them, and leaves room for some consideration of relevant X factors. And as the examination of the case law and the little case study have shown, the balance of interest is not fixed, but develops over time in light of social, economic, political, and geographic change, and advances in science and technology. So this is a balance that will need to be struck repeatedly and not always in the same place. The sort of process I've suggested is probably something that's done largely behind the scenes, on a whiteboard by officials developing a policy or law, by two states, or by a conciliation commission in the context of a negotiation or conciliation over a sticky problem, or by a judge as part of the process of analysing and weighing the arguments and evidence presented in a case. Clearly, this framework is not a silver bullet or a complete solution, but even if it is only used as a theoretical starting point in any of these cases, it could help to provide a fulsome process for balancing the interests of not only coastal and flag states, but all states, in a way that helps to preserve the compromises embedded in the Convention. Thank you.
Thank you, Dr. Goodman, for that insightful presentation. I'll now call on my next speaker. This time is a discussant, Professor Suzanne Lalonde. Dr. Suzanne Lalonde is a full professor of international law and the law of the sea at the Law Faculty of the University of de la Montréal. She holds a BA from the University of Ottawa, an LLB from Queen's University, and a PhD in Public International Law from the University of Cambridge. Her research and publications in both French and English focused on core international legal principles, especially those pertaining to sovereignty and determination of boundaries on land and at sea, with a particular emphasis on the Arctic. She was a member of the ILA committee that reported on baselines under the law of the sea in 2018, and co-editor of Ocean Development and International Law from 2017 to 2018. She is a member of the Canadian Arctic Security Working Group. Professor Lalonde, you have the floor.
Thank you so much. It's an honor to be able to participate in such a prestigious and important meeting. And I would also like to extend my thanks to the Ministry of Foreign Affairs, to the Korean Society of International Law, to UNCLOS, for this amazing conference and just the platinum standard of conferences, I must say. I think I'll be spoiled for any others now. And for the very, very warm welcome we've been given. To be asked to offer some comments on such two excellent presentations is a tall order. In fact, I do find it will be difficult to offer meaningful insights given the deep expertise of Professors Giraudeau and Goodman, and indeed the sophistication of the analysis they have offered. To prepare for today, I looked up descriptions of what it is to be a discussant, a role I have not often played compared to being a speaker. I discovered, and I wanted to do a good job, so I discovered that I am expected to highlight the key points of the two presentations, but more importantly, I am to raise questions to hopefully stimulate discussion between the presenters and members of the audience. I think my role is rather that of a devil's advocate, which the Oxford Dictionary describes as someone who expresses a contentious opinion in order to provoke debate or test the strength of the opposing arguments. I will therefore try to do justice to the two presentations we've just heard and the wonderful ideas, but to test the strength of some of the arguments put forward by Professors Giraudeau and Goodman. You will see that I rather agree with them. To turn to Professor Giraudeau's excellent presentation. Professor Giraudeau described the EEZ as a major innovation of UNCLOS and explained that it established a balance between sovereign rights and freedom, between the rights of the coastal states and the rights of third-party states. I was struck that in her abstract, Professor Giraudeau described this as a perilous balance, full of danger or risk. And in her presentation, she asked whether this balance is sustainable, given the current challenges facing this institution. In essence, Professor Giraudeau was asking us to consider whether the UNCLOS EEZ regime and the balance it establishes can adapt to new realities and cope with a slew of emerging challenges. Using the material approach, she identified one of the two approaches she suggested. She identified and briefly explained a number of issues and difficulties currently confronting the EEZ's regime. The vagueness of Article 74 for the delimitation of disputed EEZ areas, sea level rise, and its impact on existing EEZ boundaries. Indeed, she questioned the very permanence of the EEZ in this context. Referring to climate change, she mentioned the overexploitation of fish stocks and the difficulty of maintaining effective control of the EEZ. And there were others, the general protection of the marine environment, issues connected to seabed, exploration and exploitation. And one that actually also came up in Professor Goodman's presentation, competing use of space and referring to energy in this context. She mentioned also security. And in the end, she left us with quite actually a dramatic question. Is there a general threat to the relevancy of the law of the sea, I think? I would offer two general comments, perhaps slightly controversial, but I'm not sure. First, I would argue that always should have been expected that the newly created EEZ regime would be tested, that the rules that came into force in 1994 would be variously interpreted, and that kinks in their application would have to be ironed out in time through state practice and the establishment of common understandings, especially through judicial decisions and opinions. I know that we are here to celebrate 30 years of UNCLOS coming into force. But while this is undoubtedly an important milestone, it is not such a long period when one considers the evolution of the law of the sea. One need only look to the regime governing the territorial sea, which we spoke about this morning. The territorial sea is considered la grande dame of the law of the sea, one of the oldest and most enduring concepts of the law of the sea. And yet, how long did it take to agree to a maximum extent of the territorial sea, to work out an acceptable compromise between diverging interests and priorities to enable us to arrive at a generally acceptable solution? And to use one of Professor Giraudo's examples of competing uses, states are still arguing about competing uses and priorities in the territorial sea. Consider as only one example, the clash between the security priorities identified by some coastal states and the legal rule guaranteeing the right of innocent passage for all vessels, including, I would agree, foreign warships. This example and challenge posed brings me to my second general comment. I fear that the challenges, problems, and issues identified by Professor Giraudot are not only causing problems for the EEZ regime, calling into question its very capacity to remain relevant. I think many of those issues are also impacting other maritime zones. Sea level rise, for instance, is challenging the stability of all maritime limits and boundaries, including the territorial sea baselines. The problem of overexploitation is another issue that is afflicting not only the EEZ, but also the high seas. And therefore, as her last point made clear, Professor Giraudot may be calling into question the sustainability not only of the EEZ regime, but of UNCLOS more generally. And though I think there are most certainly risks, to come back to that word perilous, that I think the more challenging aspects of UNCLOS must be given more time. After all, significant progress has been made to flesh out and build common understandings on some of the challenges she raised. Examples include how the three-step approach, thanks to the pen of judges, has come to dominate the interpretation of Article 74. Another example that's been highlighted already today is the lead taken by Pacific Island states in the regional customary rule, I would argue, that is emerging or has emerged from their general approach and practice, that baselines, limits, and boundaries, once established according to international rules, should be fixed and immutable. I suppose then, and honestly, a little to my surprise, I am fairly optimistic. I think the EEZ regime and UNCLOS can adapt and therefore be sustainable. I would offer a final example in support of this rather optimistic conclusion, the continental shelf regime. Consider how the continental shelf regime, launched by the Truman Proclamation in 1945, nearly 80 years ago, has adapted to new challenges. The very definition of what constitutes the continental shelf of a state had to be revised. Indeed, the rules had to adapt in the face of new technological developments and the stress and impact they had on the exploitability criterion under the 58 Convention. And yes, the new regime under Article 76 of UNCLOS has created new uncertainties, but they are slowly and I think steadily being resolved, including through the assessments and interpretations of the Commission on the Limits of the Continental Shelf, for example, on the differences between oceanic ridges, submarine elevations. Turning to Professor Goodman's fantastic presentation. So Professor Goodman also focused on this central idea of balancing of interests, and as she stated, the concept of the balance of interests features prominently in almost every discussion of the EEZ. And in her presentation, she highlighted fundamental complexities within what UNCLOS seems to present as a supposedly straightforward framework. She addressed a number of specific questions to illuminate these complexities. What is precisely the balance of interests established in the EEZ? Which interests are relevant to this balancing exercise? By what process are such interests to be balanced? And what might this balancing exercise look like in practice? And closely connected to that last question is, should that balancing exercise change over time? In my remaining remaining minutes, I would like to focus on Professor Goodman's second question, what interests are relevant, and on her final question, should that balancing of interests change over time? Because to my mind, those two questions are closely related. In addressing question 2, Professor Goodman explained that interests must be understood as both rights and duties using the case law, and that therefore the balance established in the EEZ regime is a balance between those things that states may do, their rights, and those things that states must do or must not do, duties. She then added another layer, referring to the legitimate interests of the states and that they have a role to play in that balancing exercise. And significantly, that legitimate interests are things that affect rights and duties. Finally, Professor Goodman explained that the balancing exercise must weigh 1, the nature, 2, the importance, and 3, the impairments of rights, duties, and interests. And I think in that reference to interests, it was to those legitimate interests. I would note finally that Professor Goodman's slide emphasized that a consideration of alternatives, of what alternatives are available, should also factor in. So in terms of that question 2, the nature, importance, and impairment of rights, duties, and legitimate interests must all be factored into the balance. The inclusion of legitimate interests as a core element, and with that list that she showed us from the Arctic Sunrise, I think is of immense interest. Because for me, the concept of legitimate interests is not a static concept. Therefore, if the EEZ regime in that balancing exercise calls for a balance of rights, duties, and legitimate interests, that balancing exercise is bound to change over time. That final question raised by Professor Goodman. I would argue, and I'm a little shy to do so, I'm not sure I actually believe, but here goes. I would argue that perhaps globally impactful developments like climate change and its devastating effect on marine ecosystem health, including living resources, and other challenges like the global plague of overfishing, are perhaps having a greater impact on the legitimate interests of the coastal states as they were envisaged in 1982 than on the freedom of navigation. I think Professor Goodman's example of the use of wind farms is fascinating. The statistics in terms of ocean space that will eventually be covered by wind turbines is staggering. And yet, I still feel that the two interests can be accommodated, that using the established rule of respect for sea lanes is essential for navigation, the importance of coastal states' rights to, but especially their legitimate interests in clean energy, can be reconciled with the efficiency and safety of navigation. If one considers the question of impairment in the sense of the availability of alternatives and the alternatives, wind farms are absolutely essential to the global effort to reach net zero emissions, as she informed us. Whereas perhaps developments in AI and new ship operating technologies may help ships continue to navigate efficiently and safely, even in crowded oceans. I'm not saying that states will no longer enjoy the freedom of navigation in the EEZ. I'm not that daft. But perhaps the balance of rights, duties, and especially the legitimate interests of the coastal states, especially when you think of environmental and biodiversity interests, which in many instances will be aligned with broader international community interests, may tip the balance slightly, at least maybe on an issue-by-issue basis. As you mentioned, it is not a universal objective test. As Professor Goodman's last slide emphasized, the balance of interests in the EEZ is developing, and it must develop over time to respond to social, economic, political change, to new advances in sciences, including our scientific understanding of phenomena like climate change and its effect, and also technological developments. I am in complete agreement with her last point that the balance is not fixed, that the competing rights, duties, and legitimate interests will need to be regularly or periodically reassessed and new balances struck repeatedly. As I mentioned in my comments on Professor Giraudeau's presentation, although I acknowledge that working out these new compromises can be slow and somewhat messy, I think it's absolutely necessary to do so and that it is achievable. I have in mind the example I had written already, the example that Judge Hader gave us this morning, our emerging understanding of where the balance lies for the bunkering of different types of ships in the EEZ, thanks in large part to judicial pronouncements. UNCLOS is a constitution for the oceans. Several people have underlined already at this conference that it is a living instrument. In its truest sense then, if it is a living and breathing document, which I'm borrowing the words of Eric Fan, it is a dynamic framework designed to adapt and evolve. It allows for bounded resilience. It must, however, be allowed to breathe and grow. So let me here end by thanking Professor Giraudoux and Goodman on behalf of us all for their thought-provoking and insightful presentations. Thank you.
Thank you, Professor Lalonde, for your insightful discussion on the issue. And I'm sure that you've raised issues that the audience will also like to participate, because based on the issues that you raised, in my personal view, I observed that 3 themes run through all the presentations. Jurisdiction, security, and of course, international cooperation. They are very important in managing the EEZ. With that note, let me call upon our final discussant for this panel. Her name is Professor Kim Hyun-Young of Yonsei University. Dr. Kim Hyun-Young is a professor in the Department of Political Science and International Studies at Yonsei University, Republic of Korea. Her primary research areas include the law of the sea, climate change, international institutions, and the intersection of international law and policies and politics. She has published extensively in Korean, English, and French, contributing significantly to the field of international law. Okay. I think this is enough to describe Professor Dr. Kim Hyun-Young. You have the floor.
Yeah, thank you, Chairperson. Good afternoon. My name is Han-Jung Kim from Yonsei University. First of all, let me express my sincere gratitude to MOFA Korea, UNCLOS, and Korean Society of International Law for inviting me to this wonderful event. Our session today is titled The Legal Regime of EEZ under UNCLOS. When I teach international law of the sea, I spend a lot of time explaining the EEZ because it is one of the most significant maritime zones under UNCLOS. Our 2 speakers, Professor Giraudoux and Professor Goodman, explored the formation of EEZ and balance between coastal and flag state interests and the challenges facing the EEZ regime. Thank you both for your insightful presentations. Let me give by making a few comments on the presentations and connecting them to Korea's practice related to EEZ. First, the EEZ is an artificial zone, unlike the continental shelf, which was originally based on geographical and geological factors. During the 3rd UN Conference on the Law of the Sea, states did not agree on the 200 nautical mile limit for any scientific or ecological reason. Rather, this distance was a political compromise. As Professor Giraudoux put it, the EEZ is a great innovation of UNCLOS. Second, Professor Giraudoux also emphasized the Global South's role in shaping the concept of the EEZ. I'd like to add that Korea also contributed. In 1952, the Korean president issued a presidential decree known as the Peace Line, extending 50 to 100 miles off the Korean coast. This was mainly to protect Korean fishermen from technically advanced Japanese fishing activities. In many ways, this reflects the modern EEZ's purpose to safeguard coastal states' economic interests. At that time, the United States and Japan expressed their opposition to Korea's declaration of the peace line on the grounds of freedom of fishing on the high seas. Although the peace line faced opposition at that time, it contributed to the development of concept of EEZ. In terms of formation of customary international law, it is interesting to note that actions initially seen as inconsistent with existing rules can over time contribute to the development of a new customary rule, especially when supported by consistent state practice following. In this context, Korea's peace line declaration in 1952 can be viewed as an early example of a state practice that aligned with and contributed to the eventual formation of EEZ concept on the UNCLOS. Third, both speakers also mentioned offshore wind farms as growing challenges to the EEZ regime. For example, earlier this year, the Japanese government introduced a bill to parliament to amend the law regarding offshore renewable energy generating facilities. This bill seeks to expand the areas where offshore wind farms can be developed, moving beyond Japan's territorial waters, its EEZ. Korea is also making efforts to establish offshore wind farms in its EEZ. Currently, there is no dedicated law specifically for offshore wind farms in Korea. However, the Korean government is actively promoting the development of offshore wind farms. According to an announcement made by the Korean government in this August, 61.1 gigawatts of energy is projected to be supplied by solar and wind power by 2030. In addition, the government plans to expand wind energy capacity by another 1.9 gigawatts by 2030 through policy efforts. These include measures to simplify the licensing process for offshore wind projects. Through these initiatives, Korea aims to achieve a carbon neutral scenario before 2050. However, such developments raise practical and legal issues. For example, foreign vessels involved in wind farm construction in the EEZ may also need to enter Korea's territorial waters or ports. However, under Korean law, some ports are restricted to foreign vessels. Should these restrictions be lifted for long-term projects like offshore wind farms? At the same time, large-scale wind farms may also affect local stakeholders, such as fishermen, because these farms are likely to restrict their fishing activities as well. Environmental concerns are another challenge, as Professor Goodman also addressed. Wind farm construction can cause underwater noise, sediment disturbance, and electromagnetic waves, which affect marine ecosystems. For instance, low-frequency noise can disrupt marine mammals like dolphins. And we also have dolphins in Korea. While offshore wind energy is key to combating climate change, we must ask whether it creates new environmental issues that need to be addressed. Finally, when two states have overlapping EEZ claims, an undelimited area arises. In such cases, UNCLOS Article 74, Paragraph 3 provides that states shall make every effort not to jeopardize or hamper the reaching of a final agreement for delimitation. However, this raises an important question: to what extent can states exercise their rights in these undelimited EEZ areas? Ultimately, this is another example of the challenges of balancing competing interests, this time between the claimants themselves. The issue of what constitutes a breach of Article 74, Paragraph 3 has been addressed in cases like Guyana-Suriname arbitration and the Ghana-Cote d'Ivoire case before the UNCLOS Special Chamber. Even so, there is ongoing debate about whether disputes regarding this obligation included under, I quote, dispute concerning the interpretation or application of Articles 15, 74, and 83 relating to sea boundary delimitations, end of quotations. as described in Article 298, paragraph 1A1 of UNCLOS Part 15. Another point of discussion is whether a violation of the obligation of a restraint for fishing activities in an undelimited EEZ qualifies as dispute relating to the coastal state's sovereign rights with respect to the living resources under Article 297, paragraph 3A of the Convention. If it does, such disputes should not fall under the compulsory procedures in Part 15, Section 2, but instead would go through the conciliation process outlined in Annex 5, Section 2. With these legal uncertainties in mind, I would be interested to hear presenters' thoughts on how disputes on delimited EEZ areas should be addressed under Part 15 of UNCLOS. I know we have another panel for the peaceful settlement of disputes, but if you have any thoughts about this issue, I would like to listen to that. Once again, I'm very grateful to our speakers for their excellent presentations, and thank you for listening to my discussion.
Thank you, Dr. Kim. That was very, very fast. Now we've listened to our excellent panelists. They have a multilinguistic perspective about the law of the sea, especially on the topic under discussion. If you can see from their bios, most of them speak, I'm sure, 2 or 3 languages. Like for Kim, she speaks Korean, French, and English. And the one nearer to her, the next, speaks English and French. And of course, my immediate left, she speaks French and English as well. So they have multilingual perspective about the EEZ. Now I open the floor for your contributions, comments, interventions, and questions. Yes, you have the floor. Is there anybody here who can coordinate the mic? The gentleman, yes. Okay.
Thank you very much, James Harrison, University of Edinburgh. I enjoyed those presentations immensely. I have a question for Dr. Goodman. You gave us an interesting view on how the balance should be struck. I think my question is a bit more about who strikes that balance. And I guess the relationship between courts and states. When courts are seized of these sorts of disputes, what exactly are they doing? Are they checking that states have followed the right sort of process? Are they asking whether a reasonable balance has been struck? Or are they stepping in and saying what the right balance should be?
Other question from the floor? I can see none. Maybe I'll give the panelists opportunity to answer this question whilst we await interventions from the floor. So you have the floor.
Well, thank you for that question, and I might also take the question from my fellow panellist here as well, which had some similar flavours to do with disputes and undelimited maritime boundaries. Just as a broad comment, the thing I really like about balancing of interests, and particularly the test that was set out in the Chagos arbitration, is it speaks to me as a government lawyer. That's the same way that we would address a policy issue at the domestic level, right? You would think about what you're trying to do, who it affects negatively, and whether there's any other way that you might do it that would affect people differently. So I really like the way that that test was translated to the international plane, and I think it can be used by everybody. So in terms of who does the balancing, the first part of the question, I think everybody does the balancing. I think states do the balancing in their own actions when they're choosing what law to pass or not pass, or what jurisdiction to assert or not. I think the sort of process that I've described could be incredibly useful in the case of a disagreement between two states wanting to sort it out themselves through a process of negotiation, as a way to, legitimately identify all the different perspectives and map everything out, and essentially almost do that domestic policy process of working out the best solution for everybody, taking the best, most optimistic, good faith approach, I suppose. And in terms of courts and tribunals, I think it depends what they're being asked. And sometimes I think they do look at the process. I think in Chagos they were looking at the process and had consultation been undertaken, for instance. So sometimes it is a process issue. At the end of the day, often it is a substance issue and a question of whether the balance was struck in the right place. But there are all different sorts of balances. So the balance in a prompt release case is a very different sort of consideration to the balance in a arrested vessel case such as Virginia G, or the balance of, you know, broader sort of IUU fishing issues. So this isn't going to apply the same way in any instance. My objective here is really to try and raise up rights and duties to the same level so that due regard doesn't come in as a sort of second afterthought after the rights are established. Oh, and we better think about due regard. I think thinking about those things on the same plane is useful, and then I think thinking about them for everybody that's involved at the same time to try and resolve the best possible outcome is useful. And I suppose I'm conceiving balance of interests almost as a sort of a meta concept above the Law of the Sea Convention. The Law of the Sea Convention seeks to establish a balance of interests. It does that by enunciating rights and duties, and those rights and duties are then interpreted in the balance of interests, so there's almost a sort of virtuous circle. In terms of undelimited areas and dispute settlement, I claim no expertise, but I am an ex-government lawyer from Australia, and I was involved in early stages of the Australia and Timor-Leste case, so I do think that we have now an excellent example of the possibilities to use conciliation in a very positive way. And I know I don't speak for the Australian government in any way, shape or form, but Australia has long held the position that boundaries are best solved through negotiation. And I think the Conciliation Commission did a wonderful job of being able to draw in all the different interests, rights, duties, perspectives, and come out not just with a line, but with a solution that worked for everybody.
Thank you for those answers. Any comment on your side?
Maybe,
okay.
Yeah, it works, right? Just a few comments, thank you. I would like to thank Professor Lalonde and Professor Kim for their comments and their insightful points. Maybe I would just like to answer briefly to Professor Lalonde, who made a point, because indeed, lots of these challenges, climate change, other threats to environment, security, are not specific to EEZ. But I would say that the causes are the same, but the effects are different, for at least 3 reasons. The first one would be the ambiguities of the dispositions specific to EEZ, which are more important because it's a sui generis regime and because also of historical reasons for the project I've mentioned initially of creating a unique zone with the continental shelf. 2 other things would be the vastness of these maritime spaces and what is at stake in terms of biological diversity and economy. As I reminded to 90% of the fish market comes from the EEZ. What EEZ means for small island states is an existential aspect. So it also means that, for instance, if we think about permanence of maritime zones, if we focus on permanence of EEZ, it is indeed an existential issue for some of the countries.
Thank you. Any additional question, comment? We still have like a few minutes, at least 5 minutes more. Okay. You have the floor. Somebody else, give him the mic.
First of all, thank you for the excellent speech and perspective. It was really impressive. So I'm a sophomore in Korea University, majoring in international studies. So I have a question to Dr. Goodman. Professor mentioned that rights, duties, and legitimate interests must be balanced. So I have a question in this point. I think from a state's perspective, it seems likely that they would focus on interest when addressing matters related to the EEZ. So could you please elaborate further on how this balance can be achieved in practice?
You have the floor. Go ahead.
Oh, thank you for the question, and it's great to see you here at the conference and to be able to engage with so many people from different areas of study and different universities. I think in my ideal world, in order to achieve the balance, states would conceive of examining their rights and examining their own duties and doing that real balancing process that I've described in the presentation to make sure that the rights they're asserting meet their needs and fulfil their duties, and also align with that broader idea of what benefits everybody. Because the translation of rights and duties into the Law of the Sea Convention is part of this grand bargain, the consensus deal, the package deal, that everybody accepts all the rights and all the duties and that there are no reservations. So, a good faith implementation of the convention would look not only when states want to do something at what they're allowed to do, but also what they're required to do in giving effect to it. That's quite a difficult task, and it probably draws in more than one government agency into decision-making processes. So, as we know, it's hard working in government, trying to work across silos, and if you're trying to make a decision about fisheries and you have to consult with the Transport Agency and the Communication Agency and the Navy and the Environment Department. So I think coordination and breaking down silos within government is also a really important part of being able to do that in a practical way.
Thank you for those answers. I think one final contribution from the floor. Yes. Go ahead.
Could I? I'm a second secretary from the board, KMOFA, Chino Park. I would like to have a question to Professor Girodo. Although it was discussed in the first session, you have also discussed about the articles in UNCLOS and referred to submarine cables. What is your maybe opinion whether concerning subcables that whether there should be a kind of a additional legislation, or maybe do you think the regime of UNCLOS is sufficient to regulate those kind of subcables matters? And finally, you also referred to the notion of due account in your presentation. So if possible, could you give some more details about that notion? Thank you.
You have the floor, Professor Geraldo.
Thank you. So these are, thank you for your questions. Very vast ones, because on this matter, it's obviously not only about the EEZ. So regarding cables and pipelines, there would be a lot to say, so I'm afraid I won't be able to assess the whole question in just a few minutes. But I do think the regime is substantially insufficient because the threats regarding the cables and pipelines, especially the submarine cables, are different, diverse, and the dispositions as we have them right now don't take into account the diversity of actors, of activities that are needed into the installation, maintenance of those cables. So different reports, I mentioned the work of the International Law Association and the group dedicated to that issue. There were also, who's currently co-managed by Tara Davenport, who is here. And so there are already several reports, pre-reports that have been published. And so a third one, which is in its way. So hopefully such a work and also other ones will allow some reflections and some evolutions to that regard, which is of high interest, including for this region, including for the potential harms, intentional harms to the submarine cables in the Asia-Pacific region. Regarding of the due, I'm not sure I can answer it just like this to the question of due account and due regard, because it's such a big topic. I would just maybe comment that it's obviously a difficult notion to assess, and that the work of the International Judge has been crucial to that regard. And some clarification, further clarification will probably be needed. I don't know if some of my colleagues want to add something on this. No. Or maybe we can discuss this further.
Thank you. Let me thank my panelists for the wonderful presentation. But if I may say one or two words concerning the issue on insufficient provisions on regarding submarine cables. As you heard from previous speakers here, that UNCLOS is a constitution for the oceans. With respect to security threats to submarine cables, that can be addressed through international cooperation, using specific provisions or the umbrella, or even the preamble of UNCLOS, which talks about peace and security, to ensure that there is international peace and security. So you negotiate through international cooperation. That's why if you listen to what I just mentioned, 3 important themes run through the presentations: security, international cooperation, jurisdictional issues, sovereignty. These are the key issues or key themes that run throughout all the presentations. With respect to submarine cables, the only means for now that the international community should address that issue is through the negotiation of a protocol, like what we did with respect to the armed robbery at sea, the SWA Convention, and then you have also on piracy. So these threats could be addressed through negotiating another treaty under the umbrella of UNCLOS, because UNCLOS being the constitution of the oceans, we can negotiate an international agreement that UNCLOS subsumes for the implementation of any threats regarding the security of submarine cables. I think that could go a long way to address that issue. Just yesterday, I heard that there are issues of the cables lying between Finland and Europe. I'm sure most of you must have heard that. So the way to address these issues through international cooperation. It's very difficult to modify UNCLOS for obvious reasons. Maybe when attempts are made to modify it, what is there we may not come out with what is there already. Looking at the challenges we encountered in negotiating UNCLOS, so it becomes very, very difficult or cumbersome to make any attempt to modify UNCLOS. So that being said, let me thank you, esteemed panelists, and also participants for your enlightening contribution to our discussion on the EEZ. This discussion has underscored the complexities and opportunities surrounding this vital maritime concept. As we conclude this session, let us remember that the EEZ is a critical component of the law of the sea, balancing the interests of coastal states with those of other states. We must continue to work together to address the challenges arising from the EEZ, including environmental concerns, maritime security threats, and the need for international cooperation. So we need international cooperation in addressing any cumbersome issues within the EEZ. I thank you for your kind attention.
Thank you very much, Judge Kamara, and my gratitude to all of our panelists for the discussions. Ladies and gentlemen, please applaud all the speakers, including Judge Kamara for being a great moderator. And in the meantime, ladies and gentlemen, this concludes session 2, and we'll have a short break and before session 3 begins. Thank you. Ladies and gentlemen, may I have your attention, please? Session 3 will begin shortly at 4 p.m. So please come inside the hall and be seated. Once again, ladies and gentlemen, session 3 will begin shortly at 4 p.m. We'd like to ask all the participants to come inside the hall and be seated. Thank you. Ladies and gentlemen, may I have your attention, please? Session 3 will begin shortly. Please come inside the hall and take your seat. Once again, ladies and gentlemen, session 3 will begin momentarily, so please come inside the hall and be seated. Thank you. Ladies and gentlemen, session 3 will begin shortly, so please come inside the hall and take your seat. Once again, session 3 will begin shortly, so please come inside the hall and take your seat. Thank you. Good afternoon, ladies and gentlemen, and welcome back. Now, as the final session for today, session 3 will be conducted under the topic of the legal regime of the continental shelf. Her Excellency Ida Caracciolo, Judge of the International Tribunal for the Law of the Sea, will moderate this session. And Judge Caracciolo, please, the stage is yours.
Thank you. Good afternoon, everybody. From the outset, let me to thank deeply the Korean Ministry of Foreign Affairs and the Korean Society of International Law, which co-organized with UNCLOS this conference. And I also wish to thank them for their warm hospitality here in Seoul. I'm delighted to be back here in Korea, and I am also delighted to moderate this panel. Nearly 70 years after its creation, the continental shelf regime proves to be still controversial and it continues to fuel questions of interpretation and application that have been the subject of much commented jurisprudence and passionate, I must say, theoretical debates. Indeed, the semi-innovative origin of the continental shelf, its consuetudinary nature, its link, even if diverse, to the EZ on the one hand and the area on the other, and the framework structure of Part 6 devoted to the regime of the continental shelf are among the reasons at the basis of these never-ending controversies about the regime of the continental shelf. So I'm sure that the speakers and the discussants will have much to tell us and comment on such a thorny topic, and we will listen to them attentively to have more ideas and more food for thought. Well, without any further ado, I give now the floor to the first speaker, which is Professor Sir Malcolm Evans. He is principal of Regent's Park College in Oxford. Until 2022, he was professor of public international law at the University of Bristol, where he served also as head of the School of Law and dean of the Faculty of Social Sciences and Law. He is a well-known expert in the law of the sea and human rights law, and he operated actively in the fields of human rights law. He is also an associate member of the Institut du Droit International. Professor Sir Malcolm Evans, you have the floor.
Well, thank you very much, and it is a great privilege and pleasure to be here today, and let me add my thanks to the organisers of this wonderful event. I normally would at this say something about my thanks to the speakers which have gone before me, but I'm conspicuously not going to, because in many ways they have said much that I was planning to say. But I see this as, first of all, merely reinforcement and not in any sense, shall we say, going to prevent me saying what I was planning to say anyway. I'm particularly grateful that many of them have adopted the same approach as I am planning to take, which is to focus on the continental shelf from the three words that make up the focus of our conference here today, the then, the now, and the future. And I will use that as the frame as we move on. As regards the continental shelf, when is then? Well, as has been mentioned several times, although it is only 30 years since the entry into force of the Law of the Sea Convention, it reflects a consensus, and it's worth stressing, it reflects a consensus that was arrived back in 1982, so in some ways the then is about 40 years ago. But as we have been reminded by other speakers, if we project back only that same length of time, 40 years, before the conclusion of the 1982 convention, we find ourselves in 1942, in an era in which there was no real such thing as a regime of the continental shelf at all. For all practical purposes, the origin of the regime lies in the Truman Proclamation of 1945. When it was made, the Truman Proclamation, in truth, was a very unformed thing. It was a unilateral claim to jurisdiction and control over the natural resources of the seabed and subsoil of the areas of the continental shelf beneath the high seas but contiguous to the coasts of the United States. And with one or two other little bits and bobs, that was about it. Just about nothing of that was particularly clear, other than one thing: the purpose of the exercise, which was, in a nutshell, preserving and prudently utilizing natural resources. This presentation is not going to be a history lesson, other than to make this point. There has been nothing static about the continental shelf regime in the approximately 80 years it has been known to international law. The sketch found in the Truman Proclamation was elaborated on by the International Law Commission, and then, of course, the adoption of the 1958 Geneva Convention on the Continental Shelf only some 13 years later. And the core idea, perhaps unsurprisingly, of facilitating exploration and exploitation, in this instance of hydrocarbons, underpinned them both. The spatial extent of the continental shelf in 1958 was basically a combination of the best guess of the technological possibilities of doing so, coupled with a savings clause lest that proved inadequate. Then it was, by and large, all about exploitation. By the time of UNCLOS III, there was very much more at play than merely exploitation. And as a result, the continental shelf regime set out in the 1982 Convention is very different from that set out in the 1958 Convention. Indeed, it is not, in some senses, a regime of the continental shelf at all. The ICJ has only recently acknowledged it is about giving coastal states exclusive rights to resource jurisdiction to a distance of 200 nautical miles, and further again if geology, geomorphology and geography permit. In doing this, it is possible to argue that the 1982 Convention was possibly the single largest territorial land grab in modern history, if not in history at all. We may argue at length about the reasons for this, but ensuring a more equitable distribution of resource jurisdiction, both between states and the international community as a whole, in the guise of the area, and the common heritage of mankind, was certainly a dominant theme. But the package deal nature of the convention and the trade-offs that this brought made it difficult and ultimately unrewarding, I think, to go into this much further. The underlying point I wish to make is that access to and control over resources remained the dominant purpose of the exercise, but broader contextual and political factors shaped the manner in which that was done and resulted in a huge extension of coastal state jurisdiction over those resources and control. The underlying message then is that the new interests produced changed consensus and changed understandings of the continental shelf regime. So that was the then. What of the now? I'm something in a minority, certainly in this gathering and possibly well beyond it, in thinking that although the Law of the Sea Convention is described as a constitution of the oceans, it really isn't one. In a way, I think it would be helpful if it were. If it were a constitution, it would likely be more of a set of more general principles, a little like the freedom of the seas, which could then be more easily reimagined to take account of the changing times. But it is a treaty, a densely written one at that. And so when we want to work out what it is, we are faced with some difficulties and some tools that we have to work towards. If there's anything approaching universal consensus about anything to do with the Law of the Sea, it is that the Law of the Sea Convention is not going to be renegotiated en bloc anytime soon. And therefore, unless there is some sort of move to develop it, either through protocols, implementing agreements, etc., that we know of, then it is basically what it is, and therefore subject either to development by interpretation and, of course, through judicial and arbitral decisions. Against this background, I want to highlight some of the most significant issues that we currently face regarding the continental shelf. None will come as a surprise, but I will categorize them into two groups. First, I will consider as a part of what we could call the now question, because they are issues which I think can effectively be addressed and ought to be capable of being addressed within the current framework of the law of the sea and with the normal apparatus of the convention. But they are parts of the now which do, in my view, need attention. The first concerns the outer limit. At least for now, and whatever one might think of it, the International Court of Justice has settled the question of the relationship between the inner and outer continental shelf in the Nicaragua-Colombia case, when it determined that a claim based on natural prolongation beyond 200 nautical miles cannot intrude into a 200 nautical mile continental shelf, or EEZ, drawn from the baselines of another state. Personally, I think there is a good deal that's problematic about this decision, but I think the underlying principle is clear enough. It also means that the continental shelf is now a natural prolongation regime only in a spatial sense. In the real world, this means that states which have a continental margin extending beyond their exclusive economic zone are able to carve out for themselves resource jurisdiction in areas which would otherwise form part of the deep seabed and the common heritage of all states, but they are not able to carve out such a thing for themselves when it is within the jurisdiction of a single state. Arguably, the logic of this is open to question, but it is what it is, and at least for now there appears to be certainty. But what are the consequences of this? In practice, it is likely to shift attention to baselines from which the 200 nautical mile claims are made. Whilst in the context of maritime boundary delimitation, it has become more or less commonplace for courts and tribunals to adopt the baselines that they think are most salient for their matter in hand. It may prove very much more difficult to do this in future, because what one will really be doing at the initial phase is determining where the overlap of entitlement of what to be delimited is. So, I think for the purposes of understanding the continental shelf regime moving forward, there is going to have to be, perhaps paradoxically, a much greater focus on the detail of law relating to baselines. This isn't a bad thing, but I think it is one of the things we were going to have to see. Determining that outer limit remains as frustrating a task as ever. We all know that the Commission on the Limits of the Continental Shelf has a ferocious backlog that means that its recommendations can often take very many years to emerge, and recent research has also cast some doubt on the efficacy of that process too. On the whole, the recommendations that are adopted by states up front tend to be those which reflect the submissions made rather than those do not. But this then also has knock-on consequences for the delimitation of maritime boundaries. It also has consequences for understanding another problem, the generative capacity of maritime boundaries. It took a very long time for Article 121, subsection 3 of the Convention concerning the generative effects of rocks which cannot sustain human habitation or a life of their own to be considered customary international law. there is still, in my view, relatively little consensus about what those provisions actually means. Of course, we have the South China Seas arbitration case, but there is still controversy around that and how that may be applied in future cases. I think for me, one of the things that it may still be necessary to go back to consider are questions of that old-fashioned question of size. An island of sufficient size will not be deprived of its capacity to generate the full suite of maritime zones, even if, in the context of delimitation, they do not receive their full entitlement. But when we are talking about small features, then they should only be entitled to generate broader zones of maritime jurisdiction if they have a significance perhaps greater than their size might suggest. And it makes perfect sense to judge this in terms of some of the criteria which we know from the Convention and the arbitration. But whether that test should apply to all islands, irrespective of all other factors, is possibly a question that still needs some reflection on. And indeed, we have seen in other recent incidents of late that importance of small island features may not only be measured in terms of their economic significance or whether they can sustain human life or habitation. As we now all know, the strategic importance of small island features can be very important indeed, and in the real world influences the way that states respond to situations and their actions. Whether this is something that we also need to take into account is another question to reflect on. As time is short, there is more I could say about other matters, particularly the need to think perhaps a little bit more, again, about the difference between low tide elevations and islands. Other speakers at some length, and rightly, have focused on the effects of climate change in relation to these matters, and whether or not there should be such a marked disparity of impact upon about whether something is a low tide elevation or an island in what is so difficult a set of circumstances as around determining whether something is one or the other. And of course, with the changes that are afoot, again, is a question that we might wish to reflect on over time. These may all seem somewhat tangential questions as regards the continental shelf, but I don't think they are. We really do need to know what the basis of entitlement is, and thus to what areas states are entitled. It's as simple as that. And then, of course, we get on to boundary delimitation. I was never not going to mention maritime boundary delimitation, as this remains a topic which generates still a considerable numbers of controversies. Arguably, the principles are now surprisingly straightforward. The difficulty is applying them to the facts of the various cases. What I think I would like to do is just highlight a couple of the problems associated with maritime delimitation, which really are problems which still, in my view, need to be solved. The first concerns determining the extent of overlapping zones. This ought to seem a very straightforward pastime. All the points previously made in relation to determining outer limits of the generative capacity of maritime features, however, indicate that this may not be so. So these are matters which, again, need some reflection. The second is a product of the interplay between the work of the Commission on the Limits of the Seas and the process of boundary delimitation between states itself. You cannot know for certain that a state has an entitlement to an outer continental shelf until the state concerned has established its outer limit on the basis of CLCS recommendations. And we have heard this morning, so I will not repeat, the issues that we now have and the approaches of courts and tribunals to navigate the problems caused by the lack of such recommendations in a timely fashion, or the ability of parties to request that decisions are not made on these submissions because they may trench upon a maritime boundary dispute between them. The idea of significant uncertainty is, as has been highlighted, a useful way forward here, but what this ultimately does is perpetuate uncertainty into an area where clarity over time is needed. And it is not entirely sure how that is going to be practically resolved in the timeframes we would wish. And then we have another practical problem, which I think flows from the Nicaragua and Colombia case on the process of maritime boundary delimitation, and this concerns grey areas. I'm fortified by the comments of President Haider this morning, who not only has explained grey zones, and so avoiding me the need to do so, but also for his pointing out that one of the difficulties that we have as a result of the Nicaragua-Colombia case is that it could lead to a situation in which, if you shift an equidistance line, we end up with a really rather strange result. It may be that grey zones are incompatible with the statement of principle set out in that case, that a state cannot exercise jurisdiction over an area of continental shelf more than 200 nautical miles from its own baselines, but within 200 nautical miles of another coast, because this is precisely what anything other than an equidistance line, once it is moved, actually produces. And so once again, I think there is something fairly fundamental that we have to think of about how we apply this in the context of maritime delimitation cases moving forward. 'Twas ever thus. Problems arise, problems need to be solved. Perhaps they can all be done within the envelope of the Law of the Sea Convention, but what from this short list that we can see is that the idea after 30 years of jurisprudence we have perhaps a clearer understanding of the detail of the regime is possibly misplaced. If anything, we have at least as many problems than we had before, and perhaps more than we actually thought likely at this point. But what of the future? Well, it follows from what I've said that if there are some issues which I think can be addressed from within the current regime of the continental shelf, then there may be others which possibly cannot, or even if they can, arguably ought not. The Law of the Sea Convention was designed for a purpose, as I indicated earlier, but maybe, just maybe, the underlying purpose and rationale of what we are looking for from the Law of the Sea Convention in relation to the continental shelf is actually changing. Look at the things which other speakers have already said about what the interests here are. There are a number of different competing tensions. First of all, we have the old point about wanting to secure the stability of boundaries. It's always been important to the Law of the Sea, and certainly it has been a factor militating against the opening up of settled boundaries in the light of new information, facts or concerns. Is this going to remain the case into the future when new issues or new concerns come into play, or is the stability of boundaries so fixed in our minds that it just becomes what it says? Fixed. Things do change, though perhaps fortunately in relation to some changes the obligation not to recognize consequences of illegal acts may delay the need to revisit some of these changed circumstances. But others, that is not true of. Look at many of the points which others have already touched upon today. And then the entire history of the continental shelf regime, in fact, has been one of radical instability, not of stability, as regards its outer limits and the extent of maritime claims themselves, the basis of title, All these things have changed quite majorly over the relatively short life of the regime. States which previously had no overlapping claims suddenly find that they do, as a result of changed understandings. New problems arise. And one of those, relating to stability of boundaries, has been the debate over, for example, whether baselines are ambulatory or whether they are not. There is certainly debate about now. Of course, the logic of the convention might suggest that such baselines are ambulatory. The low or low water line is obviously ambulatory. Let's face it, it does so twice every day. So why do we say that it isn't? At what point, however, is it to be fixed? And we have our rules in order to do that. And they are logical, and they make sense. But if one's claim becomes so divorced from the basis of title and of reality, do they continue to make sense into the future? There are indeed arguments either way on the question of ambulatory baselines, but the point about the debate today is it really about baselines in the law of the sea, whether they should or whether they should not ambulate, or whether it is about something else altogether? Whether it is about climate change, whether it and the effects on small island states, for example. And if so, is the answer to those questions rightly to be distilled from thinking only of the law of the sea? If, as some speakers have pointed out, we may have a situation in which entire states disappear under the waves, the idea that this has no consequence or impact, for example, on the idea of statehood, recognition of statehood, continuity of statehood, and a whole host of other things is difficult to imagine. Not all problems which manifest at sea are necessarily problems of the law of the sea, and looking only to the law of the sea as a means to solve them is not necessarily the best way to proceed in all instances. As time is nearly up, I will just very briefly highlight a few other of the main challenges which have already been flagged as things that we need to address. Security. Boundaries are all about limits and who can do what where, and the security of one's territory is paramount. Our first speaker today showed that the capacity of states to exercise security over activities taking place within its continental shelf is in fact surprisingly limited. And we have heard only in the last session about some of the broader security concerns that are now resulting as strategic attention shifts more towards the continental shelf from a strategic rather than a purely economic point of view. The use of the continental shelf for military purposes has ambiguity enough, but now add to that what we know about the provisions concerning cables, pipelines, etc., which have been already amply and eloquently described today in terms of the fundamentals of infrastructure. And as regards, without wishing to make any assumptions about what underlies the severance of the cables only today between Finland and Germany, it is also just the case that very major military exercises are now taking place in Finland as a NATO country. If there is a problem in relation to the severance of those, can we be sure it is simply a law of the sea problem, or is it bound up in other things as well? But the need to be able to protect increasingly vital infrastructure on the continental shelf is apparent and growing. We do need to think about that. Is the way to do, what factors do we need to take into account as we settle that? Are they only to be those pertinent to the law of the sea, or more besides? And in a nutshell, as I come to conclude, what we can see is the overall changing nature of the interests that states have in the continental shelf. This fundamental change, it has broadened from being largely concerned with the exploration and exploitation of hydrocarbons towards interests, first as regards other resources, other economic uses, and now to entirely different uses: underwater carbon capture, cool storage. There are also changed strategic priorities, and of course heightened interest in decarbonisation, preservation of the marine ecosystem, and so on. All things which 80 years ago would have probably confused and bemused many of those who fashioned the regime as we know it today. So, where does this leave us? Finally, to return to the more overarching approach of my opening observation, we may now need to ask again what the continental shelf regime is actually for, or more precisely, whether it currently is for, what it is currently for, and effectively reflects what the international community wants it to deliver into the future. The regime only exists because it was created to achieve a regulatory purpose. It was never an end in itself. And if we now need it or want it to be different, then perhaps we ought to think about it holistically. Given that all states now have a 200-mile continental shelf and an entitlement to a 200-mile exclusive economic zone, it may be, as an earlier speaker hinted, we may not need the continental shelf regime at all. I think we all know why we have it. When this was put into place in the convention, there were still powerful arguments from those broad shelf states that wished to have more. Would we still accept that today if those negotiations were taking place? I don't know. Whether that is still a desirable, as desirable a purpose as it once was, is, I think, increasingly debatable. If we think, therefore, about what we see, there is a real danger that we end up, arguably as I have just done, spending too much time and energy addressing what we could call the now questions, because they can be addressed, rather than thinking of new ways of addressing the future questions. Back in 1945, the continental shelf was a now answer, a new answer to a future problem. Today, we are wrestling with the problems now posed by those, frankly, then solutions. What we need to do is to seek what we could call now solutions to the future problems. But basically, this is all proving rather difficult. And it could be that the continental shelf regime, as currently understood, simply may not be able to provide them in the way that we wish. But if that is the case, then we will just have to accept that and do the best we can with what we have. Thank you.
Thank you, Professor Sir Malcolm Evans. In an ideal world, maybe the law would have been carved in stone, but unfortunately or fortunately, we live in a real world, so there is a continuous tension between human behaviors and laws, trying one to overcome the other and vice versa. Thank you for this overview, critical and evolutive on the regime of the continental shelf. And now it's the turn of our second speaker, which, on the contrary, will focus on recent developments concerning the legal regime of the continental shelf. Our next speaker is Professor Bjorn Magnusson of the Bifrost University in Iceland. In this university, he is the Dean of the Faculty of Law. Professor Magnusson is deeply involved in studies, but also in active engagement, and in particular, he has recently been appointed to the Iceland Climatic Council and participates in the Icelandic government government's working group tasked with preparing submission to the Commission on the limits of the continental shelf. So he's an expert since many years of the outer limits of the continental shelf. Please, the floor is yours, Professor Magnus.
Thank you for the introduction. Excellencies and distinguished guests, I want to express my deepest gratitude to the organizers for inviting me to participate in this esteemed event. Their dedication and careful attention to detail have clearly created an outstanding platform for discourse on some of the most pressing issues in the international law of the sea. I'm particularly honored to be part of this distinguished panel with world-leading experts in the field, including my longtime friend and colleague, Ki-Bom Lee. Our professional and personal journey began during our PhD studies under the guidance of Professor Alan Boyle at the University of Edinburgh about 15 years ago, with Ki-Bom specializing in maritime boundaries and myself focusing on the delineation and delimitation of the continental shelf beyond 200 nautical miles. This event not only fosters critical discussions, but also renews bonds that have shaped our careers, and I'm truly thankful for the opportunity to be here. Although my recent professional efforts have been focused on leading a faculty and working on the merger of two universities in Iceland, I'm confident that I still can contribute meaningfully to today's discussion. My presentation builds on ongoing collaborative work with Colter Lathrop and Kevin Baumert. I need to note that Mr. Baumert is collaborating with us in his personal capacity, not as a US governmental official, and I should probably say as well that I'm here as myself, and I do not represent anything else. But together, we are developing an analysis of recent developments concerning the continental shelf beyond 200 nautical miles. As many of you know, the judgment of the International Court of Justice from 13 July 2023 in the maritime delimitation case between Nicaragua and Colombia has generated substantial debate regarding the legal relationship between the exclusive economic zone and the continental shelf, prompting questions about the evolving principles that govern maritime boundary delimitation. In essence, the question is about the role of the 200 nautical mile limit in maritime boundary delimitations concerning the continental shelf. In its judgment, the ICJ held that under customary international law, a state's entitlement to a continental shelf beyond 200 nautical miles from the baselines from which the breadth of its territorial sea is measured may not extend within 200 nautical miles from the baselines of another state. Referring to continental shelf beyond 200 miles as extended continental shelf, the court further elaborated that even if a state can demonstrate that it is entitled to an extended continental shelf, that entitlement may not extend within 200 nautical miles from the baselines of another state. Thus, the continental shelf within 200 nautical miles, along with the waters above that are part of the exclusive economic zone, it takes precedent over any extended continental shelf entitlement according to the court. With this legal determination, the court resolved the case in Colombia's favor. At the same time, the court introduced uncertainty into small but important continental shelf entitlements across the globe. Dissenting and separate opinions reveal divergent perspectives from the majority, indicating that the ICJ ruling may not fully align with established theories and prevailing international practices. In my presentation here today, I'm going to deepen some of the comments Professor Evans made, and I'm going to argue that the court's holding is not an accurate reflection of the current state of customary international law. My focus will be on the evidentiary basis of the court's judgment, including with reference to the continental shelf announcement made by the United States in December 2023, which postdated the court's judgment by 5 months. So, in December 2023, the United States, a non-party to UNCLOS, announced its extended continental shelf outer limits in 7 different regions. The legal basis for this announcement was customary international law. In 3 of those regions, the Bering Sea, Arctic Ocean, and Atlantic Ocean, the United States asserted extended continental shelf within the 200 nautical mile limits of a neighboring state. These areas are depicted in the maps on the screen. Although these areas are small, they are nevertheless inconsistent with the court's July 2023 holding. In considering the broader state practice pertinent to the court's holding, it is useful, or can be useful, to split the relevant practice into 2 categories. First are assertions of extended continental shelf, like the one made by Nicaragua vis-a-vis Colombia, namely assertions that are major intrusions into the 200 nautical mile zone of a neighboring state. For convenience, we call these type 1 assertions of extended continental shelf. Aside from Nicaragua, there appear to be only 3 other such examples worldwide: China and the Republic of Korea, both vis-a-vis Japan, and Somalia vis-a-vis Yemen. I will come back to this category after I address what we can call type 2 assertions of extended continental shelf. Type 2 extended continental shelf assertions are more minor in nature. These situations are typically apparent in maritime boundary delimitation contexts, where neighboring states have either already established a maritime boundary that is not based on equidistance, or alternatively have not yet established a boundary. The US examples that I have shown on the maps are type 2 extended continental shelf assertions, and how these situations arise is instructive of broader global practice of states. In the Atlantic Ocean, the area marked 1 on the map on the screen is an area of US extended continental shelf within 200 nautical miles of Canada's baselines. It lies seaward of the existing US-Canada maritime boundary, which was established by a chamber of the ICJ in 1984 in the Gulf of Maine case. That existing boundary, which terminates 200 nautical miles from the US coast, is not equidistant from the coast of the United States and Canada. And the 2 countries have not yet agreed on a boundary in more seaward areas. Area 1 arises because of 2 factors. First, the existing non-equidistant boundary, and 2, the manner in which the 2 countries have delineated their extended continental shelf limits seaward of that boundary. The United States delineated its extended continental shelf by extending the existing boundary in the seaward direction along its same trajectory. For its part, Canada used an equidistance line as its lateral limit with respect to the United States. As a result, an area of US extended continental shelf extends within 200 nautical miles of Canada. In the Arctic and Bering Sea regions, areas 2 and 3 lie on the US side of the US-Russia maritime boundary agreed in 1990. Those areas are nevertheless within 200 nautical miles of Russia's baselines. Type 2 extended continental shelf assertions are commonplace. Indeed, several more are visible in the map on the screen. Area 5 is an area of Russian extended continental shelf that is within 200 nautical miles of the United States. Of note, this area lies within Russia's continental shelf limits that were reviewed and favorably recommended upon the Commission on the Limits of the Continental Shelf in 2002. Neither that extended continental shelf nor the CLCS recommendations have been questioned. These Type 2 extended continental shelf assertions are appropriate in the context of boundaries that have either already been concluded, like US-Russia, or not yet concluded, that is US-Canada. Additional Type 2 extended continental shelf assertions abound worldwide. In the Americas and the Arctic, for instance, they have been made by Argentina, vis-a-vis Chile, Brazil, vis-a-vis both France or French Guiana and Uruguay. And Russia, vis-a-vis Norway, as you can see here, and Uruguay, vis-a-vis Argentina. In many cases, it's not entirely clear based on the geography where a state is making a Type 2 assertion. This would include France extended continental shelf vis-a-vis Canada and Venezuela's vis-a-vis Barbados. A full global review is beyond the scope of this presentation, but the point is that these situations are not necessarily unusual or extraordinary. Type 2 extended continental shelf is also evident in decisions of international courts and tribunals, as President Haidar mentioned previously today, including in the 2 cases in the Bay of Bengal decided under the Convention's dispute settlement procedures. In its 2012 judgment, the International Tribunal for the Law of the Sea established a boundary between Myanmar and Bangladesh that resulted in an area of Bangladesh's extended continental shelf within 200 nautical miles of Myanmar, that is within Myanmar's EEZ. Similarly, in 2014, an arbitral tribunal in a case between Bangladesh and India established a boundary that resulted in an area of Bangladesh's extended continental shelf within 200 nautical miles of India. In both cases, the tribunals referred to these as gray areas and importantly affirmed the continental shelf entitlement of Bangladesh in the gray areas, notwithstanding the location within the 200 nautical mile EEZ limits of neighboring states. In its 2021 judgment in the maritime delimitation case concerning Somalia and Kenya, the ICJ noted the possibility of a gray area within which Kenya might have extended continental shelf entitlement within the EEZ of Somalia. Although the court's July 2023 judgment binds only the parties to the case, its holding declared a rule of customary international law. If this rule is correct, it would preclude not just Type 1 extended continental shelf, but also Type 2. The view of the court that the state's extended continental shelf entitlement may not, as a matter of law, extend within 200 nautical miles of another state is incompatible with gray areas and all Type 2 extended continental shelf assertions. What makes the court's holding especially puzzling is that the court seemed untroubled by Type 2 extended continental shelf assertions. The court's discussion of the Bay of Bengal cases is telling in this regard. According to the court, those cases are of no assistance with respect to the case concerning Nicaragua and Colombia. The court dismissed these Type 2 situations as incidental results of boundary delimitation. Although this may be true with respect to the gray areas, the gray area itself can only exist if Bangladesh has extended continental shelf entitlement in the first instance. Boundary delimitation, as UNCLOS stated in its 2012 judgment, presupposes an area of overlapping entitlements. A boundary divides overlapping maritime entitlements. Those entitlements do not arise from the creation of a boundary. In reaching its customary international law conclusion, the court referred to the state practice of both convention parties and non-parties. The treatment of both groups of states appears problematic. With respect to convention parties, the court states that the vast majority of states parties to the convention that have made submissions to the CLCS have chosen not to assert therein outer limits of their extended continental shelf within 200 nautical miles of the baselines of another state. This means that the ICJ interpreted submissions to the CLCS as evidence that states do not assert extended continental shelf rights within another 200-mile zone. Yet, I must caution against seeing this as proof of customary law. It is highly likely that some states avoid such claims not out of legal obligation, but rather due to political sensitivities or strategic reasons. Even assuming that submissions to the CLCS, which pertain to a treaty-based procedure or probative of the existence of a rule of customary international law, the court's focus on extending continental shelf outer limits is misaligned with its holding, which pertains to extending continental shelf entitlement. The two are not the same. The court seems to assume that if a state's extended continental shelf outer limits do not encroach within 200 nautical miles of another state, then neither does its extended continental shelf entitlement. The US and Canada examples I mentioned previously are illustrative of how this is often not the case. Neither country asserts extended continental shelf outer limits within 200 nautical miles of the other, but both assert areas of entitlement within 200 nautical miles of the other. A more fulsome geographic evaluation, including with respect to the inner limits and lateral limits of a state's extended continental shelf, is needed to determine whether extended continental shelf entitlement is asserted within 200 nautical miles of a neighboring state. This is tedious work, but when it's done, a large body of state practice, specifically Type 2 extended continental shelf assertions, can be identified that raises doubts about the rule of customary international law identified by the court. With respect to non-parties, the court states that among the small number of coastal states that are not states parties to the convention, the court is not aware of any that has claimed an extended continental shelf that extends within 200 nautical miles from the baselines of another state. Searching for claimed extended continental shelf presents an evidentiary conundrum, since under both treaty and customary law, entitlement to continental shelf need not be expressly claimed. This is clear from UNCLOS and the ICJ's North Sea continental shelf case. Even leaving this aside, the court seemed to overlook the practice of two non-parties, the United States and Venezuela. Long before the court's 2023 judgment, Venezuela and the United States had each made its views known to the international community, that it is entitled to extend the continental shelf on the basis of customary international law. Given Venezuela's repeated assertions of extended continental shelf entitlement, along with its maritime boundary with Trinidad and Tobago that extends beyond 200 nautical miles, it would be difficult for Venezuela's extended continental shelf entitlement to not reach within 200 nautical miles of Barbados. The US extended continental shelf announcement of December 2023 indicated that whatever assumptions the courts may have made regarding how the United States views its extended continental shelf entitlement were not correct. Whether framed as claims or not, the United States and seemingly also Venezuela, have asserted extended continental shelf rights within 200 nautical miles of neighboring states. The identification of a rule of customary international law must be predicated on evidence of the general practice of states undertaken out of a sense of legal obligation. The view that the community of states has accepted a legal rule that precludes an entitlement to extended continental shelf within 200 nautical miles of another state, and that states have conformed their practice accordingly, is not well established and supported by the evidence. Type 2 extended continental shelf assertions appear to be commonplace and generally accepted by states, including by 2 international tribunals. Understanding this practice of states requires a deep dive into the geography of each state's assertion of extended continental shelf, and not merely an examination of CLCS submissions or express claims. It is perhaps more understandable that the court was troubled by Nicaragua's extended continental shelf assertion. Like other type 1 extended continental shelf assertion, it is bold, and someone would even call it unneighborly. Perhaps it is also unlawful. If it is, however, it is likely due to a rule of customary international law that differs from the one pronounced by the court. One of the consequences of ICJ's decision is that it opens a new chapter for the disputes in the East China Sea. Arguably, ICJ's ruling puts constraints on the states involved to assert continental shelf rights beyond 200 nautical miles within another state's 200-mile limit, in the sense that one party can always refer to the ICJ judgment to back up its position. One could argue that the ICJ's decision enhances predictability and provides further clarification of the legal regime governing the continental shelf beyond 200 nautical miles. While this may hold some truth, such a development must be underpinned by sound and robust legal reasoning. It is worth recalling that during the third United Nations Conference on the Law of the Sea, numerous states advocated for a connection between the 200 nautical mile limits of the EEZ and the continental shelf. In this context, it is reasonable to view these judgments as a step toward that alignment. Furthermore, from a broader perspective, this decision can be seen as yet another shift away from the concept of natural prolongation, or as Professor Evans called it, half-death of natural prolongation. So, to sum up what I've been saying here today, the ICJ's determination on customary international law lacks a strong theoretical foundation and is not adequately supported by state practice, which does not substantiate the conclusion that a coastal state is prohibited from extending its continental shelf rights beyond 200 nautical miles from its baselines to overlap with the rights of another coastal state within that range. It would be highly interesting to observe how UNCLOS might approach the same question previously addressed by the ICJ, should the tribunal have the opportunity to consider it in the future. Thank you all for your attention and for allowing me to share my and my colleagues' thoughts and insights. I look forward to the upcoming panel discussion and to hearing your valuable perspectives on these important issues. And I look especially forward to hear Sir Michael Wood disagree with everything I said. Thank you very much.
Thank you, Professor Magnusson, for your in-depth analysis of the last ruling of the ICJ in the case Nicaragua versus
Colombia? Well, I don't know. I don't want to enter into predictability of what Michael Wood will say, but I will limit myself to present our first discussant, and which is King Counselor and barrister at 20 Essex in London, where he practices very actively the field of public international law. He was legal advisor to the UK Foreign and Commonwealth Office, and he was a member of the UN International Law Commission. Sir Michael Wood, the floor is yours, please.
Well, thank you very much, Madam Chair. Like others, I'd like to thank all the organizers for the invitation to this excellent conference, and also all those who've been working very hard here in Seoul to make it run so smoothly. Like others, I'd like to make it clear that I'm not speaking on behalf of anyone other than myself, certainly not on behalf of any clients I may have or have had, including Colombia, who were very successful in the last case that Nicaragua brought against them. I'd very much like to thank our two speakers for their very rich and thought-provoking papers. And Professor Magnuson is right. I'm going to disagree with almost everything that he, but also that Sir Malcolm Evans said. I think they've raised very interesting questions about what I shall still call the regime of the continental shelf, subject to Malcolm's views on that, of course. I do think, I agree with Malcolm Evans that it's wrong to refer to, or it's not helpful to refer to UNCLOS as a constitution for the oceans, except in rhetorical terms. I don't think it brings anything legal to the picture. I do, however, find it useful to refer to it as a living instrument, despite the fact that that term is much hated in the United Kingdom by all those, and there are rather many of them, who are opposed to the European Convention on Human Rights. But it's a useful concept in this context. Professor Evans, to begin with him, seems to accept, perhaps reluctantly in some respects, that the current law on the continental shelf is reflected in the Convention, including in particular Part 6. That's obviously the case as between the states parties to UNCLOS. I think it's broadly the case that the law reflected in UNCLOS applies as between and with non-parties as customary international law, as international courts and tribunals have consistently held. And I think that we can leave aside, because it very rarely will occur, what's the law applicable is between those few states who are not parties to UNCLOS but remain parties to the 1958 Convention on the Continental Shelf. Though there again, I think a case can be made for concluding that the 1958 Convention has been in many respects superseded by the international law reflected in UNCLOS. Professor Evans seems to accept that there is not going to be an amending or implementing agreement on the continental shelf, completely upending it, though that seems to be what he would like to achieve, or at least he foresees might be necessary. He concludes from this that, to use his words, we have to work within the framework that the treaty, that the convention provides, subject to interpretation. I would actually put it rather more directly. In my opinion, we as lawyers should acknowledge that the law is as set out in the convention, which has to be interpreted in good faith in accordance with the Vienna rules, and that was discussed in the earlier panel today. Professor Sir Malcolm Evans then refers to what he calls some of the most significant issues that we currently face regarding the continental shelf. And I'm not convinced that we do necessarily need to face all the issues that he refers to under his heading Now. In an ideal world, perhaps, and he does not seem to challenge the ICJ's decision of 2023, even if he may not be totally impressed by the court's reasoning. Professor Evans makes the valid point that the court's 2023 decision may shift attention to the baselines for measuring maritime zones. But he goes on to suggest that greater clarity on baselines would doubtless be welcome. I'm not so sure that greater clarity is needed in the provisions of Section 2 of Part 2 of UNCLOS, a part, that is, from the question raised concerning whether baselines are static or ambulatory. The general law on baselines seems to me to be pretty clear, as Judge ad hoc McRae demonstrated in some detail as regards straight baselines in his dissenting opinion in the 2022 alleged violations case between Nicaragua and Colombia. Nor am I convinced that we should try to clarify the meaning of Article 121, paragraph 3, on rocks which cannot sustain human habitation or economic life of their own. That is a question that arises relatively rarely in practice. Even in delimitation cases, it can usually be avoided, as was done in the Black Sea case. So when the issue does arise, solutions are usually found. To seek to refine the meaning of Article 121, paragraph 3, in the abstract might, I suggest, prove fruitless, and it might even provoke disputes. The question of such rocks potentially raises very sensitive matters for quite a few states. This may be one of those cases where matters are best left unclear. The same goes, I would suggest, for the definition of low tide elevations and some of the other matters that he refers to under the heading Now. I think these are largely issues that can be resolved by one by one as necessary. Nor do I agree with what Professor Evans said about grey areas. As I'll explain when I come to Professor Magnussen's paper, I do not, in fact, read the 2023 Nicaragua-Colombia judgment as complicating the issues of grey areas. What I suggest risks complicating the matter is to misread the judgment. I don't have a great deal to say at this stage about the issues raised by Professor Evans concerning the future. I would suggest that most of these problems, such as protecting cables and pipelines at sea, can be resolved within the existing framework of UNCLOS, the living instrument. The convention has shown itself to be very adaptable. Minister Kang this morning referred to, and I agree, the convention's resilience and enduring relevance. I agree with what Professor Lalonde said in her approach earlier this afternoon. Any adaptation, of course, has to be done with a good understanding of the law of the sea and to go with the grain of the convention, as my colleague David Anderson likes to put it. We do not need to address the questions that Professor Evans has pointed to with a sledgehammer or have some kind of bonfire of existing rules. I'm not suggesting he was suggesting that, but I rather got that flavor. So I've left myself a little time to address Professor Magnussen's paper, which he's looking forward to, I think. I disagree quite strongly with his thesis. I found his differentiation between type 1 and type 2 cases of overlap very helpful. But it seems to me that that's precisely what the ICJ was doing in the 2023 judgment, though perhaps it could have done it more clearly. the 2023 judgment seems to me to be noteworthy for at least 3 reasons. Firstly, procedurally, in an unusual, controversial, but very effective procedure, the court ordered, just 2 months before the hearing that had already been scheduled on the merits, that the parties should limit their arguments exclusively to 2 legal questions about customary international law. Of course, I was delighted. In the event, the court only needed to answer one of the questions. The procedural decision was controversial, but I think it proved to be of great advantage. It considerably simplified the oral phase of the case. The order with the procedural decision was adopted without dissent, though there was an important joint declaration by 5 members of the ICJ raising questions, indeed strong doubts, about what they were agreeing to. However, in his own declaration, Judge Abraham very helpfully explained in detail why this was a sensible procedural decision in this case. That's the first interest of the judgment. Secondly, in the event the court only found it necessary to answer one of the 2 legal questions it had posed, and the precise question, I'd better read it out. Under customary international law, may a state's entitlement to a continental shelf beyond 200 nautical miles from the baselines from which the breadth of its territorial sea is measured extend within 200 nautical miles from the baselines of another state? And its answer to that question ended the case in Colombia's favor. I would point out that Nicaragua accepted the judgment on the very same day that it was given, so it resolved the issue as between the parties. The court's clear response to this one question has led to some strong criticism, including from dissenting judges on the court, and including to some extent from Professor Evans, but especially from Professor Magnuson today. Criticism in Professor Magnuson's case, both as to the substance and as to the methodology, or the application of the methodology for identifying customary international law. And I don't agree with these criticisms. The main substantive criticism is that the judgment raises doubts about what Professor Magnuson refers to as type 2 grey areas. That is the generally small, incidental, overlapping grey areas that are inevitably created when the equidistance line between adjacent states, as in the Bangladesh-Myanmar UNCLOS case, and also in the parallel Bangladesh-India arbitral award, those are the type 2 grey areas. The type 1 grey areas, which Professor Magnuson admits are very rare, are of the kind at issue in the Nicaragua-Colombia case, where with 2 opposite states, a potential or possible extended continental shelf might, whether it can encroach upon the 200-mile exclusive economic zone continental shelf of the opposite state. And if it did encroach, that would be a grey area, which could indeed be a large grey area. I think to focus on the precise formulation of the court's first question, and just on the wording of its answer to that question at paragraph 79 of the judgment, is too narrow an approach. The court's answer firstly, that answer at paragraph 79 is part of the court's reasoning. It's not part of the dispositif. The dispositif is quite specifically only about the issue between Colombia and Nicaragua. But more importantly, I think the court's answer to the legal question has to be read in the light of the detailed arguments made by the parties in writing and orally, and more importantly, the text of the whole of the 2023 judgment as a whole. If you look at this, at the legal arguments, the judgment as a whole, it seems to me clear beyond doubt that the court was in fact only intending to address what Professor Magnussen has called the Type 1 case. As he indicated, in the 2023 judgment, the ICJ does refer to the two Bay of Bengal cases. Indeed, it refers to them at some length over a number of paragraphs. But its key conclusion for present purposes was, and I'll quote from paragraph 72 of the 2023 judgment, the court said, in the two Bay of Bengal cases, the use of an adjusted equidistance line in a delimitation between adjacent states gave rise to a grey area as an incidental result of that adjustment. The circumstances in those cases are distinct from the situation in the present case, in which one state claims an extended continental shelf that lies within 200 nautical miles of the baseline of one or more other states. The court considers that the aforementioned decisions are of no assistance in answering the first question in the present case. I don't think it could have been put clearer. And I'm surprised at the interpretation that's been put upon this judgment in this case, casting doubt on the earlier judgments of the UNCLOS and the Arbitral Tribunal and the court itself, perhaps, in the Kenya-Somalia case. Of course, I note that the separate and dissenting opinions of certain judges disagreed with the court, but that's normal. But I don't think that casts any doubt on the way we should read the judgment of the court. If anything, as is so often the case with dissenting opinions, they actually strengthen the decision of the court by pointing out what wasn't adopted. That strengthens the majority view. So I don't find that an argument for having the doubts that have been expressed today. Similarly, I think that the very carefully and I think judiciously drafted US announcement of its extended continental shelf claims of December 2023, I don't see that that in any way affects the view that one has of the court's judgment of earlier 2023, except, again, perhaps to strengthen the interpretation which I would have of it, because the US ignored that case as regards Type 2 decisions. It did not in any way act in a way that disagreed with what the court had done as regards what you call Type 1 decisions. And now I've only got 17 seconds left. So this is the most interesting point for me, which is whether the judgment misapplied the proper methodology for determining a rule of customary international law. I do think the law of the sea is a laboratory for understanding customary international law. It always has been. And I find this judgment a very helpful judgment in that respect. Paragraph 77 has been criticized, but even if that criticism were right, quod non, as Professor Pelle would say, it would hardly affect the authority of the court's conclusion as to the law, which, as I think Professor Magnussen has accepted, is a clear and practical solution for Type 1 cases. I think the ICJ did make useful contributions to the methodology for determining rules of customary international law in this case. For example, when it said that the practice of states before the CLCS is indicative of opinio juris, even if such practice may have been motivated in part by considerations other than a sense of legal obligation. That's a useful clarification as to the subjective element of customary international law. Another useful clarification is to be found where the court said that, taken as a whole, the practice of states may be considered sufficiently widespread and uniform for the purpose of identification of customary international law. In addition, given its extent over a long period of time, this state practice may be seen as an expression, of opinio juris, which is a constitutive element of customary international law. And the court went on, indeed, this element may be demonstrated by induction based on an analysis of a sufficiently extensive and convincing practice. That's an important statement, a modern statement from the court, which I think is helpful, showing the flexibility in the discovery, the identification of customary international law. It was quoting the Gulf of Maine case, but that was a chamber decision. This is a much more recent decision by the full court. Madam Chair, that concludes my remarks, and I really do thank our two speakers for their stimulating papers. Thank you.
Thank you very much, Sir Michael Wood. I won't, of course, enter in analyzing the ICJ ruling. What I think that we are in the middle of a movie. So we are, let's say, envisaging the end of this spy story, which is not yet ended. So we need to wait future developments, and future judgments might provide us with more information about which interpretation is more founded, the critical one with regard to the ICJ judgment, or that of a sort of compatibility between all judgments so far adopted on the issue of delimitation of the outer margin of the continental shelf, when the overlapping concerns, of course, an inner continental shelf. There is also this, I think, creeping idea that there is a sort of if the claim for an outer continental shelf are with willingness aimed at obtaining a big part of continental shelf against the claim on an inner continental shelf advanced by another state, this is a situation when there is no willingness, but it happened because of the geographical situation in a specific case. The situation is a completely different one. I don't know, but I think we need to wait how case law will develop, starting from these apparently opposing judgments we have so far in front of us. So I give the floor to our last discussant, Professor Lee Kim-beom. He is associate professor at Yonsei Law School, and he has had taught public international law, however, in various universities, Seoul National University, the Catholic University of Korea, Kwangwon University, and Chonbuk National University. He is an expert in maritime boundary delimitation, international dispute settlement, territorial issues, and international institutional law. So last but not least, I'm saying something obvious. The floor is yours, Professor Lee.
Yeah, thank you very much, Chairperson. Good afternoon. I am Ki-bum Lee. I'm highly honored to be here, and so I have to express my thanks to Korean Ministry of Foreign Affairs and Korean Society of International Law. I am, in fact, the last participant for today's conference. So please keep your patience just a little bit more. This conference is a very good place for meeting very good law of the sea people, including my old friends. Actually, because of limited time, I'll add some some comments or observations. I think two professors and some Michael Wood all have well touched on the last year's case decided the International Court of Justice. Since the case had been involved in the legal characteristics of the contact shelf, it would be very great for us to discuss with the case here. We are dealing with here the development of the law of the sea for last 30 years. The codification of Article 76 of the UNCLOS was one of the purposes during the third United Nations Conference on the Law of the Sea, as you know. I think that we are now reaching to the climax surrounding Article 76. The climax means that all the issues in the context of Article 76 appear, even if we can solve all the problems. I think I have commented, I think, on 4 points. Firstly, the last year case, 2023 Nicaragua-Colombia case, was referring to the concept of the single continental shelf. According to paragraph 75, because of limited time, just I would very quickly read some sentences. The court notes that in contemporary customary international law, there is a single continental shelf in the sense that the substantive rights of a coastal state over its continental shelf are generally the same within and beyond 200 nautical miles from its baselines. What does that mean? Generally the same. Actually, and then the court said, indeed, in customary international law, as reflected in Article 76, paragraph 1 of the Convention, states entitlement to a continental shelf is determined in 2 different ways. As you know, distance criterion and natural prolongation criterion. That's why Professor Evans said just half depth of natural prolongation. However, the court, I think, pointed out in the wrong way the concept of the single continental shelf. The single continental shelf is just defining that the inner continental shelf is the same as the outer continental shelf in the sense that there is no distinction between them in its legal character or nature. However, the court had limited the concept of the single continental shelf only in the context of rights exercised by coastal states, so that in consequence, inner continental shelf has a priority over the outer continental shelf. Actually, in fact, on the basis of the concept of single continental shelf, international courts and tribunals accept their own jurisdiction to delimit the continental shelf beyond 200 nautical miles, and then the same identical relevant circumstances can affect the delimitation both inner continental shelf and outer continental shelf. In the in the 1958 Convention on the Continental Shelf and in the 1969 North Sea Continental Shelf cases, actually we had no two separate legal continental shelf regimes. And the most famous statement regarding the single continental shelf in 2006 in the Barbados versus Trinidad Tobago case, Annex 7 Tribunal stated that in any event, there is no, in law, only a single continental shelf rather than an inner continental shelf and separate extended or outer continental shelf. But last year's case rejected this kind of well-settled concept of the single continental shelf. So I think, I doubt that the concept of natural prolongation is half dead or dead because 200 nautical mile criterion is also reflecting natural prolongation within 200 nautical miles. But differentiating 200 nautical miles criterion from natural prolongation. Last year, the ICJ had rejected the concept of the single continental shelf. That would be the first hierarchy created by the court last year. The first hierarchy means the priority of inner continental shelf over the outer continental shelf. And then I would like to introduce the second hierarchy created by the court last year. Actually, yeah, as all you know, last year the court said under customary international law, states entitlement to a continental shelf beyond 200 nautical miles may not extend within 200 nautical miles, blah, blah. However, the court had resulted in the priority for the regime of excluded economic zone over that of the continental shelf within 200 nautical miles. So last year's case created two hierarchies. Actually, we have not known the two kind of hierarchies within 200 nautical miles. Secondly, Professor Biani Magnusson already introduces last year's United States claims to outer continental shelf. Actually, yeah, Biani rightly pointed out in his article that U.S. also could extend its own outer continental shelf in accordance with paragraph 2 to 7 of Article 76 of the UNCLOS, even though the U.S. is non-party to UNCLOS. However, at this moment, we should consider the role of CLCS. Can the CLCS review the submission by one of the non-parties? I think yes. The reason for this is that paragraph 1 of Article 3 of Annex to the UNCLOS is saying that just blah blah by coastal states, not parties or party states. That means the CLCS has a discretion to consider the submissions by non-parties, yeah, just like the US. And thirdly, yeah, already following some Michael Wood's comments. Actually, Biani has been talking about type 1 versus type 2. However, if I reframe this kind of versus the type 1 versus type 2 into different versus, I mean opposite states versus and adjacent versus. Actually, if I develop the opinions from Sir Michael Wood, I think yeah, just type 1 is very related with the the case with opposite states, but type 2 is related to the case with adjacent states. So I think the CLCS should play a role in making the recommendations, particular in the case with opposite coast, to identify the existence of both parties' entitlement to the same area. And so just in the case of with opposite coast, I could invoke the concept of admissibility in the sense that the coastal state should submit its own information prior to the reference of the case to international courts and tribunals. We could develop the issue of admissibility. Actually, Professor Bueren-Kunoi just, I think, a real supporter about the concept of admissibility, just between regarding the relationship between delimitation and delineation. Lastly, regarding the identification of the rules of customary international, several professors' discussions could touch on this issue. But if a party to UNCLOS just follows the rules provided by the UNCLOS, that would be regarded as any evidence of state practice or opinion juris. Just in order to identify the rules of customary international law, if we use the submissions from parties to UNCLOS, I think that would be more formalistic. So if I conclude my observations, actually, our conference subtitle is Then, Now, Future, the future. So for me, then means as of 1982. So we had just learned the new definition of the continental shelf. And now, 2024, actually, as I said, we face all the issues from the definition of the continental shelf or interpretation or application of the continental shelf. Future, since this year, 2024, actually, we have to sort out several issues. For example, the relationship between delimitation and delineation, just including admissibility issues and non-parties submissions to the CLCS. Actually, last year, US long way to get the continental shelf. Last year, finished it. From the 1945 Truman Proclamation to 2023, just claims to the outer continental shelf. Actually, so we have to just think about the non-parties submissions or non-parties just consistent with the rules of the provisions of the UNCLOS regarding the outer continental shelf. Let me stop at this point. Thank you very much for kind attention.
Thank you, Professor Lee, for your extremely analytical comments, which have in a certain way complemented the reflections made by the speakers. Well, I think that maybe we have some time for a reply. We won't have time for a rejoinder. But anyway, reply, no? Oh, yes. I don't know if there are some questions before the reply, so we will have a general reply. But anyway, no rejoinder because the time is running rapidly. Please, President Haidar.
Thank you very much. And I should say that I'm speaking more like Judge Haidar or just Haidar, not as president in any event. I take the view that the Nicaragua-Colombia judgment is, in fact, incompatible with the Bay of Bengal judgments. I also believe that it does not make much sense from a principal point of view to make any distinction between the type 1 and type 2 situations. I know it's academically interesting, but I don't think it is appropriate because we are dealing with issues of principle here. Either State A can extend its continental shelf into the 200-mile zone of State B or not, in principle. So therefore, I don't think we should make any distinction between type 1 and 2. And so what I think the ICJ should have done, I think they should not have asked what I call the million-dollar question and bifurcated. They should just have gone ahead and delimited based on the entitlements of the parties. And most likely, I don't know the details of this case, but I was in Bogota last week, and if what the Colombians tell me is true, then there were some weaknesses in the case of Nicaragua in terms of natural prolongation. And so simply as a matter of equity, we all know that the result, the equitable solution is the goal of Article 83. So in most cases, that would mean that, in this case, Colombia would have had full 200 nautical miles simply as a matter of equity. But at the same time, in the Bay of Bengal situations, it was the equity objective that caused the gray area to be formed. So I think we would be better served by just following Article 83, which strives at an equitable solution without taking any principled decisions on what is possible and what is not possible. In my view, I'm not convinced that there is any hierarchy between natural prolongation, continental shelf, and continental shelf based on distance. But probably in most circumstances, like in this one, the Colombia, in this case, would have full 200 nautical miles. But there are these exceptional circumstances where the opposite will occur, simply to get an equitable solution. I noticed that Sir Malcolm referred to both the Nicaragua-Colombia case, but also to the South China Sea case in terms of Article 121.3. And I think these two cases have something in common, which is that if you look at the literature following these judgments, there's a lot of criticism, and I would say overwhelming criticism of both of them. And because, as Bjarni Már said, he said he would be interested to see what UNCLOS would do if it would get a case of this kind. And so I'm not overly convinced that we would do it in the same manner as the ICJ. We might do it in a different manner, but potentially with the same outcome. So the problem in Nicaragua, Colombia, I think, is that the ICJ seems to take the view that the distance has a hierarchy over a natural prolongation. And in the South China Sea case, the problem was that, in my view, that the Arbitral Tribunal ignored the term rocks. It ignored that the convention uses the term rocks and not islands. And so I think there is a fault there, and at least personally, I would not be, I don't think I would easily follow that part of the South China Sea award. So I think there are some judgments that you cannot take for granted that will be followed as precedents in the future. They are only binding on the parties to the case, and it is basically the quality of the decisions that are decisive of whether they will become precedents or not. Thank you very much. And by the way, thank you for excellent presentations, all of you. Thank you.
I don't see if there are any hands raised. Oh, yes, please, Judge.
Thank you very much. Just two ideas to supplement what you have said. Thank you very much. You are participating in an academic exercise, so there is a lot of freedom of speech and of expression. Some remarks regarding, one remark regarding Nicaragua versus Colombia. There was the question of the economic zone present there. And that is a complex, that adds a complexity to the situation. I'm not going to judge or to argue in favor or against the decision because I'm a member of another tribunal, but I must say that that was a very important element that was taken into account and that was made present by both parties. And the second question is that notwithstanding what the jurisprudence has said, we have the possibility that states agree on something. that may accept some overlaps, so-called gray areas, but it is not so gray. It is just an agreement. That is the case of one of the examples that Professor Magnusson presented. And I think it is the freedom of the parties, because that is the essence of the limitation, according to the UN Convention, that parties are free to choose a line or to choose lines that accommodate their interests and their entitlements. And I think that is important to highlight. Thank you.
Thank you. Be blinded by the lights. I don't see anything, so I don't see, or I suppose not to see any hands. So I will give our speakers the possibility to reply. I think we have 8 minutes to do that. Please, I don't know if you want to start first, following opposite.
Well, why not? I must admit I'm so jet-lagged that I only consumed a few of the points. But anyhow, I want to say one thing. And I would like to ask Sir Michael about this. Okay, if you have to read so much into the wording of the International Court of Justice, shouldn't then have said something else?
Please, the floor is yours.
Well, thank you. And just pick up on a number of points which have been made in the in the time available, and I think they sort of all link together really, because there are different things going on here, aren't they? The first thing to note, of course, is no one ever pretended that the continental shelf has always been, shall we say, a regime that has prompted different approaches, different thoughts, heightened degree of controversies, differences, and it's wonderful to know that nothing has changed. If you're going to be delimiting, you do need the one. I don't think it, well. I think it's sort of assumed that if you're going to be delimiting anything, you actually both need to have competing entitlements. So I think that's not a bad starting point. And so then when you, and to pick up on the points that, that were just made, of course states need to be free to determine what they wish. International law is quite clear on this, particularly when it comes to maritime boundary delimitations. Agreement between states is the beginning and end of it. One of the interesting questions, I suppose, that I and no one else has asked of is whether you can now actually agree, I suppose you could, to give up, well, of course you can, to give up your entitlement to another state if in the course of a bilateral negotiation or discussion, you decide to allow a state to have to exercise jurisdiction on a, let us call it, an outer continental shelf that overlaps within an inner. That's clearly within the realm of what you can do as a state, one assumes. But of course, international law does many different things, and at one level, it creates the space and the basic principles in which those wanting to settle disputes will move to litigation, will move to negotiation, and in those areas, naturally, it's appropriate that courts and tribunals respond to them with a flexibility that enables them to most satisfactorily answer the question. If you go back to the question posed by the court in the Nicaragua-Colombia case, it is one of absolute interest academically to me. It has been for very many years, but I absolutely get it, that in these situations, sometimes it's better not to actually approach it from that way. And as I said, in relation to baselines, for example, it's long been the case that these are one of the flexible tools that are available to a court, a tribunal, or negotiators to be able to produce a settlement that sort of works for everybody. And in those circumstances, coming to solutions that work for everybody is absolutely fine. But there are other occasions when we expect law to do something different, and that is actually give us some degree of clarity about what actually the law is, and therefore what actually can be achieved. And in brief, I'm tempted to say that I'm delighted and happy that Sir Michael is entitled to be as wrong as I am on so many things, because I do feel that there are a number of points. In some ways, I think we're a lot closer to each other than meets the eye. Is the convention a living instrument? Yes, of course it is. Nothing wrong with that. The problem is that it's, in my view, got too many different lives, and it's trying to live them all at the same time, and it's sort of leading to a bit of family feuds. If we use the example, for example, that we had brilliantly this morning, that Anna distilled out of the discussion between Tara and Anna, they could both easily see that the territorial sea was not delivering what we want it to deliver. And as was pointed out, Tara wanted to take things out. Anna wants to put it in to the territorial sea. You can't really do both, but we need a solution. And so we may have to think a little bit more about what is appropriate, and so on. I don't know that it's so terribly helpful to be so unclear about what key terms also means all of the time. There are times when creative ambiguity, particularly in negotiation and in dispute settlement, is really important and it's really helpful. But there are others when I think it's not. And so if we take Article 1213, for example, I think one of the results of the Nicaragua-Colombia case is that it has made it more difficult to live with creative ambiguity, because if you take the point that you have to have title before you can move to a delimitation, we now need to know, almost as a condition precedent, whether something can or can't generate that extended maritime zone before we can move to the next stage of knowing what is the area to be delimited, where the 200-mile limit falls or whether it doesn't fall, etc., etc. I'm not at all reluctant to accept that the law is set out in Part 6 of the Law of the Sea Convention on the Continental Shelf. It absolutely is. I think the point in part is that is now becoming the problem, but I'm not saying that it isn't what it is, but you can't just say that because it is, things have got to be accepted uncritically. If we did that, we'd still have the 1958 Convention definition of the continental shelf, because at a point, that was it. Things move on. And I suppose, I must draw to a conclusion, but, I'm not talking or calling for a bonfire of the rules. What I'm simply doing is doubting that the rule book that was written basically for the problems and issues of the 1970s is ideal for solving the problems which we have now identified in the 2020s. It's not that it can't do it, it's not probably that we don't have to do it, but it's just not the ideal lens through which to be able to tackle some of the problems that I believe we really do have to face. And again, perhaps unlike Michael, I think that there are problems that we do have to face, and we just can't let them all just wait and see and deal with them as they arise. That's responding to the problems, not actually looking forward to those problems, just like the original of the continental shelf was. We can see there's a need to do something. What's the regime that can help address it? At the moment, it's not helping address some of the real problems that we see, but it is what it is. Thank you.
Thank you. I think that we have reached the end of our working day, and of this panel as well. So I wish to thank the participants for this very active and debate and in-depth and critical analysis. And I wish to thank the audience, which patiently has followed our discussion, sometimes highly technical, but the delimitation issues stimulate such a technical reflections. And
I wish you all a pleasant evening, and for those attending, a nice reception. Thank you. Goodbye.
Thank you, Judge Caracciolo, and thank you everyone for enlightening speeches. And let us give all the speakers a big round of applause once again, ladies and gentlemen, for their exceptional presentations and discussions. As we come to the conclusion of today's session, I hope today's conference was beneficial to all attendees, and thank you once again for your active participation today. And we look forward to reuniting with you tomorrow for session 4 and 5 starting at 10:30 a.m. Korea Standard Time. Thank you for your participation.